11:32, we are live. We are live. Good afternoon and welcome to bill hearings for the House Health and Government Operations Committee. I'm your chairman, Jocelyn Peña-Melnick. Our vice chair is watching. She's excused. For today, I kindly ask for your patience. If we encounter any technical or streaming issues, I'm going to go through some rules. Today is a very long day. We do have 22 bill hearings, 130-something people, and we have a lot of meetings in between. You'll see me get up at noon, and I think Bagno Rosenberg will be running the committee while I take meetings and come back. So I need us to be, someone gave me this, I don't know who, we need to be Gumby today, okay? And thank you whoever gifted this to me, because I always say we need to be Gumby. So I'm gonna go through some quick rules to make our life better. As a reminder, there's no food or drinking in the gallery because our staff, they're busy, they don't have time to clean up. You'll see that we will drink because we're here for hours and we have to stay hydrated. Now, the rules for testifying here, I have decided in this committee not to time the bill sponsor. That does not mean that you have 20 minutes, 15 minutes, or 10 minutes. It means you have at the most 5 minutes, okay? For those of you that are favorable or unfavorable and are not the bill sponsor, you have 2 minutes. And there's going to be a timer display on the screen at the witness panel. When it goes off, please wrap it up. Don't make me interrupt you. I don't like to do that, okay? And please, to the committee, I want to thank you for, I know what is going to be a very busy, challenging week. This is the week before crossover, and we'll probably be here Saturday as well, and Monday. And I thank you for being on time and for all the work you're going to do this week. We could not do the work without you. And in a very humble way, I know we're doing great work. I want to thank the staff for their hard work in putting this together, everyone, and our 3 lawyers who do all the work here as well. Members of the public will be able to view the live stream of this hearing on the Maryland General Assembly website right now live and on YouTube. I'm going to go through the bill actually hearing the order, but I reserve the right to change it. Why would I change it? Because my members have, bill hearings somewhere else, or the members as well. Because there's a witness that's running late. Do not take it personally, okay? Please be patient. We're going to get to you. And we do pay attention. We do have this recording, and we do watch it, and we read everything that is given to us. But before I do that, I like to allow the new Secretary of Health that is coming to the state. I want her to introduce herself to the committee. I asked her to come and introduce herself. So can you come here for a second and let them know your name?
Sure. It's nice to meet all of you. I'm Mina Seishamani. If confirmed, I will be coming in as a Secretary of Health April 8th. I have been in Maryland for the better part of more than 20 years with raising 2 kids. They're both in public school in Maryland. I'm a physician by background, ear, nose, and throat surgeon, and I also am a health economist, and I've had the good fortune of being able to both take care of patients at the bedside and work in health policy and health management. And most recently, I led the Medicare program. And before that, I led care transformation while taking care of patients at MedStar Health. So I'm really excited for the potential to work with all of you, to make the health of our state better. And I really appreciate Chair Peña-Melnick for allowing me some time to introduce myself.
Absolutely. Can we give her a warm welcome, everyone? Thank you so much for coming. And I told her that we're going to work with her, right? And we're going to open our doors because we want her to do well, and we have a lot of respect for the department. And thank you for giving me time this morning, okay?
Yes.
I appreciate you. Have a blessed day. All right, so we're going to start with, Jeremy, which one are you here for? 1299. Which one? 1299?
1129.
Okay, 1129. All right, so we're gonna start with 1129. If you will be so kind and come up, and then we're gonna do Delegate Forbes 1468. We are gonna then do Is Delegate Fair here? He is? Okay, then we're gonna do Delegate Fair. I'm trying to take the ones that are not in this committee, our colleagues, so that you can get going, all right? So we're gonna start with those for now. Good, and the one that we have in front of us is 1129, Delegate Jones, Constitutional Officers, Gender Neutral Language, and it's gonna be followed by 1468, if you can be ready, followed by 1055. Good morning.
Good morning. Thank you so much, Chair. For the record, I am Delegate Dana Jones, representing District 30A, the capital city here in the House of Delegates. I also have the honor to be the president of the Women's Caucus of Maryland. I want to thank Jeremy Baker from the governor's office for being here with me today. Chair, Vice Chair, and members of the Health and Government Operations Committee, I'm here today to introduce HB 1129, Constitutional Officers, Gender Neutral Language. This legislation is straightforward, impactful, and timely. Currently, Maryland is fortunate to have 4 out of 7 executive branch constitutional officers held by women. Lieutenant Governor Aruna Miller, Comptroller Brooke Learman, Secretary of State Susan Lee, and Adjunct General Major General Janine Burkhead. These women are outstanding, capable leaders who serve Maryland with dedication and integrity. However, our state constitution still refers to these offices in a way that presumes the office holders are male. This constitutional amendment will modernize Maryland's constitution by correcting this outdated language. Instead of using male or female pronouns, the language which we only use male pronouns, it only says he in our Constitution, the language would remove all pronouns and refer to the office holders by their title only. For example, rather than saying he shall, in reference to the comptroller, it would read the comptroller shall. 9 other states have already made this change, including states such as North Carolina and Utah. This is not the first time that Maryland has adopted gender-neutral language. In 1982, Maryland passed a constitutional amendment that replaced gender-specific with gender-neutral language in referencing imprisonment for debt. This measure passed with nearly 75% of the vote. It's important to me, as it is all members, I'm sure, of this committee, that everyone feels empowered and inspired to serve their state through elected office. In the most recent election, Maryland elected 3 women to serve in the United States Congress. Additionally, 30% of our senators and 45% of our delegates are women. We are incredibly fortunate to have such diversity in our elected leadership, and as children through adults learn and read the Maryland Constitution, it is essential that language in our founding document reflects the reality that anyone can hold office. As you will see in your floor system, I am extraordinarily proud to have the support of Governor Moore, Comptroller Learman, Attorney General Brown, Secretary of State Lee, and Adjunct General Burkhead. With that, I respectfully urge a favorable report on 1129 for gender-neutral language and taking out the pronouns in our Constitution. Thank you, Chair.
Madam Chair, Madam Vice Chair, members of the committee, Jeremy Baker, Chief Legislative Officer to the Governor. I am here in favor of HB 1129 to replace our he language with gender-neutral pronouns. I want to make sure that this common sense legislation passes, so that for my delegate on the left, Terry Hill, as well as my delegate on the right, Delegate Kathy Jalega, can all see themselves in constitutional offices. This is common sense legislation. It makes a ton of sense. Let's make sure we're moving with the times. I urge a favorable report.
I'm going to open it up for questions now. Are there any questions for the delegate and her panel from anyone? All right, seeing none, thank you so much. We really appreciate you.
Thank you, committee.
And you're welcome. This concludes the bill hearing on House Bill 1129. If I may, I'm going to do the, see, I told you I reserve the right to change. I'm going to call this person because it is her birthday today, and this is her gift for her to go early. So Delegate Foley, it is her birthday. Happy birthday. Come over. House Bill 1119.
I'm embarrassed to say my witnesses aren't here.
They're not here?
No, they're celebrating my birthday.
Well, do you want to wait?
Can we wait, like, maybe we can have another, if these other couple bills go.
Let me know. All right, but I thought I would honor you for your birthday. All right, so let's go to Delegate 4. Oh.
Thank you.
All right, Delegate Forbes. 1468. You're supposed to sing happy birthday to Delegate Foley. No, just kidding. Cyber Maryland Program Revisions, 1468.
Good morning, Chairman Pena-Melnick. Good morning, Vice Chair Collison and members of the Health and Government Operations Committee. I'm Delegate Kathy Forbes, and I'm grateful for the opportunity to present HB 1468, revisions to the Cyber Maryland program. The bill before you today builds on previous work that has studied the unfilled cybersecurity jobs in Maryland and have made recommendations on how we can ensure the funds we are spending to train the cybersecurity workforce match the needs of employers seeking cybersecurity employees. This bill transfers the Cyber Maryland program and Cyber Maryland Fund from the Maryland Technology Development Corporation, TEDCO, to the Maryland Department of Labor. And I'm happy to have Executive Director Troy LeMay here and Secretary Portia Wu here from Labor. This bill will make some revisions to the awards made by the Cyber Maryland program and alters the purposes for which the Cyber Maryland Fund may be used based on the studies we've conducted over the past few years. There is a huge unmet need. We don't have people that are properly trained to take the jobs that are available. Right now, there's a gap of more than 6,500 unfilled positions in Maryland, and they're really good jobs that would earn people a good living and would be filling a need that's that we know is available in the workplace now. In Maryland's Cybersecurity Talent Strategy Report, and you all have a hard copy of this. I could not link it because it has not been published yet. This was a study done by the Cyber Maryland Board and the Governor's Workforce Development Board, and it developed 4 fundamental goals aimed at closing the workforce gap for employers and expanding economic opportunity for Marylanders in the cybersecurity field. These goals include equipping every Marylander with foundational skills to grow the pipeline of potential cyber talent, transforming post-secondary cybersecurity education to align with industry needs, expanding new pathways into cybersecurity careers beyond traditional higher education, and strengthening federal, state, and local government cybersecurity workforce. The bill before you today addresses those 4 fundamental goals, and moving the Cyber Maryland program will allow the Department of Labor to utilize existing resources and grants to better accomplish the goals of the program. This version of the bill is strong because it clarifies and focuses how the state's resources will be spent. With this legislation, we are enacting the recommendation of the studies, and we're taking a major step towards equipping Marylanders with the skills needed to enter the cybersecurity field and meet the growing workforce demands in our state. I would be remiss if I did not thank my Senate sponsor, Katie Fry-Hester, for her yeoman's work on this issue and bringing me along on this ride. I ask you for a favorable report. Thank you.
Next, please.
Madam Secretary.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Portia Wu, and I serve as Maryland's Secretary of Labor, and I'm testifying in support with amendments of House Bill 1468, which transfers the Cyber Maryland program from TEDCO to the Department of Labor. I want to thank Delegate Forbes and Senator Hester for their leadership and guiding the Cyber Maryland program, which was established through original legislation in 2023. The department joins the sponsor and TEDCO in supporting this transfer as the program shifts from the report and analysis phase to execution phase. Moving this to labor at this time will enable us to leverage our existing expertise and infrastructure to bring this workforce strategy plan to life. Cybersecurity is one of Maryland's unique strengths, and our cyber workforce must be at the heart of any economic growth strategy. As Delegate Forbes stated, there are thousands of open jobs. Median cybersecurity jobs, the median wages in Maryland are over $130,000. So these are very good jobs, and we want to bring skilled individuals into them. Actually, the report shows that the Maryland DC region has the highest demand for cyber jobs in the country, over 3 times the national average. So this is a strategic investment we must make We do have amendments which we are working on with the sponsors. They go to some of the funding strategies in the bill. In this uncertain budget climate, we recommended a more flexible approach, but it's very much in keeping with the direction that was proposed in their legislation. So we support the bill's goals, appreciate their willingness to work with us, and thank you. We urge a favorable report.
Good morning. My name is Troy Lamel Stovall. I serve as the CEO of TEDCO. Again, I want to raise up Delegate Forbes and Senator Hester and Secretary Wu for all their leadership in these last couple of years in making this a reality. We very much support the transfer of this program from TEDCO to the Department of Labor. As if you know about the entrepreneurial journey, sometimes along the entrepreneurial journey, the founder of something has to realize that they're not the one to take it to its natural conclusion. And so this is a natural step in the evolution of this program. But let me also say this very much aligns with the governor's lighthouse sectors that he's focused on, being cyber being one of them. And I think as I close, when people hear cyber, many times they're thinking about jobs at the NSA, but as the report plays out, this is about jobs for cyber for that donut shop sitting on Main Street in any of your districts. This is about cyber here for the state or cyber for a corporate entity, but it's also about cyber obviously for those NSA jobs. So it's about that totality of cyber jobs that we all need, and how do we make sure those people are ready? How do we make sure that industry is looking at them differently in terms of how they look at what types of qualifications are necessary to do that, and how do we get Maryland to the point where this truly is a home of cyber? So again, we urge a favorable response, and we support both the bill and the amendments that were mentioned. Thank you.
I feel like we've been here before with both of you. I'm going to open it up for questions. Are there any questions? Actually, before I get there to the committee, I looked at the fiscal note. The money is in the budget right now. Page 5 of the fiscal note says that, correct?
Yes, it's proposed in the governor's budget. That's correct.
Okay, wonderful. Delegate Shalega, then Johnson.
Thank you, Madam Chair. Thank you all
You're
for
welcome.
being here. 2 quick questions. Why not do it? Why Department of Labor?
If I might.
Please.
Because this is a workforce strategy. It's not about the technology itself. It's about making sure individuals are trained in cybersecurity. DO-IT is part of the Cyber Maryland board, so they provide that key input. But at this stage, first it was, what are the key priorities? Now, how do we execute them? We are moving to the, apprenticeship grants, working with higher ed institutions, standing up training programs and clinics, and Department of Labor already has that infrastructure to do that.
Thank you. And finally, I notice on page 5 and 6 of the bill, there are 12 different programs. Are you going to streamline them? It sounds kind of like it's been jigsaw puzzled, together, and you could find some opportunity to streamline these. Is that something you're looking at?
I don't want to speak for the delegates' intent with the bill, but I would say we've proposed an amendment. The bill as introduced would have sort of done a sweep of those programs and used the funding to fund Cyber Maryland. We're concerned that then year to year, especially if you want to build a very strong pipeline, not knowing what your funding is going to be year to year seemed too uncertain. In addition, the governor had proposed funding in his budget. What we're proposing in the amendment instead is to do an assessment of those programs and report the outcomes to the General Assembly to see, are we making sure we're getting the most effective use out of our resources, but not sort of sweeping the funds and using that to fund Cyber Maryland.
Thank you.
Johnson?
Thank you, Madam Chair. I was looking at the fiscal note, and can you explain to us why it's only going to be a $99,000 decrease to TEDCO, but it's going to take us $3 million or $3.1 million for the Department of Labor to do that job?
So I'm happy to take that on. And, TEDCO was really in an incubator stage. And I will say prior year budgets were more than $99,000. I think there was a specific reason that happened in the current fiscal year, but which others can speak to. But that was an incubation and reporting stage. Now we're turning into the implementation stage. So what we're going to be doing is funding training for actual workers out there in the world. And this will not just be, as Director Stovall said, it's not just going to be, you're working at the NSA. It's also for our critical infrastructure like water, energy, technology, healthcare. I think Frederick Health is a great example of the cost that a ransomware attack can have for public services. And so it's going to be funding individuals and working with companies to say, we're going to place and train people there, state and local government, all the places that need to be done. But you obviously can't train a lot of people on $99,000. You need to stand up a program. We want to issue grants, do contracts, that kind of thing.
All right, thank you. Thank you, Madam Chair.
Any other questions? I see none. Thank you so much. Appreciate you. And thank you for being with us today. Next we have, is Mindy Lehman, is she testifying?
She is not testifying.
Okay. How about Fatima Wahid? Fatima? All right. Not here. So this actually concludes the bill hearing on House Bill 1468. Delegate Foley, are your witnesses here?
Yes, ma'am.
Why don't you come over? And then it will be Delegate Fair, okay? I have to step aside to a meeting in a few minutes, and Delegate Rosenberg will continue.
Thank you, Madam Chair. I apologize for the delay. Thank you. Good afternoon, Chair Pena-Melnick, and Vice Chair Collison, if you're watching, and members of the esteemed Health and Government Operations Committee. For the record, I'm Delegate Linda Foley, and I'm presenting HB 1119, Procurement, Advertising, Local News Organizations. This bill requires that at least 50% of the value of state government advertising in digital or print publications, with some exceptions, go directly to qualified local news organizations, in quotes, as defined in the legislation. These are entities that have a physical presence in Maryland, employ full-time journalists dedicated to covering the state, and meet other criteria to demonstrate their commitments to local news coverage. This legislation is critical to supporting local journalism and ensuring that state government advertising dollars are invested back into the communities they serve. At a time when local news organizations are struggling to maintain operations and keep reporters on the ground covering important issues, this bill would provide a much-needed boost. According to a 2023 Maryland Local News Ecosystem Study by the University of Maryland's Philip Merrill College of Journalism, 39% of state news organizations say they are skeptical they could survive in 2 years without revenue growth. It's important to note that most news outlets in Maryland are small, with the majority having budgets of less than $250,000 a year and more than a third having budgets of $100,000 or less. This targeted procurement policy will help channel state advertising dollar resources that have already been budgeted to the news outlets that are truly embedded in and serving Maryland communities. It will provide a reliable revenue stream to support local journalism and ensure citizens have access to high-quality reporting on issues that matter most to them. I want to acknowledge the exemptions from this policy for advertising related to tourism promotion and employment recruitment. So that means that those dollars don't have to stay in state or aren't part of the 50%. This bill does not affect those types of ads, which usually must appear in out-of-state media. I also want to address the written informational testimony provided by the Maryland Lottery and Gaming Control Agency that was also included in the fiscal note. I believed that the bill's description of what constitutes a local news organization is broad enough to address their concerns about placement of advertising in digital or print media. I believe the same is true for the kind of advertising described in the MDOT informational letter. And I would like to point out that MDOT spends advertising dollars in very strange places. Like last year, for example, they sponsored a bobblehead, Delegate Rosenberg, at Camden Yards. So if they can sponsor a bobblehead, I think they can throw a little money toward local news outlets. Overall, the bill represents a strategic investment in the future of local news in Maryland. By directing a specified percentage of state, digital, and print advertising dollars to qualifying local news organizations, we can help sustain this critical civic infrastructure and ensure all Marylanders have access to the information they need to be engaged and informed citizens and members of our community. I urge a favorable report on HB 1119. I thank you for your attention. I'm happy to answer any questions.
Who's next?
I can go next. Good afternoon or good morning, committee. I'm Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, D.C. Press Association. Thank you, Delegate Foley, for bringing 1119, House Bill 1119 forward. We are in strong support of this bill. It is a revenue-neutral bill, as Delegate Foley has specified, and it would keep dollars in Maryland. This is a tested proposal. There are programs in New York City, San Francisco, Connecticut, among others, that already prioritize local media for state advertising dollars. It works well. I think the guardrails around specified in this bill are important to recognize that it is focusing on actual news media, not sort of phantom companies, not companies created expressly for the purpose of accessing this revenue, but it is prioritizing the local news outlets that support our local communities. And so it keeps dollars in Maryland. And also, I wanted to share, I think sometimes there's a perception when you think of local news, code word newspaper, gosh, are they really able to get the advertising message out to the communities that are needed? You'll hear directly from boots on the ground, from Sarah at the Baltimore Banner and Lenora House from the Afro, about some of the advertising capabilities that they have. Our members are able to act as full-service marketing agencies. If there is digital, print, direct mail, billboard, whatever the need is, our members can fill it, and they fill it very well. And so I just wanted to make sure that you knew the whole breadth of services that are available to our state agencies. This is not a poor substitute. It is an actual handshake win-win for local news and the state. We urge a favorable report. Thank you.
Thank you. So before the next witness, just for planning purposes, I'm going to step aside to meet with all the health officers. We have an emergency meeting, but I have this bill, and I have Delegate Fair next, and then Delegate Warman, only because we have Judiciary here, and I don't want her to wait a long time. And Delegate Rosenberg will take over, okay? Next witness, please.
Hi, everyone. Good morning. My name is Sarah Walton. I am from the Baltimore Banner. I want to thank the chair, vice chair, and other members of this committee. We are in support of this bill. As Maryland's largest newsroom, we employ 85 journalists with an employee list of a total of 130. We're tackling the most pressing issues, from the Key Bridge disaster to Baltimore's opioid crisis. So despite our promising growth since 2022 and recent accolades, like receiving the prestigious George Polk Award, we and other local news organizations face a steep climb to financial sustainability, given challenges in the decline of newspaper ad revenue by more than 80% since the early 2000s. This loss has fueled countless newsroom closures and the proliferation of news deserts, which weaken civic engagement, increase polarization, and allow corruption to flourish. We are living proof that innovative nonprofit business models can work, but truly achieving long-term solutions will require many creative solutions like the win-win offered in this bill, which will strengthen local journalism while ensuring state advertising reaches the most engaged audiences. How will this bill strengthen local news and benefits for Maryland? The 50% set aside of state advertising dollars for local news would allow local news organizations like the Banner to maintain and grow coverage. This means expanding to cover more ground in counties across the state and even more in-depth reporting on local government, schools, public safety, and key community issues. This bill does not restrict government choices in advertising. It simply requires them to be intentional about prioritizing local news. State agencies would still have full discretion over their advertising strategies while ensuring taxpayer dollars support Maryland-based journalism. This bill is revenue neutral, requiring no new appropriation from the state budget. As Delegate Foley mentioned, it simply allocates existing advertising funds to make better use of them while strengthening Maryland's local eco-news system. This bill is the essential firewall. There will be an essential firewall. Sorry about that. And one quick note, the potential benefits for the Banner and the state agencies have much to gain too. Contextual relevance, and unlike ad placements on low-quality platforms, reputable local news publishers can provide clean, less cluttered experience that is more likely to resonate with readers. Many local publishers cater to specific communities and demographics, ensuring government ads reached engagement-relevant audiences. The credibility and trust the Banner and other reputable publishers have established with readers translates to a higher public confidence in ad messages that appear on these platforms. Thank you, and sorry for going over the 2 minutes.
Thank you. Are there any questions for the sponsor or for the witness? Delegate Salega.
Thank you, Mr. Chair. Thank you all for being here. I had a question for the Banner. You have a paywall, so people that would see these would have to be subscribers. How many subscribers do you have?
We have over 60,000 subscribers.
Okay.
And anyone can reach our website, which has over 3 million in page views each month.
But you can't see it unless you pay for it.
You'll be able to see the ads on the homepage.
I didn't know that. And you mentioned in your testimony something about corruption to flourish. I didn't understand what that was about.
The support of local journalism helps ensure that there are eyes on businesses, governments, ensuring that transparency is important. And that's something that we're keeping our eyes on to produce any type of corruption at all levels.
Thank you.
Are there any further questions for any of the witnesses? Delegate Hill.
Thank you. And thank you, Delegate Foley, for the bill and for trying to address a big problem. So Delegate Shalega was asking the Banner about the paywall and whether ads can be seen without going through the paywall. The question is that a general practice that you may not see the article, but you can always access the ads? And if it is not, would you have any objection to an amendment that would require for advertising that people should be able to, if the goal is to make sure that the advertisement is seen by as many Marylanders as possible, that paywalls cannot, whether they're listed in some way, is there any objection to an amendment that would allow or require that paywalls do not stop folks from seeing advertisements?
I can't address the amendment part, but let me tell you about the advertising part. So when we have clients, and full disclosure, MDDC has a full-service ad agency as well that often connects advertisers to local news outlets. It can happen in a variety of ways. So oftentimes, if you hit an article that's on a paywall, you're seeing lots around it. So you're always getting advertising. There's also many of our members are also placing in programmatic platforms. So those ads are not only appearing on their own direct buy website, but they're also appearing in other places. So sometimes how ads can follow you, that's all programmatic advertising. And so in terms of where those ads are showing, traditionally, and it kind of depends on what the client needs. And so I think this is where news media can be a real resource. We know those local markets. We know where people are looking. We're in the business of audience development. Oftentimes, if you're advertising on the local news website, that is a more trusted platform than like advertising on TikTok or doing something like that. However, local news can place ads in those ways as well. So it is full service. It's not just you're buying a digital ad on the platform of the Baltimore Banner or the platform of the Afro. You are reaching a wider audience based on whatever the client needs.
Mr. Chair? If I could follow up, can I follow up, Delegate?
Mr. Chair, may I? Yeah, so the question is, I'm not talking about general, we're talking about the specific advertising that we're obligating the state to do. And I very much appreciate trying to make sure these news organizations have the funds to keep going. But I also appreciate, and we've had many bills before this committee about making sure that the ads get to the people. So I'm talking about those listings. Can we ensure that state listings are not behind a paywall so that folks can use whatever local newspaper, whatever general state newspaper, and access the information that we're having the state put out?
Okay. So thank you, Delegate, for the question. First of all, if the ads are placed in print, not an issue, right? Second of all, whatever the policies are with respect to the media in Maryland, this is an industry-wide response to ads. I mean, I'm not that involved in the integral placing of ads or where ads appear, but the same would be true of out-of-state ads. Out-of-state ads would be put either behind a paywall or not behind the paywall. I think that the policies are the same, whether it's a local media or an out-of-state media. I don't think that the behind the paywall is unique to local media. So they're putting ads now wherever they're putting them, and presumably some of them are going into local advertising. I think actually most of the ads that our state agencies place probably do go in. I think probably, I wouldn't be surprised if it was more than 50% at the moment. I hope it's close to that, and they're placing ads now. So wherever they're placing the ads now, the same paywall policies would be in effect. And my understanding is that you can place ads either outside the paywall or inside the paywall. So there may be a particular article that's of interest that, for example, an advertiser might put an ad in that article, embedded in that article itself. That's my understanding, and maybe the banner can respond to that. But then there are also sort of general advertising that goes on, website that you can see when you call up the article or the headline on the article, you might see the ad that's been placed. So that policy is whatever the policy is with the state agencies. They have ad advisors who advise them where to place ads, either in front of or behind the paywall. And I don't think that would change. And it doesn't change for out-of-state media either, I would just point out. So I don't know if you want to respond.
He only lets one person per question.
Oh, okay, sorry.
Delegate Ross. No questions for me. Oh, it's still Delegate Saliga or Delegate? No, it's fine. Oh, pardon me, depth perception on my fault.
Yeah. I probably have a quick follow-up. You mentioned that it doesn't impact tourism, and then you mentioned something else is not impacted. Employment. Okay, thank you. So here's the follow-up. I'm looking at the letter of information from the lottery, and I'm just curious if you have any responses to the concerns that they raised in that letter.
I think before I would address the Lottery Commission's concern, I would want to see some figures about where they place ads. Again, we're not talking about all ads. We're talking about, first of all, digital and print ads. No television, right? We're not talking about television. And we're also talking about only 50%. So I would like to know, I mean, they didn't give any specifics about what they do now. So before I respond to what the issue that they raised, I'd like to know what they do now. And I don't see any information about that. Again, these requirements are pretty limited. You already have a budget for print and digital advertising if you're an agency or the Lottery Commission. And then the question becomes, where do you place those ads with that budget? And, I'm guessing that a sizable percentage of that is in Maryland. And if you read the requirements for what constitutes a local news media, they're pretty broad. In terms of, what it says a local news outlet would be. So I would have to see whether or not the Lottery Commission, what they're doing now, and whether or not how much of that falls within the parameters of what we have laid out here.
Thank you, Mr. Chairman, and thank you for the bill. I wanted to kind of piggyback on Delegate Hill's question. So what we're doing is mandating 50% to be spent in Maryland. So I think her question was really getting at, so then are we going to require our Maryland citizens, our taxpayers, to then pay more money to see these ads?
I think the answer is no, Delegate, because they're already we're not mandating that anybody pay more. What we're saying is that you have a budget for digital and print advertising. Again, not advertising, not the bobbleheads at Camden Yards, but you have a budget for advertising, and you have budgeted a certain amount for print and digital. The amount for print and digital might be very low. I don't know, depending on the agency. And all that we're saying is those dollars that you've already budgeted, that they need to go to local media outlets. And I would think 50% need to go to local media outlets. 50%, half. And I would say that in terms of Marylanders, that they probably, if they're spending more than 50% out of state, I don't know that Marylanders even get to see it, and number one. And number two, I'm not sure what the cost, I think, would be the same, whether it's, as I said earlier, whether it's placed in a media outlet that's out of state or a media outlet that's in state. The costs are, the advertising costs don't change, nor do the paywall policies change.
All right, thank you, Mr. Chairman.
Okay, point of personal privilege. I don't look at the schedule for giveaways. I have at least one friend who does, but not me. Thank you.
Thank you. I got that bobblehead, by the way, so I love it. It's on my shelf, but.
Good for you. Any other questions?
Mr. Chair, I think we might have another virtual witness.
We should.
We should. Do we?
Lenora House from the Afro.
From the Afro?
She should be in the waiting room.
Okay, Lenora House.
Mm-hmm. And she is in the Zoom waiting room.
Ms. House, welcome. Please let us know what your thoughts.
Can you hear and see me?
Yes.
Yes, we can.
Go ahead.
Go ahead, proceed.
Can you hear me?
Yes. We can hear you. Can you hear us?
Okay, I just turned my volume up, so I believe I can hear you all well. Thank you. Good morning or good afternoon, everyone. My name is Lenora Housey. I am the, yes, I'm speaking.
Go ahead. We can hear you.
Yes. Lenora Housey is my name. I am the executive director. Uh-oh, we have a delay.
Yeah, tell her to turn off.
Don't listen to us.
Yeah, she's got to turn off the streaming.
Yeah, turn off the streaming so that you're not hearing yourself or us.
Okay, hold on.
We can hear you fine. You don't need to hear us. Please proceed with your testimony. Ms. House, please proceed. Yeah.
She has to turn off the streaming.
Please proceed.
Yes, I'm turning this off so I can just go on the Zoom, but I'm still in the waiting room on the Zoom.
No, you're not.
No, you're not. Go ahead.
Yes, I apologize for the technical difficulties, but I'll make this even more brief than it was going to be.
Go ahead.
Keep plowing through. Go ahead.
I think it's a significant.
Yes, so the Afro, as many of you know, is a century-old institution that has served primarily the Black community for almost 133 years. My colleagues have said a lot of what I would have said, but I would add some unique circumstances that the Afro finds themselves in as a member of the Black press. Many of you have heard the statement that when America gets a cold, Black America gets pneumonia. The same is true for the Black press. And so some of the challenges that you heard expressed by my colleague at the banner, those are only exacerbated when it comes to the Afro. We rely heavily on our on our local advertisers and agencies to support us so that we can continue offering the work, the journalism, bringing communities together that we are otherwise not able to do. I got a little envious when I heard my banner colleague talk about the number of people in their newsroom. We have 5, and those 5 people are challenged to try to get and cultivate news from across the entire state of Maryland. We would have more, but obviously you all know that it takes revenue advertising to do that. And I'd also like to stress the point that Rebecca made, that we like to say we're not your grandfather's newspaper. We do have a print edition. We consider that our legacy edition. It publishes every weekly, every Saturday, and we have a very loyal subscriber base. But we also have a very robust website. We do not have a paywall for the very reasons and concerns some of you mentioned, because again, within our community, sometimes getting information and dispensing it with equity is a challenge. And so we want to be able to keep delivering the news and the information that we believe our community needs, and particularly in the times that we are in now. So we would ask that you see this bill as a favorable one so that we can make sure we can continue to do the work that is much needed in the press and in specifically the Black press. Thank you for my time.
Thank you. Are there any questions for the witness? Seeing none, we thank you very much. And there are no other witnesses on this bill. Correct? That concludes
Thank you,
the
Mr. Chair.
hearing on this legislation. Is Delegate Fair? Yes, sir.
Yes, sir. May I call up my panel, Mr. Chair? I have Sam Williamson, Courtney Bergen, and Sandy Raines, please. And then virtually, if I can add one virtually as well, Andrew Edelman. I believe Katie O'Malley wanted to be here to testify on behalf of the National Women's Law Center, but unfortunately has a personal emergency, so she is not going to be able to join us. But if we could bring up Andrew Edelman as well.
That's fair.
Am I good to go? Thank you. Mr. Chair and esteemed members of the Health and Government Operations Committee, Delegate Chris Fair presenting House Bill 1055. This bill convenes a task force of representatives from all 3 branches of government and various other expert stakeholders to 1, analyze the impacts of federal actions on Marylanders' civil rights and non-discrimination protections. 2, identify gaps, inconsistencies, or deficiencies in state and local frameworks for civil rights and non-discrimination enforcement. 3, identify ways to ensure that individuals have diverse and effective remedies when they experience discrimination. And finally, 4, annually recommend actions to address the task force findings. This multi-year effort is necessary because the General Assembly has a duty to ensure that Marylanders continue to have a robust and effective non-discrimination protections consistent with its legislative intent when it created those protections. The federal administration is unilaterally changing long-standing interpretations of federal non-discrimination laws, slashing resources and staff for the agencies charged with enforcing civil rights laws, reducing funding for state-level human rights enforcement organizations, and threatening to sue states over local non-discrimination policies it disagrees with. At the state and local levels, recent court cases like John Doe v. CRS have illuminated inconsistencies within Maryland's non-discrimination framework. Enforcement agencies are experiencing significant staffing shortages and associated case backlogs, and other agencies like the Maryland Insurance Administration struggle with ambiguous regulatory authority for implementing statutory protections. Meanwhile, plaintiffs and defendants are not able to consistently utilize existing statutes to access the courts or otherwise resolve disputes in ways that meaningfully redress alleged harms. With so much uncertainty and so many fearful residents looking to Maryland state government for strong action in defense of their rights and protections, it is imperative that the General Assembly respond quickly and effectively. I acknowledge and deeply appreciate Maryland Commission on Civil Rights' continued feedback on this legislation and have the utmost respect for its work as the agency at the forefront of the fight against discrimination in Maryland for nearly 100 years. As a gay Marylander, I am a beneficiary of its work to formally study the problem of sexual orientation discrimination and its successful legislative advocacy response to that study. That study, in the early 2000s under Governor Glendening, was one of the more recent formal studies that the agency has published on its own accord. And the agency's freely disclosed bandwidth constraints mean that nearly every other study issued by MCCR since then was a result of the statutory mandate passed by the Maryland General Assembly. Even in its testimony on this bill, MCCR admits, quote, MCCR has been forced to forego formal studies and, quote, MCCR is unable to conduct specialized and targeted studies as authorized under current law. So while MCCR has the statutory authority to conduct the very study contemplated by this bill, it freely and frequently says it does not have the resources to do so, even though it implies there is an urgent need for such work to be done on behalf of all Marylanders. According to DLS analysis of this year's budget, MCCR is rightly slated to receive an additional $1.6 million to hire 11 additional staffers. 3 are for education, 2 are for litigation, 1 is for administrative support, and 5 are civil rights caseworkers to address the backlog of over 1,000 cases. But per the same analysis, nearly $2 million of MCCR's budget this year comes from the federal agencies like the EEOC and HUD, each of which are slated to see significant budget cuts with ripple effects on their grantees like MCCR. Further, existing state budget projections have worsened by hundreds of millions of dollars, making it extremely difficult for the state to step in and fill any gap in MCCR's federal funding. Considering the federal fiscal landscape facing MCCR and the impending deluge of new state-level cases as federal non-discrimination protections evaporate, it is unlikely that studies like this one contemplated by House Bill 1055 will be conducted even with the significant cash infusion in this year's budget. Finally, there are other non-discrimination protections outside of Title 20 that MCCR is not charged with enforcing, some of which are rife with statutory ambiguity as to how their enforcing agencies can implement regulations pursuant to that authority. HB 1055 then provides a pathway for MCCR, all branches of government, and a wide array of expert stakeholders to thoroughly study non-discrimination issues proactively and over a sustained period without incurring additional costs to MCCR or jeopardizing its critical enforcement and outreach work. I have already proposed an amendment to address projected costs to MCCR and the Office of the Attorney General for staffing the task force, which also eliminates the fiscal note. And I am more than happy to also change its name in response to MCCR's feedback. The core point remains that Marylanders need strong and well-informed action from their government to address the threats to their civil rights protections, and the MCCR freely acknowledges it lacks the bandwidth to do the research to support that legislation on its own while it continues to diligently enforce Marylanders' civil rights protections. To facilitate well-informed legislation, to advance and protect Marylanders' hard-won civil rights and non-discrimination protections, I urge this committee to issue a favorable report on House Bill 1055. Thank you, Mr. Chair.
Are there, okay, next witness, sorry.
Oh, Sandy, you want to go first?
Thank you, Chair, Vice Chair, and members of the committee for providing this opportunity. My name is Sandy Gold-Rains. I'm a board member of GLSEN, Maryland, the state chapter of the leading national organization working on behalf of LGBTQ+ students and educators to build inclusive and supportive educational environments. And we urge you to give a favorable report to this bill, HB 1055. We submitted written testimony, and as part of that written testimony, we included the most recent results for Maryland, the Maryland snapshot of the GLSEN National School Climate Survey. Some of the pertinent findings show that the vast majority of Maryland LGBTQ+ students face discrimination from other students, ranging from 76 to 96%, depending on the type. Most of them experience more than one form of this discrimination. Almost half, 46%, reported their school had discriminatory policies and practices of at least one form. Only 17% reported that their school had a comprehensive anti-bullying harassment policy that included sexual orientation and gender identity and expression. Only 15% reported that their school had policy or guidelines to support transgender and non-binary students. Those are amazing statistics that students are reporting how non-supportive their schools are. Also, only 27% reported they were provided with positive representations. And GLSEN has also heard through our travels throughout the state at Pride events and also online, we have heard from many students, parents, and educators about issues they have been facing. And this is across Maryland in all counties. One student was told that the administrators would not stop the perpetrators of physical abuse that they were facing because of the LGBTQ identity. And in order to stop it, they had dressed differently. Another student was told they had to change schools. Thank you for your support, and I urge you to give favorable reply. Thank you.
Good afternoon, Chair and members of the committee. My name is Sam Williamson. I'm an attorney at the Public Justice Center. I'm also one of the leaders of the Trans Rights Advocacy Coalition, or TRAC. I'm here in support of HB 1055. This bill would enable Maryland to better protect our marginalized communities. There have been sweeping federal executive orders that undermine anti-discrimination protections and specifically target the trans community and others. For example, recent executive orders attempt to define trans people out of existence and direct changes in anti-discrimination law to reduce access to medically necessary gender-affirming health care, exclude trans kids from school programs and sports, and exclude trans women from shelters. A federal judge recently described these executive orders as, quote, unadulterated animus. Maryland needs to make changes to stand in this gap. For example, right now, before filing an employment discrimination lawsuit, most cases must be filed with either the Federal Equal Employment Opportunity Commission, EEOC, or the Maryland Commission on Civil Rights, MCCR. The EEOC has been directed to enforce federal anti-discrimination laws in a manner that is itself discriminatory, and it has been dropping cases across the nation. MCCR has a backlog of hundreds of employment cases, and that backlog was growing even before federal changes made it likely that MCCR will receive more cases. All of this means that it is increasingly difficult to enforce both federal and state anti-discrimination laws. We need to make changes, and this commission can consider ideas, such as changing the requirement that one needs to file anti-discrimination cases with an agency before filing with the court. Having a dedicated commission to study the shifting legal landscape and make recommendations will better position Maryland to protect our marginalized communities and ensure that all can live safe, full, and joyful lives. For these reasons, I urge a favorable report on HB 1055. Thank you.
Thanks, Sam.
Good afternoon. My name is Courtney Bergen. I'm an attorney and Equal Justice Works Fellow with Disability Rights Maryland. And DRM is here in support of House Bill 1055 because anti-discrimination protections are a critical part of Maryland's culture and who we believe we are as a state. As all of you know, there's been sweeping attacks on all sorts of civil rights protections, but these have also been targeted at the disability community, often intersecting with other communities. For example, currently there's a case in going up to the Supreme Court where 17 states are suing the United States to try to vacate, actually just totally get rid of Section 504 of the Rehabilitation Act. Section 504 is one of the major ways that people with disabilities can enforce their rights within healthcare settings, educational settings, and any other place that is a recipient of federal funds. So if this law were to go away, Marylanders with disabilities would be without many critical protections in these settings. And attacks, this is not the only law that's being attacked right now. The ADA has also been threatened, and then importantly, along these lines, one of Disability Rights' main source of fundings as a protection advocacy agency for the state of Maryland is the PAMI Act, Protection Advocacy for Individuals with Mental Illness, and this has recently, there's been some op-eds where the urging to get rid of this act and the funding that empowers Disability Rights Maryland to go into hospitals and protect patients' rights. If this were to go away, people with mental health disabilities would be without lawyers to protect them. So we really need to be looking at both what's happening and where the gaps are on the state levels, as all the other witnesses have been saying, because people in Maryland right now currently lack means to enforce these individual rights. So we really urge you to support House Bill 1055 and support the development of a Commission on Anti-Discrimination. Thank you.
Mr. Chair, may we add Andrew Edelman from the virtual testimony for the panel?
He is listed.
I would appreciate it if we could add specifically Andrew to the panel.
Okay, are there any questions of the people who are present? The witnesses, the sponsor, or the witnesses? Delegate Alston.
Thank you, Mr. Chair. So I'm looking at the bill as well as the letter of information from the Office of Civil Rights, and I don't see your amendments that you said made it cost neutral. They're not in the system. So what do your amendments do?
We emailed those this morning just to make sure they were fresh in your inbox, and it came a little late, so you might not have seen it until about 11. It simply deletes the portions that require MCCR and OAG to staff, and instead the commission is going to staff itself, and so through existing resources. So the entire cost and the entire fiscal note is related to MCCR and OAG having to provide a staff member for the commission.
I will tell you then that amendment deeply concerns me because we have the Office of the Maryland Commission on Civil Rights that is charged with doing this work, and they are overburdened actually defending the rights of Marylanders when people are discriminated against. And so not having them as a part of the conversation becomes a problem in how this commission would move forward. If it goes to subcommittee, we can discuss more. I won't belabor the point here.
If I can, MCCR is at the table. They are a member of the commission. They are simply not staffing it. So we will handle the staffing, the note-taking, the reminders of meetings, the follow-ups, the information studies, the research, and all of that. MCCR will be at the table to review all that information, provide critical feedback, and provide its guidance on what it thinks is the best avenues for us to take forward. MCCR is intimately involved in every step of this process.
So when you say we, who is we, and how is it not a cost to doing research and doing all of the things that you just mentioned?
The commission will work within itself to identify the research that needs to be done, and then either the commission members themselves, which make up a variety of stakeholders, about a dozen different stakeholders, will then divvy up that work amongst themselves instead of having a dedicated staff person that we push all that work off to.
Okay, and then finally, I noticed that there are no people of color on your panel. Is there a reason for that?
There is not, and I'm sorry to say that there isn't.
Okay, thank you.
Thank you.
Several virtual, we want to thank the witnesses who are present for your testimony. Oh, I'm sorry, Delegate Hill.
Thank you, Mr. Chair. Just real quick, so the question is asked, why can't the advocates do the monitoring? And when there are issues, bring it to MCCR, bring it to legislators if there are solutions that you think need to be there. Why is it not sufficient? The advocates are already doing this monitoring. Why does this, I'm missing why this additional layer needs to be there.
Sure. So the biggest challenge that we have is there is numerous systemic problems. And let's just take MCCR's charge in Title 20 as an example. There are countless discriminatory policies, discrimination-based policies that we have to look at statewide that do not fall under the charge of MCCR at all. They don't fall under Title 20. And so that requires us to pull other stakeholders into the room to have that conversation about how. The larger question, to your larger question about why do we need to do this as instead of piecemeal, is because we need to look at it as advocates point out these challenges. They are independent inside of a silo. What we're not looking at is the whole framework, the entire picture, and that's what this commission will really be designed
Right, so
to do.
what I'm asking is why can't the advocates form their own commission?
Because some of those results may result in legislation, and we would want to have representatives from the Maryland General Assembly sitting in that room understanding how we built that recommendation to the legislature, and then understand and then bringing together not just stakeholders as advocates, but also the Office of the Attorney General is in there, MCCR is in there, state agencies from the executive branch, the judicial branch, and the legislative branch are all represented inside of this commission so that we can tackle these issues from as many different points as possible.
All right, thank you.
Thank you so much, Delegate.
Thank you. That double checking does conclude the questions from the members for this live panel. We do have several people virtually. We can call them up. Courtney, no, Bergen, you testified. Wendy Novak, Ken Phelps, and Andrew Edelman. Please proceed.
Good afternoon to the chair and members of the committee. My name is Andrew Edelman. I'm a partner at the law firm Correa and Puth, and I'm pleased to testify on behalf of the Metropolitan Washington Employment Lawyers Association, or MWELA, in favor of HB 1055, which establishes the Commission on Non-Discrimination to help study non-discrimination laws and make recommendations on legislation to address deficiencies. I'm a member of MWELA, which is an association of over 350 attorneys in Maryland, the District of Columbia, and Virginia, whose practice is dedicated primarily to the representation of employees and the advancement of civil rights in the workplace. As someone who practices in Maryland on a regular basis, my practice and that of many MWELA members is devoted to enabling Maryland employees and individuals live their lives free from discrimination. And much of the practice of MWELA members involves claims under Maryland state and local anti-discrimination statutes, such as the Maryland Fair Employment Practices Act and FEPA, or Title 20 of the State Government Code. Currently, although Maryland law prohibits discrimination on a wide range of protected characteristics and forbids discrimination on those illicit criteria in many facets of life, there are a number of important changes that could be made to MFEPA to expand protections and to bring it up to the high standards shown in other states' civil rights laws. In the employment arena, for example, the human rights laws of California, Illinois, and New York City make employers strictly liable for unlawful harassment of employees by their supervisors, a more stringent standard than federal law. Maryland law has not yet taken this step to promote accountability for employers and the recourse for employees subjected to serious sexual, racial, and other forms of harassment. Importantly, Maryland state anti-discrimination law confers a private right of action or a right of individuals, not only government authorities, to bring lawsuits for discrimination in only two areas, employment and housing. The commission can study these practices and determine, frankly, a right without a remedy is no right at all. We urge the committee to vote favorably of this bill. Thank you.
Next witness, please. Please start. Thank you.
Is that me?
Yes.
Okay. Certain members of our community are under attack from the federal government. There has been an attempt to undo all the civil rights protection that has been made. We have some very good state laws that protect from discrimination, but few are aware of these laws or how to implement them or where to go for help if there is discrimination. Non-discriminatory policies are not only the right thing to do, there are numerous benefits. Research shows that diverse teams are more flexible and adaptable, leading to better results. People need to belong, to be included. This is true for our children as well. All parents want their children to be safe and welcomed in school. Currently, there is significant confusion over what rights students and parents have in school. Our LGBTQ students are significantly more likely to miss school out of concern for their safety or be threatened or injured with a weapon on school property. Students and parents that reach out for help when they witness discrimination, such as the exclusion of a book in the family life curriculum, because it recognizes that some families have two moms or two dads, they've struggled with where to go for assistance. The Carroll County school system and others do not even notify parents that there is an option to report discrimination to the state, or even that the state has a non-discriminatory policy. Too often, civil rights are considered politics and left to interpretation and ignored. Many institutions would rather deal with the consequences than do the right thing. The composition of this committee is well thought out. In particular, I think it's helpful that members of all three branches of government are included. I'm hopeful that this will help eliminate any gaps in protection. The work groups to solicit input from stakeholders will be helpful to keep the public informed and engaged. I urge a favorable report on HB 1055. Thank you.
Thank you. Are there other witnesses waiting to testify? No. Are there questions from the committee for these two virtual witnesses? Seeing none, there are no more witnesses on this bill. We thank you for your presentation.
Thank you, Mr. Chair. Thank you, committee.
Next bill is House Bill 1409, Delegate Warman. You're getting to be a regular up there.
Mr. Chairman, could I have my panel come up with me?
Certainly.
Awesome, thank you. It's good to see you. Good to see you. Thank you for doing this. Thank you, Chair, and members of the committee, and thank you, our judiciary members, for being here as well. My name is Delegate Teresa Warman. I appreciate the opportunity to present House Bill 1409 today. This bill came to me the way that all good bills do, from a constituent who experienced a problem and wanted to fix it. BJ Carter is here today to share her story, but I wanted to take a moment to recognize her and her late husband, Jack Carter. Jack was a Holocaust survivor before coming to the United States to rebuild his life. In his later years, as dementia took hold, he became vulnerable in a different way, one that required trust and thus caring for him. BJ did everything she could to protect him, using video monitoring to help ensure his safety. But even with that, she still didn't have the full picture. Like so many families, when something went wrong, she was left with more questions than answers. That's why I introduced this bill, to give families the full picture. Under this bill, residents of medical care facilities or their legal representatives would have the right to install electronic monitoring devices, including both video and audio, in their personal rooms. This is not a mandate, but a choice, a tool for families who want more oversight and accountability in their loved ones' care. The bill also includes strong safeguards to ensure monitoring is done fairly and with respect to privacy. It would have roommate consent before monitoring could occur in a shared room. Signage will be posted so staff and visitors are aware of the monitoring. Protections against retaliation from facilities, and recordings will be admissible in legal proceedings to give families clarity when something goes wrong. I still believe in the original bill because families deserve answers. When a loved one experiences a fall or an injury or a sudden decline, families shouldn't be left wondering what happened. They should have clarity, not uncertainty. But I also know how this process works, and sitting among you guys, I've become a realist. And once a bill like this is introduced, we hear a lot from different voices, some in support, some with concerns, and some who want to change the bill entirely. Late last week, I received significant feedback, including concerns from MDH that could be addressed with simple fixes, but also broader feedback from others who want a different approach. After conversations with some of you and stakeholders, I made the decision to accept Lifespan's and Dana Kaufman's amendments and narrow the bill to an expansion of VERA's law to include assisted living facilities. For some context, VERA's law was passed in Maryland in 2003 to allow nursing home residents or their legal representatives to install electronic monitoring devices in their rooms. Instead of creating a new law, what this bill now does is simply extend VERA's law to include assisted living facilities, the next largest category of long-term facilities. This means that instead of the broader protections that I had originally introduced, HB 1409 will now expand VERA's law to assisted living facilities, giving those residents the same right to install cameras that nursing home residents already have. It will maintain the existing safeguards under VERA's law, including roommate consent, required signage, and protections against retaliation. It would have the Office of Healthcare Quality to review advancements in monitoring technology to determine whether guidelines should be updated in the future. I also want to flag that the fiscal note was released on Sunday, but it is based on the original version of the bill, with this bill now being a simple extension of VERA's law rather than a full set of new requirements. The fiscal impact should be significantly lower. I hope that that will be considered in your review. Now, I won't pretend that I'm happy about narrowing this bill. The original bill did more protections, more options, and more transparency, but I also know that this is what it will take to pass a bill this year. That being said, I want to be very clear. This isn't the end of the conversation. I appreciate all the stakeholders who provided input, and I look forward to working with you in the interim to bring back a stronger bill next year. I appreciate the committee's time and consideration, and I hope that this is just one step forward in ensuring greater transparency and accountability in Maryland's healthcare facilities. Thank you, and I'm happy to take any questions, and I'll pass it on to my to District 16's constituent, BJ Carter. Thank you.
Go ahead. Hello, my name is BJ Carter. I live in Chevy Chase, Maryland. I'm here to speak in support of House Bill 1409. This bill is very important to me and every other family who has a loved one in a nursing home, assisted living, or special Alzheimer's care or memory care. My husband, who passed away in January, was in assisted living and then in memory care. When he moved to the memory care floor, I purchased a Blink camera for his room. Both video and audio recordings are necessary to truly monitor quality of care. Video to see the interactions, watch for falls, be alert for gaps in care, such as when my husband lay on the floor for 4 hours during the night because no one checked on him. And audio to capture the verbal and emotional elements of the interaction, as well as to hear if our loved ones are moaning in pain and need attention. In Maryland right now, these facilities can refuse to allow families to place a camera in their loved one's room. And if the facility does allow it, and even with appropriate signage on the door indicating the placement of a recording device, the state of Maryland has guidelines that audio recording is not permitted in nursing homes. I've uploaded Vera's law, which denies audio and says the camera cannot rotate. At the assisted living where my husband was, their policy was to only allow audio if state regulations said they had to allow it. In a November 2007 review of nursing home regulations provided to the General Assembly, which I also uploaded, it was noted that a change was needed to clarify that electronic monitoring is to be considered a healthcare/medical decision with the same provisions for advance and surrogate decision-making as other healthcare decisions. I agree. It's why I'm here today to urge you to support House Bill 1409. It's time to correct this for all families who care about their loved ones. These facilities should be required by law, which Vera's law is not a law, it's only a resource, to allow families to monitor for quality of care with video and audio recording with appropriate signage. Thank you for your time and attention.
Good afternoon, Mr. Chair and members of the Health and Government Operations Committee. My name is Tammy Bresnahan, and I serve as the Senior Director of Advocacy for AARP Maryland. On behalf of our more than 850,000 members across the state, AARP Maryland strongly supports House Bill 1409, which upholds the rights of older Marylanders living in medical facilities, specifically assisted living facilities, many of whom rely on these environments for their safety, dignity, and well-being. We thank Delegate Warman for her leadership on introducing House Bill 1409. This bill came to my attention by BJ Carter as well, and her story scared me, and I thought of myself, my family members, that how about if we would lay on the floor for over 4.5 hours, and only because she had an video and an audio recorder did she know how long her husband, who had mental dementia and Alzheimer's issues, was on the floor. Older Marylanders deserve to feel safe in their homes, and that is their home. That is their place where they live. These facilities should not have the authority to prohibit residents from using audio or video monitoring for their own protection. We agree with Delegate Warman. I know that she has to do the best she can with the time element involved and the dynamics of the committee and other resources, so we support her amendments. However, we really ask you to work with her and work with the advocates on a favorable report for House Bill 1409. Thank you very much.
Thank you very much. For the record, my name is Dana Kaufman. I'm here on behalf of Lifespan Network. I first want to thank the delegate for having many conversations with me about this bill and working with me on it. As you can imagine, we had very robust conversations within Lifespan about the best way to proceed. And at this point, we do appreciate the ability to take what was put into place in 2003, Vera's Law, to provide the guidelines to assisted living. And just as a note of clarification, the bill talked about Alzheimer's special care units. Those are units within an assisted living. They are not licensed separately. So just to make sure people are aware of that. And this would apply to all assisted livings. The bill will also have a requirement for OHCQ and others to take a look at the guidelines to see if they need updating. The guidelines were passed in 2003. It's 2025 now, so technology has changed. So we'll be looking at that in ways, but the guidelines have worked. They also include some good templates and policies for the nursing homes and now assisted livings to use. And I will say one of the defining factors for us in coming to this amendment was that we recognize that families are putting in these devices, and oftentimes they're doing it good intentioned, but without roommate consent, without the communities or programs knowing about it. I had one tell me that they would support this approach because they kept hearing voices in the middle of the night and they couldn't figure out where it was coming from, and it was coming from a camera that they didn't know was there, and that was, causing concern just because they didn't know and they were hearing the voices. So we do think that this is a good approach. We understand it doesn't go as far, but we appreciate, again, working with the delegate and to continuing to examine this issue. Thank you.
Okay, are there any questions first from our guests from Judiciary? Proceed.
Thank you, Mr. Chair. Thank you, panelists, and thank you, Delegate Mormon, for bringing this bill. There was a concern about state-run facilities in the testimony. Is there anybody on the panel that can
Yeah, thank you for the question. There's no state-run assisted living facilities, so it wouldn't. That would not be a concern for this current version of the bill.
Thank you.
Thank you, Mr. Chair, and thank you for the bill and for working things out. Ms. Kaufman, why would we not take this opportunity to also allow for audio recording?
Audio is against this, and I am not an expert in this by any means, so luckily we do have individuals from Judiciary, but audio is against the state's wiretap law, so you would have to have an exemption from those as well. So given the time and the money, it just seemed like this would be a cleaner approach, and then we can study that issue going forward.
So if we found out during subcommittee that we could actually use this because it makes an exception, any way to make an exception in these situations for the audio, would Lifespan have any objection to that?
I would have to go back, but Vera's law does not have that, does not allow that.
Thank you.
Thank you. It's the state and federal wiretap laws that would kind of be a problem with the audio. I'm sorry, I was talking to a colleague mid-sentence. Thank you, Mr. Chair. My question is, one of the concerns I have we have a deficit in assisted livings, right? We don't have enough to meet the demands of our state. And I'm wondering what kind of chilling effect this may have, because a lot of assisted livings are small family-run operations where the people actually live in the homes with their the people that they're providing care for. So how will having these cameras in people's actual home work? And then what happens when other residents or their family don't consent to the recording? Then what happens?
So thank you very much for that question. And I appreciate you recognizing that there is differences between assisted living and nursing homes, because assisted living is really a small business in the state of Maryland. You've heard me say that many times. The nice thing about Vera's law at this point is, one, Vera's law guideline says you have to have consent. If you are going to do it, you have to have consent. It actually also allows for, and it's an election, it's not a mandate, so there has to be agreement between all parties, the family who wants it, the roommate if there is one, and the community.
Okay, thank you. Thank you.
Thank you. Okay, there appear to be no other questions for this witness panel. Let's see, do we have And there's no one else. Is there anyone else who wishes to testify on this bill in person or virtually? No one has signed up for virtual. Okay, thank you very much.
Thank you.
Thank you. Delegate Wu, House Bill 1309. And you can come up with your other witness.
Yes, can I bring my
Please.
panelist here? Professor Ben Yellen. Good afternoon, Mr. Chair, the member of the Health and Government Operation Committee. For the record, I'm a Delegate Chao from District 9A, representing Howard County and Montgomery County. I'm presenting HB 1309, which aims to establish a more comprehensive guidelines and practice to bolster the cybersecurity of our educational institutions. This bill seeks to remove outdated purchasing priorities, strengthen compliance with state cybersecurity standards, and employ information security officers to support the local school system. This bill is cross-filed by Senator Katie Hester. Nationally, according to Government Accountability Office, federal agencies reported over 30,000 IT security incidents in the year 2022. The U.S. faced a total of 869 ransomware attacks during the same year, leading to financial losses rising nearly 50% compared to the previous fiscal year, from $6.9 billion to $10.3 billion. Similarly, the education sector experienced a 258% increase in cyber attacks compared to the previous year, with a 546% rise in data breach cases as well. The growing number of cyber attacks demonstrate a substantial need for implementing statewide cybersecurity protocols to foster a secure digital infrastructure. Locally, not a long time ago, in 2020, the Baltimore County Public School System experienced a ransomware attack. The incident, which began with an email being mistakenly opened by a staff member, will cost the school system nearly $10 million to recover. Students, teachers, and staff members were locked out of the system, and normal school operations were interrupted, which was a huge learning loss. HB 1309 is proposed to minimize such incidents occurrence in the future. HB 1309 would broaden the definition of educational technology to include cybersecurity, account for cybersecurity professionals in local school system costs, and incorporate cybersecurity expenditures in annual fiscal reports. The goal is to have adequate cybersecurity professional staffing, and beginning in 2026, local school systems should comply with state minimum cybersecurity standard and conduct cybersecurity maturity assessment every 2 years. Additionally, within the state of finance and the procurement article, the bill proposed that the Office of Security Management in the Department of Information Technology must annually review and update the state cybersecurity standards, as well as provide service and guidance to local governments in an effort to improve cybersecurity-related actions across the state. School systems and government agencies often face substantial financial costs of their cyber attacks, diverting resources toward a system which actually focus on their serving. Cyber incidents strain budgets and can expose confidential information as well, raising the risk of identity theft and unauthorized disclosure of records, thereby compromising individual security and destabilizing public trust in government agencies. By repealing outdated purchasing requirements and prioritizing the implementation of cybersecurity policies, HB 1309 strengthens the digital protections necessary to reduce financial burdens and security threats which are caused by cyber incidents. As you noticed in the original fiscal note, it is not surprisingly high. We are amending the bill to make it more affordable, probably cost neutral. We're submitting the amendment today, so hopefully you will receive that by today. And the amendment will talk about if the LEA does not meet the minimum cybersecurity standard, they must first meet with a DOIT information security officer and develop a plan for the resolution of outstanding issues and timeline to fix it, and submit a plan to state CISO office. So this will probably eliminate all the fiscal note, but still provide a solid framework to enhance our cybersecurity, or security breaches could happen anytime. I'm looking forward to your favorable report. Thank you.
Mr. Allen?
Thank you, and I want to thank Delegate Wu for bringing this important legislation forward. My name is Ben Yellen. I'm the Program Director for Public Policy and External Affairs at the University of Maryland Center for Health and Homeland Security. I was also the co-chair with Senator Katie Fry Hester of the ad hoc subcommittee of the Maryland Cybersecurity Council on state and local cybersecurity. The cyber threat to K-12 education is particularly acute. School districts face two particularly unique vulnerabilities. First, schools house sensitive data, such as social security numbers, addresses, and other personally identifiable information of students, faculty, and staff. Second, public school systems have been historically under-resourced. Particularly in smaller jurisdictions, school systems do not have the personnel, expertise, or funds to protect their networks. As a result of these factors and many others, attacks against K-12 schools have increased by nearly 400% over the past decade. HB 1309 is an important first step in protecting our schools from cyber attacks. This bill builds on the 2022 cybersecurity package by requiring the Office of Security Management within DO-IT to set minimum cybersecurity standards for local school systems. OSM is well situated to develop these standards commensurate with best practices and federal standards like the NIST framework. And the bill allows flexibility by not being overly prescriptive as to which measures school systems should adopt. For these reasons, I respectfully request a favorable report on House Bill 1309. Thank you.
Are there questions for these two witnesses, the sponsor and this witness? Seeing none, we thank you very much. There is a witness favorable with amendment.
Thank you.
Fatima Waheed. Fatima Waheed. Thank you.
My name is Hussein Waheed. I'm with the Advanced Technology Acceleration Initiative, University of Maryland, College Park, and the methodologies, algorithms that we have developed deliver transformative economic efficiency from interactive implementation specifications and standards. These standards play a significant role in reducing the risk of cybersecurity violations, breaches, and risks. Information on open and direct results during the last 5 years have shown that just the implementation of these methodologies and implementation specifications and standards produce economic efficiency of over $500 million up to 2030. And every year, $70 million are saved just from one initiative that was developed, implemented, and delivered in 2 to 3 months. And this initiative later on became a national standard. So these methodologies are consistent with the #1 ranked Center for Advanced Lifecycle Engineering, University of Maryland, College Park, and also consistent with the recommendations and implementation practices of distinguished Professor Ashwani Gupta at University of Maryland. Last year, we had put together a bill that was to implement these practices, but the work group, governor's work group, did not meet, and we have not been able to proceed further with the implementation. The survey just recently revealed has shown the validity of all these projections and implementation practices. So the pilots, guidelines, and bills do actually accelerate the development of agile, adaptive, dynamical algorithms that are needed for continuous human and machine learning, artificial intelligence, cybersecurity, and transformative economic efficiency.
Thank you very much. Are there questions for this witness? If not, we thank you very much. That concludes the hearing on House Bill 1309. The next bill is House Bill 1166. Delegate Adams.
Good afternoon, committee members. For the record, Delegate Chris Adams here to present House Bill 1166 titled State Finance and Procurement Retention Proceeds. The bill is a reintroduction of a bill I brought to the committee for the past couple of years. I bring it again today just because I believe there's an issue that needs fixing. This bill will fix a problem within state procurement. So you'll recall in prior years I've testified that I passed this same bill for private contracts under the real property article. The purpose of this was to set finite timelines on retention proceeds. So I think the committee would have to conclude with me as to what the definition of retention is, and what it is the protection that an owner is afforded under Maryland law to withhold, in this case, 5% of any contract for the purpose of making sure that warranty period is covered, there are any remaining issues with the execution of work. And at the end of the day, the state, in addition to what is already afforded under private contracts, the state has additional benefits under law that basically let them hold monies for any amount and for any real good cause. All right, so that's current law. In the years past where I've had difficulties on the bill is when Department of General Services and MDOT will come in and they talk about retainage, but when they talk about it with a definition that I disagree with. Retainage is not an incentive. It's not a bonus. It's not meant to be anything other than protecting the owners after the work's been completed. So in my bill, what I've said is that if there are undisputed amounts, so if the state has an undisputed amount of money, look, punch lists are disputes. Punch list is work that's not finished. If there are any other issues related to warranty and having to come back, these are disputed amounts. So if the state does not have a dispute with the amount of this retainage that's owed, it sets in motion under the bill a 90-day timeline for which retainage money gets paid. I'll just leave the committee with the final thought on this because you've heard the bill before. I wouldn't be here if I didn't have some personal experience with retainage, and my testimony to the committee is that in many cases through the lens of contractors, owners can certainly take far longer than 90 days, and with the state, I would gander or guess that sometimes people wait almost a year before they get their final monies, and that'll be the testimony you've heard both perhaps in this bill, but certainly in prior years. And that's what I'm trying to fix. I'm not trying to take anything away from government that they don't already have with or without the bill. What I'm trying to do is say it's good business to set a finite timeline when there's undisputed amounts of money and that those get paid within 90 days. So with that, I'd ask the committee's favorable report. I certainly can talk to the bill because I have experience and would be glad to answer questions.
Mr. Griffin.
Thank you, Mr. Chair, members of the committee. Andrew Griffin here on behalf of the Associated Utility Contractors of Maryland. Here, happy to support the bill. I will just say, utility contractors, think of folks who work on water pipes, sewage pipes, septic pipes. Oftentimes, these contractors are your first or your second tier contractor, so lower down the totem pole when it comes to payment. These subcontractors further down the line, oftentimes they're constrained on when they can hold a general contractor responsible for payment by the Federal Millers Act. So they only have 90 days if they don't get paid to go after the bond of the general contractor. So what this bill does is it gets that payment process moving faster. So for the person, in the case of a lot of utility contractors who aren't responsible for items on a punch list, the punch list typically does not include whether or not the water pipe has been installed correctly. These folks oftentimes can wait a very long time to get paid. And so the legislation here would fix a lot of that. So happy to answer any questions, but just want to urge support for the bill.
Thank you very much. Are there questions from members of the committee? Chair seeing none. Oh, sorry, Delegate Johnson.
Thank you, Mr. Chairman, and thanks for the bill. Is there anything that would take longer than 90 days when it comes to the workmanship or the job being done correctly? Is there anything that would take longer than 90 days to show up?
Right, so I mean, under current law, and you'll see that in the bill, any disputed amount or any amounts determined by the state that they wish to withhold to protect the interests of the state can be held longer than 90 days. And in fact, you don't even get to the retainage component because the state can withhold this before we start setting the timeline in place for the 90 days.
All right, thank you. Yeah. Thank you, Mr. Chairman.
Thank you.
If there are no other questions, that concludes, and there are no other witnesses, that concludes the hearing. Thank you.
Thank you, sir.
Delegate Patterson, House Bill 1163. Well, that's an excused absence. Okay, and also with an excused absence is Delegate Cullison, House Bill 1448, but we have Leon Yee testifying for Delegate Cullison. On House Bill 1448, Animal Testing and Research, Alternative Non-Animal Test Methods. I see.
All right. Good afternoon, Chair, Vice Chair Colson, and honorable members of the House Health and Government Operations Committee. Thank you for the opportunity to present HB 1448, Animal Testing and Research, Alternative Non-Animal Test Methods. This bill prohibits certain research facilities in Maryland from using traditional animal testing methods, provided that an alternative non-animal test method has received approval or the requirement to use a traditional test method is waived. During circumstances where no non-animal alternatives are available, the smallest number of animals possible should be used in order to minimize pain and suffering. Maryland is a national leader in biomedical industry and research. We spearheaded the effort back in 2023 to create the Human Relevant Research Fund, which provided Maryland scientists with grants to develop non-animal technologies. However, now that we have these new non-animal methods, we must mandate that they are prioritized over traditional animal testing methods. Though some might say that animal testing is critical for biomedical research due to animal similarities with humans, this does not hold up in the results. Animal tests are not the best indicators or subjects of human biology. The NIH has studied that almost 90% of human drug testing fails during human clinical trials after having completed animal studies. This is because of the lack of efficacy or unexpected toxicity on humans. Alternative methods such as organ chips, living cells taken from humans, catch these costly errors before moving to clinical studies. These chips help reduce the number of drugs that, though may pass animal trials, ultimately fail in human trials. This saves on research and development costs as clinical trials get more expensive as they progress. Testing facilities also lack requirements to ensure proper reporting and documentation. HB 1448 addresses limitations in federal law to properly gauge the number of animals, non-animal alternatives, and waivers used by Maryland facilities that use animal testing. If Maryland is to maintain its position as a national leader of biomedical industry and research, we must move away from now outdated animal testing. We must embrace faster, less expensive, and more human-safe alternative testing methods to keep up with states who have already passed similar laws, such as in Virginia and New Jersey. HB 1448 is the next natural progression in moving Maryland towards a healthier and safer future, one that tackles our most challenging medical issues, one that minimizes unnecessary animal suffering, and one that cements us on the national stage. Thank you all for listening, and I respectfully request your favorable consideration.
Thank you. I would just add for the committee's information, Mr. Yee is one of Delegate Cullison's legislative interns for the current session and a native Marylander, and is a junior at Johns Hopkins studying Earth and planetary sciences.
Thank you.
Ms. Conley.
Thank you so much, Chair, members of the committee. My name is Kathleen Conley. I'm Vice President with Humane World for Animals, formerly called to the Humane Society of the United States. I'm a Frederick citizen, and I used to work in an animal research laboratory for several years. We're here to support House Bill 1448, which will prevent the use of traditional animal tests when there is an accepted non-animal test available, and then will also increase transparency of animal laboratories. I want to stress that this bill does not impact biomedical research. It is limited to testing of products such as household cleaners, chemicals, drugs, and so on. It does not prohibit testing when it's required by federal law or a state agency. It does apply to Maryland facilities carrying out product testing with the exception of federal facilities. There is a global trend toward adopting non-animal alternatives, including at federal agencies such as EPA, FDA, NIH, and DOD. As you heard, animal tests are shockingly inaccurate, while non-animal approaches are proving to be superior, which is why Maryland passed a law investing in these alternative approaches. This bill will simply ensure uptake of those once they are accepted. Any claims that there's already adequate oversight of animal laboratories simply aren't true. The Animal Welfare Act, believe it or not, excludes most animals used in laboratories. For those covered by federal law, they only have to consider using alternatives. They don't actually have to use them. As one example, we exposed 32 beagles being used for a 1-year pesticide test in a lab. The lab approved that test, even though the EPA waives this test and it was unnecessary. This bill would prevent such a test from happening. This bill has strong public support. A poll conducted in 2023 demonstrates that 72% of Maryland voters support banning product testing on animals, and 80% support requiring disclosure on number of animals used and why they were used, the purpose of the testing, which this bill would require. Humane World for Animals urges a favorable report on House Bill 1448. Thank you.
Thank you. Are there any questions from the members of the committee? If not, we thank you very much. There are virtual witnesses. Lisa Radov, Meredith Blanchard, Kimberly Fulton are favorable witnesses. That's it. Please proceed in that order if you can. Lisa.
Good afternoon, Acting Chair Rosenberg, members of the committee. My name is Lisa Radov. I'm the president and chair of Maryland Votes for Animals, here in strong support of HB 1448. You've already heard compelling testimony about this, and you will hear more witnesses talk about the need to transition to other alternatives to animal testing. When a non-animal alternative is available, it is unfortunately not guaranteed that there will be a transition to a new and more humane alternative. Change is not always easy for large institutions, so the reality is such animal tests can persist even after long, suitable alternatives are available. These animal tests are outdated, and they're long overdue for replacement. HB 1448 would prohibit outdated tests from being used or continuing to be used on these products and to complete the replacement process that we began with in 2023. In closing, I would like to thank Vice Chair Cullison and her wonderful representative today. Great job on your testimony, and urge a favorable report.
Next would be Ms. Meredith Blanchard.
Good afternoon, Acting Chair and members of the committee. Thank you for the opportunity to speak today. My name is Meredith Blanchard, and I'm speaking on behalf of the National Anti-Vivisection Society and our supporters in Maryland to express our strong support for HB 1448. Today, you'll hear from representatives of animal use facilities who assert that their institutional animal care and use committees, known as IACUCs, operate in full compliance with federal law and adequately safeguard the welfare of animals used in research. While this may be true in some cases, IACUCs are not the fail-safe oversight mechanism that laboratories often claim them to be. A review by NAVS found that in 2023 alone, 130 animal research facilities in the United States were cited for a total of 193 IACUC-related violations. In Maryland specifically, 7 IACUC violations were reported at laboratories that year, leading to accidental animal deaths and unapproved procedures being performed on animals, among other issues. This pattern raises serious concerns about the effectiveness of IACUCs as the primary overseers of animal welfare in research settings. These failures highlight the urgent need for legislation like HB 1448. While laboratories may strive to uphold ethical standards, oversight gaps persist and protocols alone are not enough to prevent harm. When scientifically validated non-animal methods are available, their use should not be optional. It should be mandatory for the benefit of both animal welfare and human health. Passing this bill is a step toward advancing better science increasing transparency, and ensuring that laboratories employ the most reliable and ethical testing methods. I urge you to support HB 1448 and move Maryland toward a future where innovation and ethics go hand in hand. Thank you.
Last witness. Go ahead. You're not Kimberly Fulton, I would assume.
No.
Fullerton. So I don't have a name. Sherman McFarland, my apologies.
Am I, Delegate Rosenberg, am I audible right now?
You are.
Okay, perfect. Thank you very much, members of the committee. My name is Sherman McFarland, and I'm representing the American Anti-Vivisection Society today. Founded in 1883, we are the first nonprofit animal advocacy and educational organization in the United States dedicated to ending the use of animals in research, testing, and education. On behalf of our members and supporters, including those in Maryland, we strongly support HB 1448 as presented because this bill will spare animals from pain and suffering and advance the use of reliable non-animal test methods. It is important to note that approximately 90% of drugs tested on animals fail during human clinical trials. However, non-animal test methods are based on human biology, which makes them more accurate predictors of toxicity in humans. As you know, Maryland became a leader in non-animal science when it created the Human Relevant Research Fund in 2023. We support HB 1448 because it requires all research facilities in Maryland to use non-animal test methods when approved by the relevant federal or state agencies. In cases where a research facility is still permitted to perform animal tests, that facility must use the fewest number of animals possible and reduce the level of pain, suffering, and stress of the animals. This provision reflects Maryland's commitment to animal welfare and demonstrates that science and compassion can go hand in hand. We also support HB 1448 because it holds research facilities accountable by requiring them to annually report on the animal tests, non-animal tests, and the number and species of animals that they used in the previous year. This transparency is important because it will encourage the use of non-animal test methods and will also allow citizens to see progress in reducing animal testing. By enacting this bill, Maryland can continue to serve as a model of animal welfare and good science policy. We encourage a favorable report on HB 1448 and want to thank Delegate Cullison. We also encourage the committee to consult our written testimony in support of this bill. Thank you all so much for your time.
Are there questions from the committee for these virtual witnesses? Delegate Patterson, you're in plenty of time. You can catch your breath. You're next. Delegate Hill.
I guess I'm really asking, sponsor, are there amendments being considered? The Office of the AG has asked for some things. There are some other testimony. Are you all looking at amendments with these different stakeholders?
It's my understanding that the sponsor is interested in speaking with anyone who would like to discuss amendments.
Okay, thank you. That's all I need to know.
There are no other witnesses and no other questions. We thank you all for your testimony. Appreciate it.
Thank you.
Thank you. The next bill is Delegate Patterson's bill, Task Force to Study Fencing for Bodies of Water and Playgrounds established, House Bill 1163.
Thank you very much. Good morning, Chair Rosenberg and members of the House Health and Government Operations Committee. For the record, I'm Delegate Edith Patterson, sponsor of House Bill 1163, which is a task force to study fencing of bodies of water and playgrounds. This legislation is inspired by the heartbreaking story of a 5-year-old boy from Charles County. This boy was autistic and nonverbal. Tragically, he drowned after wandering away from a supervised area. Meeting with his parents and members of the autism community in Charles County, my eyes were opened to the devastating reality that drowning is the leading cause of death for autistic children and adults. What I learned was deeply concerning. Nearly half of children with autism are at risk of wandering away from safe environments. This behavior, known as elopement, is often paired with an attraction to water and an inability to recognize its dangers. This behavior resulted in an alarming number of preventable tragedies. In response, I have introduced two critical pieces of legislation. One focuses on elopement reporting, while this bill establishes a work group to study fencing. The work group's mission is to evaluate and recommend practical measures to protect children at risk of elopement. Specifically, there are two things this bill will do. First, is to assess fencing requirements for bodies of water. The work group will review current standards and propose ensuring bodies of water are completely enclosed with sturdy fencing that meet modern safety standards. And secondly, the committee will evaluate fencing for playgrounds. It will also study fencing requirements for playgrounds managed by housing corporations, condominium associations, or homeowners associations to ensure these areas are safe, but most of all that they are enclosed. The measures are essential to safeguard children with autism and prevent further future tragedies. By studying infrastructure solutions like fencing, we can safely create environments for children at risk of elopement. We owe it to the families of our communities to make proactive alternatives to protect their children and to ensure their safety. We have one amendment for consideration, and that is to add 2 representatives to the task force. And again, I am encouraging your support for this legislation, and we have support from the Legislative Black Caucus of Maryland as well as the ARC of Maryland. We're requesting a favorable report. Thank you. I have a witness also to testify.
Please, next witness.
I am Victoria Rodriguez-Roldan. I am the coordinator of State Autism Strategy for the Maryland Department of Disabilities. We're here on an informational basis to be able to answer the questions, any questions that this committee might have asked. In the event of its passage, my position will be the one to chair this commission created by the bill.
Are there questions for the sponsor or the other witness? Delegate Hill.
Thank you, Mr. Chair. Thank you, Delegate, for the bill. Ms. Rodriguez-Roldan, why is this not something that in your role as state coordinator of strategy that you can't get the information? Why is it needed that we have a task force do this?
At this time, we already have a series of priorities going on where elopement is one of them. One of the tasks of my position is the introduction and publication, which should be in the next coming weeks, hopefully, of a strategic plan to service the state's guiding policy when it comes to autism-related needs, and it will be covering the next 5 years. So at this instant, wandering and elopement is one of the areas of interest to focus on, but it is one of many areas in it. I defer to the delegate and to this General Assembly to make elopement a higher priority or not, but we do have it in our list of issues that we're working on at the Autism Strategy Program and the Department of Disabilities.
So the workforce gives you resources that you otherwise don't have to look into the issue of fencing?
The workforce, excuse me, thank you for the question, Delegate Hill. The work group will be comprised of persons who will be responsible for the sturdy fencing. And that's why it includes homeowners associations as well as schools and parks and recreation as well, along with parents and other advocacy groups. It does not exist at this time. I know in my community where we also had a drowning. The fencing was put up, but it's just a very flimsy fencing. We want to make sure that the group looks at all angles and will come back in December with a recommendation to ensure that what we are proposing can actually occur.
Thank you. Thank you, Mr. Chair.
Delegate Johnson.
Thank you, Mr. Chairman. Thank you. I think this is an important bill. I just have a question about the bodies of water. You know, how expansive is that? Is that creeks, rivers, the bay? I mean, exactly, are you narrowing it? Because it just says bodies of water, so.
That will be, thank you for the question as well. And I think that's why we will have the various groups engaged. You have the homeowners association, condominiums, and so also the body will make a recommendation as to the areas for enclosure. I cannot be specific in terms of declaring the bodies that will be identified, but I do know that typically they are bodies of water around homes or where elopement occurs.
Okay, just a quick follow-up, Mr. Chairman. And if you don't know, it's fine, but do you know if the majority of the drownings are in pools or stormwater management ponds, things around communities, or if they're in larger bodies of water?
That will be, again, part of the study. For example, they will evaluate where they should be, whether it's around playgrounds, whether it is around homeowners, but they will do a total assessment. And that's why you have state representatives part of this work group as well.
Okay, all right, thank you. Thank you, Mr. Chairman.
If there are no other questions and there are no virtual witnesses and no other witnesses in the room, that concludes the hearing on this bill, House Bill 1163. Delegate Patterson, you have a second bill?
Yes, I do.
We welcome you.
It's House Bill 1306.
Correct. Thank you.
Okay.
Sickle cell disease specialized clinics and scholarship program for medical residents.
Again, good morning, Chair Rosenberg and members of the House Health and Government Operations Committee. For the record, I'm Delegate Edith Patterson, sponsor of House Bill 1306, Public Health, Sickle Cell Disease, Specialized Clinics, and Scholarship Programs for Medical Residents. Sickle cell disease, often called SCD, is a rare, life-threatening genetic blood disorder that affects over 5,000 Marylanders, with more than 50% relying on Medicaid for their care. Historically, specialized SCD treatment has been concentrated in Baltimore City. However, only 30% of Maryland's SCD patients reside in Baltimore City and County, leaving many without sufficient access to care near their homes. As a result, patients are often forced to travel 2 or more hours for treatment, leading to increased reliance on local emergency rooms, many of which lack access to comprehensive SCD infusion clinics, while also driving up Medicaid costs. A proven model for success exists. For example, in 2022, an adult CDS center was established at Capital Region Medical Center, Prince George's County, with the support of Johns Hopkins and the University of Maryland. This program connects specialists from these institutions to a community-based clinic serving over 1,600 SCD patients who previously had to travel to Baltimore for treatment. By establishing this center and connecting the community-based clinics to specialists has reduced emergency room visits by overall 63%. It's decreased hospital admission by 41%, increased access to care for patients, and lowered the costs of the state Medicaid program. Building on the success, this legislation seeks to replicate the capital region model statewide. Specifically, it calls for the establishment of 3 additional SCD centers, special care hubs in Montgomery County, in Hartford County, and a county on Maryland's Eastern Shore. These centers will provide coordinated, comprehensive medical care, linking outpatient services with inpatient treatment at specialized institutions such as University of Maryland Medical System and Johns Hopkins. In other words, it will be a statewide, geographically placed throughout the state. Given the significant challenges that SCD patients face, this legislation is an essential step towards ensuring that patients are provided with adequate and comprehensive care throughout the state. By establishing and supporting a network of clinics, it will ensure that care can be provided to our patients in Maryland. In summary, the legislation is a straightforward yet impactful measure to provide adequate care to SCD patients in the communities that they live in. It addresses a lack of sufficient access to care where it is needed and ensure that SCD patients will have access to comprehensive care. Again, this legislation has support from the Legislative Black Caucus of Maryland, various advocacy groups, and from parents. I am requesting a favorable report, and I have advocates who are here to offer testimony. Thank you.
Thank you, Delegate Patterson. Good afternoon, and Chair and members of the committee. My name is Tanika Hoffman. I am a sickle cell warrior, an advocate, and the founder of the Sickle Cell Coalition of Maryland. I urge you to vote favorably for HB 1306, which brings access to sickle cell care, which is comprehensive throughout the state. Maryland is the home to over 5,000 sickle cell warriors, yet our healthcare system remains underprepared and underfunded to meet our needs. As mentioned, sickle cell disease is a life-threatening condition marked with pain, also known as a pain crisis. I like to tell people when they ask, what does a pain crisis feel like? I would say, have you ever experienced a Charlie horse? If you've participated in sports or possibly experienced dehydration, well, that's what a sickle cell crisis feels like, except for it can last for hours to days to months in some cases. And often there are only a few medical options available to us, which informs our care. And because we live in a society where we're dealing with the opioid epidemic, and opioids are one of the only things that can help treat our pain, we're often forced to the margins. I truly believe that it is important for us to navigate untrained providers, delay in care, and lack of comprehensive services while other chronic diseases receive substantial funding. Care should not be dependent on where a patient lives, and comprehensive sickle cell care must be available statewide. I have personally benefited from the hub and spoke model in Prince George's County. Before the Sickle Cell Center was built in Prince George's County, I was one of the many sickle cell warriors traveling to Baltimore on 295 in excruciating pain, jumping on potholes and screaming in pain. But at least I knew there was a home there where I wouldn't face discrimination and that my medical providers understood my pain. For decades, advocacy in the sickle cell community has faced persistent gaps, but we do have a study, the ESCAPE study, that demonstrates that specialized infusion clinics reduce hospitalizations by 36%. Emergency department visits go down by 46%. This study was done at Johns Hopkins Sickle Cell Center, proving that the structures for care and comprehensive care is very much so important. HB 1306 is a rare and critical investment that will expand access, strengthen the workforce, and provide sustainable care for a generation that is now making it into adulthood as well as into senior citizenhood. I urge you to vote favorably for my community, to listen to our community. We've been ignored for so long, but we are finally making progression, and I thank you so much for the opportunity to hear my story.
Hoffman, since you weren't able to sign up or whatever, after the bill hearing, if you could sign up in the committee offices. Thank you. Mr. Williams.
I think Mr. Williams is online.
Derek Robertson.
Derek Robertson, you are signed up. Thank you. Please proceed.
And I want to start by thanking Delegate Patterson for bringing this bill. It's not her first, and we really appreciate her support for the sickle cell disease community. My name is Derek Robertson. My wife and I started the Maryland Sickle Cell Disease Association in 2006. We have 3 sons, 2 of whom live with sickle cell disease. In 2006, we actually had to move from Montgomery County to Ellicott City because we were concerned about the lack of available care. We needed to get closer to Johns Hopkins. Not everybody can do that. And the situation 20 years ago still remains today, where we talk to advocates in Montgomery County who are trying to see how they're going to navigate care. I don't have much to add to what Delegate Patterson so eloquently outlined, the benefits of this bill and Tanika's story. I just want to thank you for your time, and I want to thank Delegate Hill and Delegate Gazone from Howard County. I want to especially thank Delegate Warman for taking the time to see me last week. So I thank this body. I just ask for a favorable review of this bill. It is critically important to the sickle cell disease community at this time. It's a rare opportunity where you have a model that does what we try to do in healthcare all the time, which is to improve healthcare outcomes while saving cost. And to get those both going together is something that we are proud of, and we have it right here. And I just wanted to mention that this model that's here in Prince George's County is being looked at nationally. Senator Van Hollen has a bill which he hopes to reintroduce this year with a similar model, and he's looking right here in Maryland as guidance for that. So again, thank you for your time, and again, ask for a favorable review of HB 1306. Thank you.
Thank you. Are there questions? Sponsor or the witnesses? Delegate Hill.
First of all, Delegate Patterson, thank you so much for your work in this area. It's a $6 million note, and the Department of Health is pretty clear that they get about $1.2 million a year to do the work that they're doing in sickle cell. So I guess I'm asking, it's not in the budget, they get 1.4. Any solutions to that note?
We are aware that the fiscal cost is astronomical high, but I think it's really important to also bring to the legislature's attention the need for the centers. There could be a consideration, instead of having 3, maybe have 1. I'm not sure. But I think that we have brought this to the Department of Health attention far too often. This is not the first time the bill has been introduced. And it's critical when you think about lives that are lost, and also the challenges that the patients are facing with Johns Hopkins. So it's pretty limited in terms of how they can get the infusion and treatment that's needed. You know, as an aside, in terms of what patients encounter, Tanika indicated she didn't sign up because she was hospitalized. And the sickle cell warriors are really different because in so many ways they look so healthy, but yet the disease is crippling them, not only crippling them, but killing them. And so when we look at the need to have clinics and centers, it cannot go unnoticed.
And the treatments that are available now are life-saving treatments. They have made, these are not just stabilizing treatments, right? These can really...
They are life-saving treatments. And
well, actually, I could speak to that. What you hear in the news of gene therapy, you're probably referring to, will probably impact about 10% or less of the folks. So, for example, I mentioned my 2 sons would probably not be eligible for gene therapy, only because, ironically, they're not sick enough. So it's going to be the patients that are the most severe. And it is a very grueling procedure. So you have to go through a bone marrow transplant, effectively, and then you're months out of work. So what we're really focused on are therapies, because even though that is going to impact, like I said, it's going to be about 10% of the population. To date, since it was approved in 2023, there has been, I believe, 2 patients so far that have been out of study. We do know there are more signing up, but it's not going to be the answer to the services that are critical today.
Thank you. Thank you very much.
Seeing no further questions from the committee, we thank you very much.
I think, I'm sorry, I think Mr. Williams, Rudy Williams, is online.
Oh, okay. He's virtual?
Yes.
Yes, sir, he is. Thank you very much. Mr. Williams?
He is joining.
He's joining. Mr. Williams, we welcome you to the hearing. Please give us your thoughts.
Good afternoon. Wing warrior Denise G. Williams, married 51 years to Rudy Williams, who is speaking, transitioned to heaven in 2024 and prayed daily that God, family, love, and medicine would collaborate a union with our warrior daughter Nicole Millicents and spouse Angela and 3 grandchildren, Kylin, Ava, and Anna, and great-granddaughter Lila, who reside in Montgomery County. Denise and I arrived in Harford County from Connecticut in 2010. And Denise, age 57 at that time, had experienced many crises: iron overload, stroke and partial paralysis in college, acute chest syndromes, necrosis of hips and shoulders, and pulmonary hypertension. The most challenging sickle cell disease experience was kidney disease. An apherous blood exchange therapy every 3 weeks at Johns Hopkins in Baltimore in 2017 allowed Denise to live 7 additional years to see 2 of our 3 grandchildren graduate from high school. The expert care at Johns Hopkins Sickle Cell Disease Center in Baltimore helped Denise reach the age of 71, and the toll of losing our warrior daughter and Denise's warrior sister 4 months apart in 2023 was devastating. Our wing warrior daughter Nicole had different experience in Montgomery County. A Howard University grad, she has successfully transitioned from pediatrics to adult at Howard University Hospital, which excels in expert sickle cell disease care. A second-generation entrepreneur, Nicole and Angela's lives were busy managing 3 busy daughters and companies. Nicole, Dr. John Sampson at Hopkins, and myself tried to discuss sickle cell disease protocols with Shady Grove Hospital in 2018 with no success. Ironically, Nicole transitioned to heaven in 2023 at age 50. And if Shady Grove Hospital had the hub and spoke sickle cell disease care model, like at Hopkins, University of Maryland, and University of Maryland Region Health in Prince George's County, Nicole and other warriors may be alive today. In most cases, warriors desire care where they live. I unequivocally support HB 1306, which supports the sickle cell disease hub and spoke model and funding for warrior care in Harford, Montgomery counties, and Eastern Shore, which they deserve, as well as medical school scholarships in this bill, because we have an extreme shortage of Maryland sickle cell disease providers. Thank you very much for your time.
Okay. I am going to open it up for questions now. Are there any questions from the committee? All right, seeing none, thank you so much for being with us. We really appreciate you. Nice to see you.
Nice to see you, Delegate, and thank you so much for your support.
My pleasure.
I appreciate it.
See you, Ms. Melnick, for your support.
Thank you. You have a blessed day. Thank you for being here. I was at a meeting, so a couple of meetings. Thank you. So, and I think this concludes this bill hearing, right? On House Bill 11. 1 second, 1306, House Bill 1306. We are going now to Delegate Kaiser, House Bill 1051, morticians and funeral directors, not-for-profit funeral establishments. And you could bring your panel if you have one, Delegate. I want to thank Delegate Rosenberg, Chair Rosenberg, for sharing. Really appreciate you. Good afternoon.
Good afternoon, Madam Chair. Good afternoon, committee members. My pleasure to come before you today on testimony on House Bill 1051. And this bill would allow for the creation of not-for-profit funeral homes, creating a licensing option and a regulatory structure aligned with current corporate funeral establishment licenses. You can look at my written testimony to look at the some data about the costs of funerals and the fact that here in Maryland they are more expensive than many other states. And we do have a law from 1945, so I can't blame anyone in the room here, but the law from 1945 restricts funeral home ownership to funeral directors, morticians, and then 59 corporate charters that were grandfathered in. So it seems like it doesn't really create an option for new small businesses, or in this case, for not-for-profit. So the current industry structure, I believe, limits competition, limits consumer choice, and this bill is just one small piece of trying to open that up a little bit. We do have the not-for-profit structure is used by many industries in the state, including hospitals, schools, religious organizations, cemeteries, veterinary clinics, farms, caterers, and bankers. So there's definitely a model for doing this. I do know from the Senate hearing on this that there was many points of opposition, including verbal and written testimony questioning the ethics of one of the people sitting with me. So I don't think that's ever an appropriate thing in these public hearings. I also believe that this is maybe not the beginning of the conversation. Certainly there have been conversations in the past about this, but I believe that we have to look at the overall structure, and I also know that we're looking in general, given the challenges at our state crematories, that there's something not quite right with how things are operated in our state. And so I also believe, based on that legislation of mine from I think it was last year. Time flies when you're having fun here in the General Assembly, right? The green burial bill that I had, that, that's new, that's different. A lot of people want it. Thank you, Delegate Woods. A lot of people want it. A lot of consumers want it, but in some cases, older industries maybe not as inclined to trying something new and different. And so I think that too is related to this. So again, I appreciate your interest in this and hope to have your support, but want us to also, both in the short term, think about what we can do, but potentially even the long term about opening up this industry. So thank you all very much for your attention. Thank you, Madam Chair.
Welcome. Who would you like to go next?
Mr. Emden, Von Emden.
Thank you. Madam Chair, delegates, and thank you, Delegate Kaiser, for introducing this bill. My name is Gidon Van Emden. From my great-great-grandmother down, my family has been involved in their Jewish community's funeral practices, and I continue that tradition today as the chair of my synagogue's Funeral Practices Committee. I'm involved with the Jewish Funeral Practices Committee of Greater Washington, and I serve as a consumer member of the Maryland Board of Morticians. I am here today, however, strictly in my personal capacity to advocate for HB 1051. Not-for-profit funeral homes already exist legally and safely in almost 20 states and around the world. The proposed bill is brief and simple. It changes the law to allow for not-for-profit funeral homes in our great state of Maryland. Over the past months, in discussing this issue with many Marylanders, most simply asked, are they not legal now, and why not? Starting a funeral establishment is onerous in this state, and as explained, it must be owned wholly by licensed funeral directors. This requirement excludes not-for-profits, even as the law allows grandfathered corporate exceptions. So what this bill proposes is simply to allow a not-for-profit entity to apply for a new corporate license. It has to fulfill all other requirements. It has to pass an inspection, appoint a supervisory mortician, and ensure that all matters that require it are handled by a licensed professional. The only difference is that this funeral establishment would ultimately be responsible to a board of directors rather than to shareholders. In discussing this bill with Jewish, Muslim, African American, and other community leaders, I was often told that they would like to support this bill, but are afraid to do so publicly because it might upend their current relationship with a funeral home. The fact that folks are so concerned about retaliation that they fear speaking out is living proof that we need this bill. This bill, which will cost nothing to implement, proposes simply to carefully create the opportunity for not-for-profit establishments to make a significant difference. I ask the committee to report favorably on this bill. Thank you.
Thank you.
Good afternoon, Madam Chair. My name is David Zinner. I'm 74 years old, and I went bicycle riding with my friends Mike and David on Saturday. It was cold, it was windy, it was glorious. I tried to ride at least twice a week, but last year it was not quite so glorious. My hip was hurting, and I could barely swing my leg over the seat to get on my bike. I went to a surgeon who specializes in hip and knee replacements. When he looked at the x-ray, he said, "David, you're bone on bone, you need a new hip." The good news is I do hundreds of these each year. I replied, "What's your success rate?" He said, "I've had 2 that did not work out well because they didn't follow my instructions." I had lots of questions, but I did have surgery, and now I'm back on my bike. My surgeon earned his medical degree at University of Cincinnati College of Medicine. He completed orthopedic surgery at Case Western Reserve, followed by adult reconstruction at Florida Orthopedic Institute. Why am I telling you all this? My surgery was done at St. Agnes Medical Center. In addition to my surgeon, there was an anesthesiologist, many nurses, and physical therapists. My surgery was successful, and I'm back on my bike. But I ask lots of questions, especially when they're going to cut me open. But what was the one question I did not ask of any of the licensed professionals who took care of me? What was that one question? I didn't ask them whether they worked for a for-profit or a nonprofit. And despite what those opposed to the bill will testify, it doesn't matter to those who receive the services. If my licensed, experienced professional doctor can take care of me when I'm alive, then I trust my licensed, experienced funeral professional to take care of me after I die, regardless of whether a profit or nonprofit owns the business. Please pass HB 1051.
Thank you. I'm going to open it up and thank you both for being here. We really appreciate your testimony. I'm going to open it up for questions now from the committee. Are there any questions from the committee? Delegate Johnson.
Thank you, Madam Chair, and thank you for the bill, Delegate. And I'm all for expanding businesses in Maryland. However, my question is, do you think the timing is right now to open this industry with our board situation and the current information this committee's gotten on the lack of oversight and inspections at the time?
That's a great question, Delegate Johnson, and I guess that's a question to be answered by everyone on the committee. But obviously this was brought to me before we had all of that news. But I do think as the Board of Funeral,
Morticians
and funeral directors, thank you. As they are reconstituted, I mean, this could also be something that they take a look at and study as well. So there's always that possibility. But yes, timing is everything. So maybe I wasn't so lucky on this one.
Thank you. Thank you, Madam Chair.
You're welcome. Delegate Shalega, followed by Delegate Riley.
Thanks, Madam Chair. Thanks for being here. Good to see you. So I was wondering a couple questions. I'll keep them brief because I know we have a long day. How will the board or anyone regulate the owner, since the board, it's my understanding, regulates those that are licensed by them? Would you create a separate licensing scheme?
Potentially, it would be the same, that you would still require these not-for-profits to have a trained mortician on staff, and they could be regulated in the same way.
So I'm reading the testimony that came in, and this is opposed from actually a funeral home that I know. They're in my area. They said that there was an example of this with an establishment that was sold to an individual from Pittsburgh. Under the ownership, multiple supervising morticians were cited for violations. It sounds like it was a revolving door. So they hired the licensed mortician that had very little influence over how that was being run. So they quit, and then they brought another one in, and it, rinse and repeat. So while I understand what you're trying to do, I think we have to get at the ability to regulate as well the nonprofit that owns it, because they're under the current scheme. I don't think we can.
Thank you, Delegate Schleg, and I appreciate you bringing up that point, and I heard a similar point from the opposition as well, that when it's merely the mortician working for the person, they don't have the same say and ownership, agency, all that within the organization, and the revolving door that you're describing. So maybe it would then need a different regulatory structure.
Yeah, because they could potentially not be Marylanders. I mean, it could be a nonprofit from California. So, then that gets to another point. But
we could also limit it to just Marylanders.
Right.
That would be fine.
Thank you, Madam Chair.
Riley.
Might I add to that, if you don't mind, Delegate Shalega?
Usually we don't allow it, but let me ask you a question. What do you think about that?
Thank you for your question, Madam Chair. The structure as it currently exists requires an establishment license, and you can only apply for that either by being a professional association or corporation, or you can have one of those 59 corporate licenses. Those 59 corporate licenses, I've looked at the Board of Morticians website, have not caused any more problems, relatively speaking, than the licenses that are issued to professional associations. So in that sense, I don't know that the ownership is necessarily the question, just as in David's example of a hospital. You have to hold the professionals accountable and the organization, but how it's owned is not necessarily the issue in that respect.
Okay. We have a follow-up, Delegate Shalega.
I did.
All right.
You were reading my mind.
Yes.
In that case, why don't you just purchase one of those 59 outstanding charters?
Because they almost never come on the market. When they do, and I say this respectfully to the corporations that can afford to do that, they get snapped up by larger corporations that can afford to pay a few $100,000 for each of them. Also, why should we limit it this way? The question of why don't we just open up the entire regulatory structure is a fair one, especially in light of a review of the board to begin with. But what we've tried with this bill is specifically to create a very careful carve-out that allows for not-for-profits, but does not take an axe to the entire regulatory system.
I think yes, and we probably agree it needs some better structure. Thank you.
You're welcome. Delegate Riley, followed by Rosenberg.
Thank you, Madam Chair. Yeah, so I too was reading some of the letters of opposition, and they clearly state out that for-profit and nonprofit are two different entities. So we're a little concerned about, or they're concerned about, like tax obligations. There's going to be a difference there, and also you kind of mentioned a little bit about the financial responsibilities of not going for the business. So do you see anything, that the disadvantages that you're putting on the current businesses, and can you refute that or explain, that would not be an issue if we pass this bill for profit or nonprofit? Because they do have different regulations, or none, or different tax breaks.
I understand the opposition to the bill is largely, at least as I see it, a fear of more competition. And the question about regulation is, I would argue that the system for regulating funeral homes today is complicated, but it by and large works. There is no financial test in that system. We don't ask any of the new applicants or any of the recurring applicants, renewing applicants, to prove anything in terms of their being able to go concern or make a profit or stay alive. There are regulations that require them to respond in a certain way if they can no longer do business. And that's important. But in terms of a financial test or a business test, that doesn't exist for current funeral homes. So why should it exist for new ones?
Well, I guess because currently they've been in business for years, and they've put up a lot of money, and they've paid a lot of money for those licenses and to get certified and all of that. And why shouldn't a new nonprofit come in and not have to follow the same?
The new funeral homes that are not corporate licensees, there's no requirement like this. Anyone can go to mortuary school and follow the requirements, and then as a mortician, start a professional association and ask for an establishment license, and they get inspected on all kinds of things, and those regulations are obviously public and clear, and financial acumen is not one of them.
Okay, well, thank you for explaining that. I appreciate it. Thank you very much.
Delegate Rosenberg, followed by Olston.
Mr. Van Emden, you said your family had been in the business, the funeral business for 5 generations. Could you tell us where that began and if the cemetery, the Jewish cemetery in that community still exists?
I should say we were not in the business. This is all volunteer. That's important, especially because I'm a consumer member of the Board of Morticians, and I'm, as such, not allowed to have a financial connection to the industry. Yes, I grew up in Amsterdam, and my uncle, my grandmother, and her parents, their parents, were involved in Amsterdam, in Nijmegen, in Os, in a variety of places. I was involved also in London when I lived there. I can also tell you that outside of the United States, many funeral homes, especially Jewish and also Muslim ones, are usually operated by the communities they serve rather than by corporate entities.
Thank you.
Thank you. Delegate Olston.
Thank you, Madam Chair. And thank you for this bill. I actually really like the concept. I was just, I guess I'm not clear, and I'm sorry if you explained this earlier, as to why you can't currently do this under existing law.
Under existing law, to apply for a new establishment license, sorry, I should take a slight step back. There's a number of different requirements for being a funeral director and owning and operating a funeral home. It's actually our pro bono legal team has not found an industry that is more strictly licensed in this respect in the state. You need to you need to first become a licensed funeral director or mortician, and there's regulations for that. That is not what we're changing. Then, as a mortician or a group of licensed morticians, you can set up an establishment, a funeral home, and then when you fulfilled those requirements, you can apply for a license, and that license will only be granted if you are set up as a professional association or a professional corporation that is entirely owned by licensed practitioners. And so a not-for-profit cannot have that structure and is therefore unable to fulfill that requirement.
Understood. Thank you.
Thank you.
Thank you. I don't see any other, oh, Delegate Shalega. Okay.
Sorry.
All right.
I think I'm where Delegate Riley was going, but didn't tie the bow on it. Look, I'm all for free markets. I'm a capitalist, but the free market has to be equal. So when you're not for profit, couldn't you then take donations, contributions that were tax deductible? So you could operate your business from tax deductible. I go to my church. I send my church a nice contribution that is tax deductible for me, supports your business. My church holds a funeral for me and charges me $100. How do you create a free market with equal opportunity? And then could you then serve anyone that came to your church or synagogue or mosque to do the same thing? And I think that's the competition part that Delegate Riley was getting at was, let's make it a free market. Let's open it up. Let's let everybody compete on the same ground, but it has to be a level playing field.
Delegate Shalega, thank you for that question. Part of what I ended my testimony with is mentioning the different industries that we already allow in Maryland, from hospitals, schools, religious organizations, cemeteries, vets, farms, caterers, and bakers. So we already allow for that type of structure.
Well, hospitals are highly regulated, as you know, so
yes.
that you can't use that one. So
Well, they're highly regulated too, but I hear you.
We don't have a rate-setting commission for funerals that says you got to charge this much for a casket and this, so some of that's not.
Well, it sounds like you're suggesting it.
Apples. No, again, I'm a free market capitalist. That would be the opposite. So anyway, that's another concern that I think Delegate Rowley was trying to get out there. Thank you.
All right, seeing no other questions, thank you so much for being with us. We really appreciate you. Let's go to a panel of unfavorable. Holly McComas, Samantha Logan, Errol Canup, Walter Nathan Malloy, Camille Fish, William Costelli, Andrew Osmeyer, okay. Good afternoon.
Good afternoon. Good afternoon.
Who would like to get started, please? Why don't you go ahead, William? Bill, go ahead.
Thank you. Thank you, Madam Chair, members of the committee. Bill Castelli with SCI and their Dignity Home Funeral Homes. And we are opposed to the legislation. We believe that, this is a difficult business to be in, and many of you have probably seen some of the difficulties that heaven-bound crematory experience. So we do believe that, these businesses need to be well-resourced, need to have the best training, and we think the current business model provides that. We think there are opportunities within the business model as well for a nonprofit to open if they purchase one of the corporate charters. And for that reason, we encourage an unfavorable report. We think to the extent that it is too onerous to open up, maybe that is where the focus needs to be in terms of taking a look at existing regulation, not just within the state, but this is an industry that's also regulated by FTC too. And for that reason, we would encourage an unfavorable report.
Thank you. Next, please.
Holly McComas, McComas Funeral Home, 7th generation funeral director. We were founded in 1808. Thank you for having us. I just want to point out, not for profit does not mean cheap or inexpensive, especially if you're talking about funds and where they're coming from. They're going to have to come from somewhere, and our communities are heavy laden with nonprofits. So it's going to cost something. So it's a matter of where those funds are coming from. And we are, as professionals and as funeral directors, we encourage the regulation. We don't want to lessen that. We want to be the best out there that we can be. And by doing that, we have regulation. So we do encourage that regulation. We want to be regulated just as we would want the nonprofits to be regulated. So I would encourage if somebody wants to be a nonprofit, do just like you said, go through all the steps that the rest of us need to, so that way you can be regulated and you have your boundaries. For-profit funeral homes and businesses really do encourage, through taxes and job creation, a healthy community, a healthy financial situation for the state. The nonprofit would be asking for money from both the state and the community. So I encourage the thought process behind that, again, where the funds are coming from. I do oppose this regulation, and I know everybody has my written testimony, so thank you very much.
Thank you.
Yes, I'm Samantha Logan. I'm a 4th generation funeral director, vice president, and co-owner of Harry Witzke Funeral Home, which is a family-owned corporate funeral home. I also have the honor of being the current president of the Maryland State Funeral Directors Association, and both myself and the association do stand in opposition to this bill. While the intent behind these bills may seem beneficial, they pose significant risks to the current funeral service industry and the families it serves. Maryland already has a competitive funeral home market that offers pricing options below the national average. The introduction for not-for-profit funeral homes could disrupt this balance, potentially leading to higher costs in the long run and threatening the financial stability of existing funeral businesses. The recent failure of Heaven-Bound cremation services in Charles County highlights the risks of inadequate funding and mismanagement in funeral services. Financial instability is a significant concern for not-for-profit funeral homes, particularly in high-cost areas like Montgomery County, which could jeopardize operational standards and consumer safety. Additionally, the potential for religiously affiliated not-for-profit organizations to own and control funeral homes raises concerns regarding regulatory exemptions. If such entities seek religious exemptions, they could gain an unfair competitive advantage and operate outside of the stringent state laws that ensure consumer protection and public health. Maryland's funeral home industry is already well regulated and provides compassionate, affordable services to families. Introducing not-for-profit funeral homes threatens to undermine this system, reducing employment opportunities, diminishing tax revenue, and eroding consumer protections. I urge you to oppose House Bill 1051 and support policies that maintain the integrity and stability of Maryland's funeral service industry. Thank you.
Thank you for being with us. Next, please.
Good afternoon. My name is Walter Nathan Malloy Jr., and I am the attorney and lobbyist for Maryland State Funeral Directors Association. I am also a third-generation funeral director and vice president of March Funeral Homes, Marshall March Funeral Homes, and March Life Tribute Centers in Maryland. We are at a critical time in funeral service. What the committee decides here today will have an everlasting impact on funeral service and the Maryland consumer. I cannot sufficiently stress the importance of opposing House Bill 1051 for the state of Maryland and the consumer. This is about accountability, the accountability of ownership, making sure that owners are licensed, making sure owners are properly educated in funeral service. Mr. Von Emden is incorrect. There are requirements, but they may be onerous, but they're necessary. If anything has taught us about the recent events in Charles County, it's to make sure that we protect the consumer. And how do we best do that? We best do that through licensing regulations, making sure everyone is sufficiently trained and educated and has the best ethics available to practice funeral service. House Bill 1051 will have unintended consequences that will impact funeral service. It attempts to relax the restrictions codified in 7-309 and 7-310. The restriction on ownership in Maryland was challenged in the U.S. Court of Appeals. The court noted the restrictions on funeral establishment ownership are rationally justified because the use of corporations causes such business to be owned by people who know nothing about funeral service. These restrictions foster a greater degree of accountability to regulators. The Court of Appeals went on to state that the Maryland General Assembly had a rational basis for believing that limiting funeral home licenses to licensed individuals would foster a greater degree of accountability. Today is not the time to deregulate funeral service. I believe Winston Churchill said it best, those that fail to learn from history are doomed to repeat it. Thank you very much.
Thank you for your testimony. That's a great quote, especially with everything that's happening in the world right now and in this country. I'm going to open it up for questions. Delegate Bagnall, followed by Delegate Rosenberg, followed by Delegate Taveras.
Thank you very much, Madam Chair.
Oh, in Austin. Okay.
And thank you for your testimony, but I'm confused as to what the opposition is, because I'm reading the bill and I don't see anything in here that's about deregulating or about not requiring the same standards. And I am aware that we have a lot of nonprofits that operate in the healthcare space and our assisted living space. So I'm trying to understand what the concern is. Because it doesn't appear that this is about deregulating the services, and it doesn't appear that it's about changing the standards. So who's ever best to answer this? What is the opposition? What is the feedback?
I'll attempt to answer that and be brief. Okay, the law currently states that there are only 58, 59 current corporations that can operate a funeral establishment in Maryland. They are not creating any new corporations. This bill wants to be able to create a new corporation and operate that corporation as a not-for-profit. A not-for-profit corporation has no owners. There are no owners to undergo a background check to make sure they're adequately, they will handle money appropriately. Let's start with that. We as funeral directors are required to undergo background checks to make sure we handle money appropriately and have handled money appropriately, i.e. there are no criminal convictions for theft or embezzlement, any of those charges. Not-for-profits can be created by people with a criminal background. There's nothing in this bill that restricts that. Not-for-profits are operated by boards of directors, okay? But the boards of directors are not required to be educated, trained, or licensed in funeral service. So we're talking about individuals operating funeral establishments, handling the remains of your loved ones who haven't taken one accounting class, haven't undergone any training in mortuary law, business, or any requirement whatsoever, making decisions for a funeral establishment and then instructing a licensee under the auspices of a supervising mortician what to do and what not to do. And that's the problem. You're opening up funeral service to be controlled and control a nonprofit to people who do not have the education, training, or experience. We undergo at minimum a year's apprenticeship under a licensed funeral establishment and licensed funeral director just to learn how to become a funeral director. There's nothing in the law that's going to require these board of directors of nonprofits to do that. And that's what Mr. Van Emden has not shared with you. He's not shared the fact that they're asking you to allow them to complete an end run around the current regulations that require at least the three of us to undergo 2 to 3 years of education, training in various topics so that we can manage and properly operate a funeral establishment. I hope I answered your question. If someone else wishes to chime in, feel free.
No.
Sorry.
Yeah. I have Delegate Rosenberg.
The next to last witness talked about, and you've expanded upon it, Mr. March, the concerns raised by religious exemptions. In effect, is what you said, I think. But wouldn't the religious exemption come about only if a court of law held that this different type of home had a legal right to that exemption? So it's not a discretionary or something they can do of their own volition.
Are you asking me or?
Either way.
Whoever wants to answer.
Okay. Being a practicing lawyer, I'm also aware of the fact that many times things are done based on interpretations of laws or the silence of a law. So you're correct, there would be a determination by a court as to whether or not they were in fact exempted or not. However, again, it's open to interpretation. I can't say they could or would not be able to operate based on an exemption because I'm not familiar with the facts and circumstances, and that would pertain on a case-by-case basis. So I apologize, but I hope I answered your question, but I don't think I did.
Okay. Thank you. I have, let's see, Bagno, Rosenberg, Taveras, Alston, Riley. All right? Taveras, you're next.
Yes, ma'am. Thank you, Madam Chair. My question is, so I just want to make sure that the way you're interpreting the legislation is that individuals can collect money that's donated and at the same time receive funds from the family in order to intern the individual, correct?
Well,
is that how the funds for this nonprofit would work?
Well, you use two different terms, and I just want to make sure I'm clear. You said donate money. So nonprofits can collect donations that are tax-free, that they can use to unfairly compete against for-profit businesses that must pay tax on income. So yes, they can collect donations. They can also collect money from families to pay for funeral expenses as part of a funeral establishment. They would, in theory, also be allowed to collect what we call pre-need or pre-arranged funds to prepay for funeral expenses that have a whole set of different regulations regarding trusting and insurance and escrow agreements. And that's been a issue for several not several, but there have been issues with regarding properly handling those funds with licensees over the years.
Thank you. Next, we have Delegate Olston, followed by Riley.
Thank you, Madam Chair. So I'll try and be brief, but your testimony raised a couple of concerns for me. First, when it comes to corporations, you can have the same restrictions, whether it's a for-profit or nonprofit corporation. So the owners of your for-profit corporations in Maryland could potentially not have that same training and education that you've alluded to, because they would just be the directors or members of that corporation. So where in this bill does it say that these nonprofits are going to be treated differently than the for-profits? Because I don't see that.
The legislature decided that we weren't going to allow any new corporations whatsoever. And that is the protection against those issues. For various reasons, they grandfathered the pre-existing statutes, and it goes back to when soldiers were returning from the war and they wanted, or going to war, and they wanted to make sure that they could continue those corporations or businesses that were in existence prior to going to war. So, but they allowed those to be grandfathered in when they returned from, I think it was World War II, to make sure that they could continue to operate. But they said no more. We're going to require that everyone who opens a new establishment must be educated and trained, and it must be owned wholly by licensees. Because as the Court of Appeals ruled, and as the Board of Morticians has maintained for many years, and the legislature, that's the best way to hold owners accountable, is to make sure that they're licensed.
Okay, so I think the biggest problem that I have with this grandfathering is it's from 1945, when people who looked like me couldn't own a business. Women couldn't necessarily own businesses, and our laws that were perpetuated by this state were grossly discriminatory, not only in Maryland, but all across the country. So we've excluded a whole class of people, either based on their gender or skin color, from ever being included in these kind of businesses. So that's a problem, and I think that's why we're looking at this. And then finally, I'll end with this question. We have other for-profit businesses that are required to compete with nonprofit entities. For example, law firms. Law firms are for-profit entities where you are required to be a member of the bar in order to own that law firm. Would you agree?
Yes.
Okay. And we also have nonprofit firms, Maryland Legal Aid, Community Legal Services, that provide pro bono legal services to indigent populations. Would you not agree?
Yes.
And would you agree that though the creation of those nonprofit firms has not had any chilling effect on the profitability of for-profit law firms?
I wouldn't have data on that, so I don't know.
Okay, thank you. I have no further questions.
Okay, but may I respond to her question?
No, we're running.
Okay.
We have a lot of bill hearings, and we have to take a break at 3 because some of you have testimony in rules, okay? So can we keep it short? All right, Delia Riley?
Thank you, Madam Chair. Yes, reading through some of the testimony we have. So currently, the private businesses that are currently funeral homes, their license falls under the health occupations article because it deals with the human bodies. So under this bill, I didn't see anything in there. I could have just overlooked it. Under this bill, are the nonprofits going to be part of the health occupations article?
That is my understanding.
Okay, thank you.
Thank you. I think that is it for questions from this panel. Is there someone that did not get called that was unfavorable? I did call you earlier and you were not here. Anyone? All right, so we have, thank you so much for being with us. We do have a favorable that is virtual, and that's the last witness for this bill hearing Will you please bring that person up? Thank you.
Thank you.
And while this person comes up, we do have rules of three. I know that about 3 of you have bill hearings and rules where you have to go testify. Some of us are on rules. So we're going to take a short break at 3 o'clock, like 2 minutes to 3, and then come right back and get started with those that we have, because we still have a lot on the agenda, okay? Remember that these bills, some of them will go to subcommittee, all right? Some of them have a big fiscal note, all right? Some of them may need a little bit more work, okay? All right. So, let's see. Do we have the virtual witness person? Good afternoon, ma'am. Will you be so kind and get started? Can you give us your testimony? This is Zainab Chaudhry. Will you please give us your testimony from CARE? Ms. Chaudhry, will you please unmute yourself and give us your testimony? We would love to hear from you. She's not. Hello? All right, well, I'm so sorry. We did give you some time. We do have a lot of work ahead of us. I know you were the last witness. I have you recorded as favorable. Are you there? Can you hear me? Can you speak? Hello?
Hello, yes. Good afternoon, Madam Chair.
Good afternoon. Can you get started?
Yes, absolutely. Thank you so
you.
much, Chair Peña-Melnick, committee members. I will be very brief. I know that you have a long day ahead of you. I just wanted to have the opportunity to express my organization, the Council on American Islamic Relations, strong support for this legislation. This bill presents a critical opportunity to lower funeral costs and ensure equitable access to dignified, affordable end-of-life services, particularly for diverse faith-based communities across our state. Under the current framework, for-profit funeral homes dominate the industry, often resulting in high costs that place a significant financial strain on families. The inclusion of not-for-profit funeral establishments as proposed in this bill will introduce a much-needed alternative that can help reduce expenses. Nonprofit funeral homes are mission-driven rather than profit-driven, enabling them to provide services at more affordable rates. For Maryland's Muslim communities, which adhere to specific burial rites, including timely burials and the avoidance of cremation, cost-effective funeral services are crucial. This bill would allow mosques and other community-based organizations to establish funeral services that align with religious and cultural needs, while also easing the financial burdens on grieving families. This bill would mean lower costs, expanding access, and all while ensuring ethical practices that would encourage community-focused funeral services that provide and prioritize dignity and affordability over financial gain. In my written testimony, I have more context related to why we support this bill. What I can just share with you is based on conversations with mosque leaders across the state. This is a bill that would greatly help the mosques in our communities to be able to facilitate funeral services for community members who otherwise in many cases cannot afford funerals or have to rely on charitable donations or other sorts of funding to help them cover the costs. And this was expand mosques and churches and synagogues and other houses of worship's ability to be able to serve a very critical function within our communities, especially in this time where grieving families have so many other issues that they have to be concerned about. Financial concerns should not be one of them. So we urge a favorable report, and I'm happy to answer any questions.
Thank you, and thank you very much for being with us. I'm glad I was persistent. Are there any questions? All right, seeing none, thank you so much for being with us. We really appreciate you. This actually concludes the bill hearing on House Bill 1051. Next, we have Delegate Kaiser, House Bill 1292, Health Insurance Provider Directory Require Updates. I have Delegate Kaiser and I have Robin Elliott. Robin Elliott, are you here?
Madam Chair, can you bring up Jared Schreiber? He's speaking on my behalf.
Yes, will you be so kind and bring that person up, please? Thank you. And Jamie Sexton, if you're here, can you join the delegate? And Robin, why don't you both join her? She will love the company. Sorry, Matt Chantillano, you're not a friend today. Okay. Good afternoon, delegate. Go ahead.
Thank you, Madam Chair. I'm going to defer in one moment to my intern, Jared Schreiber. He's a sophomore public policy major at the University of Maryland, and he's done the work on this bill. Like many of you, the Thursday and Friday bill hearings were delayed until today. He would have been here in person on Thursday, but instead virtually from College Park today. He was one of my top students in my ethics class last semester, the sharpest, the most intellectual of my students. So I won the best two of my students to be my interns for this session. So I'm going to turn things over to Jared, and then I'll answer questions, though I'll probably also rely on the people to my side to answer some questions. So Jared, go ahead.
When our interns have an opportunity to present, I think that is really such an amazing experience. So good afternoon. How are you?
I'm doing well. Thank you very much, Madam Chair. And thank you very much, Delegate Kaiser, for that very kind introduction. Madam Chair Pena-Melnick and distinguished members of the Health and Government Operations Committee, it is my pleasure to come before you and offer testimony in favor of House Bill 1292 and then address directory inaccuracies. And as such, we've amended the bill to include the recommendations. First, I'd like to share some details about what HB 1292 does. To better align Maryland code with federal law, this bill makes certain vocabulary changes, requires insurers to update and outline directories within 2 rather than 15 working days of receiving this updated information from the providers, and it requires printed directories to include a statement listing the date of the publication and a notice to refer to online directories for more updated information. Additionally, this bill adds the requirement for carriers to include a statement reminding individuals to confirm with the provider before seeking treatment that they participate in their specific health plan and not just the insurance carrier overall. Finally, this bill requires the agency to notify this committee of any regulation changes related to directories made during the interim. So why does this matter? Delegates, as we are in the digital age, it is no surprise that Americans are becoming increasingly reliant on the internet to find their in-network clinicians and physicians, with the most common digital avenue being these provider directories. In short, a provider directory is a database that is published on the website of these insurance companies that lists all of the in-network providers located within the geographic region of a given patient. As noted in Delegate Kaiser's written testimony, approximately 46% of Americans rely on these provider directories. And as such, it should be a given that these directories are accurate. However, it is unfortunate that these directories are often very inaccurate, and you can see the statistics in her written testimony. What I would like to highlight, though, is what we have found is that the accuracy of behavioral health specialists are disproportionately inaccurate given the tendency of these providers to switch their insurance contracts more frequently than other specialties. And what's so important to recognize is that these inaccuracies cause real problems for patients. According to the National Institute of Health, these inaccuracies have resulted in patients being twice as likely to be treated by an out-of-network provider and 4 times more likely to receive a surprise bill. And although state and federal measures have been proposed and enacted, including the 2021 No Surprises Act, they have honestly been relatively ineffective at addressing these inaccuracies. 2024 data from published in the American Journal of Managed Care indicates that provider directories remain inaccurate for an average about 450 days longer than the 90 days that are permitted under federal statute and the 15 days permitted under Maryland law. Additionally, some research published by the University of Colorado School of Medicine in 2023 suggests that 81% of physician data found in the directories of 5 of the nation's most popular insurers, that be Aetna, Elevance, Cigna, Humana, and United Healthcare, still have inaccuracies despite the 2021 federal legislation and Maryland law. For all these reasons, individuals across the nation have been forced to resort to individual litigation to force providers to update these directories. These ghost network lawsuits are not only costly to individual plaintiffs, but also take a while before dispositive judgment can be reached. If you have any questions about these lawsuits, I am happy to provide more information at your request. But overall, we look forward to continue working with MIA on this issue, and I urge a favorable report on House Bill 1292. Thank you very much.
Excellent, excellent testimony, very impressive. Who will go next?
I'm happy to start us off, Madam Chair.
Thank you.
Thank you for the time. I'm a little intimidated to follow Mr. Schreiber, who did a phenomenal job explaining this bill, probably more eloquently than I could do myself.
Try to follow that.
I know. It's tough. For the record, my name is Jamie Sexton. I'm with the Maryland Insurance Administration. We appreciate the opportunity to share our support for this bill. I think you've heard us say time and time again this session that the MIA is primarily a consumer protection agency. And that's exactly what this bill is doing, is providing an important consumer protection to Maryland in our state. It will provide consumers with more accurate and timely information when searching for participating providers in their network. The ability to access reliable in-network information is paramount for consumers in our state to receive timely care, especially in cases of sudden injuries or illnesses with quickly emerging symptoms. By ensuring that patients have access to an accurate list of in-network providers, this bill will help them avoid the burden of unexpected out-of-network costs, which I'm sure you've heard much about this session and in previous sessions. In doing so, the bill strengthens network adequacy protections in our state, aligning with the goals of the ACA. We understand the committee's interest in the current accuracy of provider directories and the frequency of reviews. As you may be aware, the MIA is currently examining provider network directory functions as part of our reporting requirements under MAPIA, specifically with regard to Senate Bill 334, House Bill 455 from the 2020 legislative session. As part of that mandate, we're required to submit an NQTL report to the MGA by December 1st of this year. And provider network directories are one of the selected areas of focus for that reporting period. We think that this bill will provide a phenomenal base as far as consumer protections in that process that we can build on once we know more from this reporting period. The analysis of that report is extensive and detailed. It's relying on data provided by carriers, but we want to assure you that we are very committed to improving provider directory accuracy. We look forward to continuing a dialogue with the sponsor and stakeholders to refining amendments to further clarify the bill's intent of strengthening provider directory accuracy requirements and network adequacy protections in Maryland. Thank you for the time.
Excellent, thank you. Next, please.
Okay. Good afternoon, Robin Elliott. I'm here today on behalf of the Maryland Community Health System, which is a network of federally qualified health centers. Very much in support of this legislation and happy to work with the sponsors and stakeholders on amendments. This part of the law, by and large, was framed prior to a lot of the automation that we now have in our system. So we think provider directory information should be looked at and sped up as this bill proposes to do. As you've heard, it helps empower consumers find the care that they need. It's also really important for providers like federally qualified health centers or care coordinators who are trying to find specialists who are in network for their patients. When these directories aren't updated, they spend a lot of time reaching out and trying to figure out who their patient can see and not risk the financial liability. So for that reason, we are strongly in support. Thank you so much.
Thank you, and thank you both, Jamie and Robin, for working with the committee on this issue and many of the other ones. Okay, we appreciate your time and efforts. I'm going to open it up for questions now. Are there questions for the sponsor and her panelists, including Jared? He'll take all the questions. All right, seeing none, thank you so much. We appreciate you. Thank you, Jared. Good work. We do have an unfavorable, someone who doesn't have many friends today. Matthew Chantilano, the League of Life and Health Insurance.
Thank you, Delegate Woods.
I'm just kidding, Matt.
I'll do my best to make friends. Matt Celentano here today on behalf of the League of Life and Health Insurers in opposition to House Bill 1292 as introduced. We understand the intent of the legislation, and we're certainly happy to work on it. It's been relayed to me that there are amendments. We'd be happy to look at them and see if we can get to a place of understanding. But the bill as introduced requires the carriers verify the information of every provider within the network every 90 days. This is an incredible lift, and it will set up the carriers to fail. We have a really hard time getting providers to respond to any outreach as it is, and the legislation does not account for the robust outreach that's already happening from carriers. It's not uncommon for a provider to be contacted between 10 to 15 times before we ever get a response. To do that for thousands of providers, and I looked yesterday, there are over 15,000 providers in Maryland. We have to do that every 3 months. This is just sort of an unrealistic ask. There are 6 carriers too, and many of those providers are dealing and contracted with all 6 carriers. So that's 15,000 providers times 6 carriers times 15 contacts. That's 1.35 million contacts every 3 months. We had a very similar conversation to this bill, or this committee, about this prior to the pandemic in 2019, and there was ongoing discussions with the MIA about how we could approve upon it. And we actually respectfully requested that the boards be involved in this. If there is no skin in the game from the provider side to require them to respond to the carriers about updating this information, we are set up to fail. We want to do this, but we need the other side of the equation to be involved in this. And if we have them involved, we can make serious progress. We're not opposed to the intent of this bill at all. We just wanted to highlight the challenge of reaching out to this many people, and we urge an unfavorable report to the bill that is introduced, but we are certainly willing to work on it. Thank you very much.
Thank you. Are there any questions? Delegate Bagno.
Madam Chair, and just a quick question, because I do take your point. Is it possible to limit the number of the amount of outreach by looking at existing claims and making the assumption that they are operating in network if they're already making claims?
That's a great question. Thank you, Delegate Bagnall. I think that the carriers are probably focusing on the providers that are already submitting claims, so we know that they're active, but it still might take 10 to 15 times, even if they are active, to get them to respond to us about updating contact information. And now we're going to have to do that every 3 months and verify each time. I'm not saying that there shouldn't be a back and forth. It would be great to do this through a portal, through electronic means, but we have to have them required to respond to us when we outreach over and over and over.
Thank you. Thank you.
Since I'm pretty sure that this is already being done, somewhere, right? We do have 50 states, and you guys do business in many other states. So if I can ask you to work with the sponsor and see if we can find a compromise.
More than happy to, Madam Chair, and we'd like to work with the MIA as well.
Yeah, because this is important, and
Correct.
we hear from our constituents all the time about this
Yes.
issue. So we're grateful if you could work with us, okay?
Sure.
This actually concludes the bill hearing on House Bill 1292. Next, we have Delegate Kerr, 1027. Will you be so kind, please, and give us your testimony? And you have Fatima Wadhi, who's here. Oh, you don't have a panel? Okay. I didn't want you to be lonely, Delegate Kerr. Although sometimes being lonely is better than bad company, right? That's true. Very true. Good afternoon, Delegate.
Good afternoon, Madam Chair.
And if you could put the microphone closer to you, that would be wonderful.
Okay.
And this is House Bill 1027, work group to study implementation of a statewide 311 non-emergency telephone system.
That's correct. Well, good afternoon again. I'm Delegate Ken Kerr, here to present House Bill 1027, work group to study implementation of a statewide 311 non-emergency telephone system. And this bill is a follow-up to last year's HB 1141 that this committee and the House passed that established a work group to explore using artificial intelligence to develop a 311 non-emergency system. Currently, Baltimore City, Prince George's County, and St. Mary's have a 311 system that they're very happy with, and it's functioning well, helping people navigate government bureaucracy and government websites to find answers to non-emergency questions. You know, a lot of times people have trouble navigating those websites or the bureaucracy, and they get frustrated and they end up calling 911. So in Maryland, about 37% of all calls to 911 are non-emergencies. That's more than 1 out of every 3 calls. You know, when's recycling day? That Monday was a holiday. Is the library closed on Sunday? A tree fell across my street. I can't get to work. There's an injured deer in my backyard. Those are important things, but they're not emergencies. So we've already passed legislation to make it easy to transfer 911 calls to 988, but a similar process doesn't exist for 311. So in the interim, DoIT has done a great job in leading the work group we created last year, engaging a company called the Gardner Group consulting firm to do the research on artificial intelligence and 311. And this bill, this year's bill, will allow us to continue the progress that we've made and implement the findings of the DoIT study and the Gardner Group. And that study I referred to will be available shortly. There's an amendment that removes statewide because of fiscal concerns. One of the early recommendations of the Gardner's Group report was that we should start smaller, perhaps with a pilot. So again, the purpose of this bill and last year's legislation is to lighten the workload on 911, and I request a favorable report.
This is your microphone is not working. Please check your connection or use. You're working on that? Yeah. Okay.
Gotta do it all over again.
Good afternoon, Madam Chair, members of the committee.
Okay, so let's open it up for questions. Are there any questions for the delegate? All right, seeing none, thank you, delegate. We have, while they fix it, how about Fatima Wadhi? Are you here? From Advanced Technology Acceleration. You can get started, sir.
Yes, thank you. My name is Hussain Wahid. I'm conducting the transformative economic efficiency with the help of advanced technology acceleration.
Can you try to use the other microphone, see if that other one works? Although we could. I think our streaming may be, what, is it working?
I think our streaming is
working now. It's not working?
It's frozen. It's okay. You know what? We have to wait. Remember when I said you weren't listening? That part of my opening that says sometimes we have streaming issues. It doesn't happen often, but it happens. So let's be patient and just wait, okay?
By the way, I was not here for a specific reason. On Sunday, I was looking up the bills I have to testify on, and the whole website had disappeared. And I did not know whether I would be able to testify or not. This morning at about 10:30, I got a confirmation that yes.
It's working. Let's see, 1 second, please. Delegate Kerr, you look good there. This is just an opportunity to take a deep breath. I think we're back, right? All right, so go ahead, sir.
Yes, thank you. As I stated, my name is Hussain Wahid, and I'm developing transformative efficiency applications in the state of Maryland with the help of advanced technology acceleration, also in collaboration with University of Maryland, College Park, distinguished Professor Ashwini Gupta, and the Advanced Life Cycling Engineering Center methodologies that is currently ranked as #1 in the country. These methodologies and algorithms have produced results very recently during the pandemic and the epidemic of isolation and loneliness, specifically through an initiative lasting about 2-3 months. The initiative resulted in the delivery of about $500 million economic efficiency without any additional costs or time consumption, because they've been verified and also they became national standards. Going along with this result, we were trying to utilize these examples through the bill HB 999 for best practices and innovation in the state of Maryland, but the work group did not meet. And as a result, we have to continue the effort to deliver. No, I'm testifying for the 311 bill because it reduces the risk of economic efficiency through health impacts, meaning people continue to suffer without getting some kind of help, and that relates to the advanced technology applications. As I will explain, the algorithms also help with AI significantly, and they also help with continuous human learning and cybersecurity and machine learning. So all comes together, and that is why I was pointing out that they do not cost anything.
Thank you so much. Any questions for this witness? Seeing none, thank you very much.
Thank you.
Appreciate you. This actually concludes the bill hearing on House Bill 1027. So this is where we are right now at 2:55. There's 3 members of this committee. Rules starts at 3 p.m., so in 4 minutes. There are 3 members of this committee that need to go to rules to give testimony because they have bills. There's about 6 members that they are on the rule committee. So we are going to take a break now at 3. We will return at 3:35, God willing. This is the order when we return that were taken. And if I may ask the committee members, there's food back there, a lot of food. You could take a break, those of you that do not have to go to rules, and have something to eat. And please be here on time. If some of us that are on rules are not able to make it, I'm going to have someone start the hearings at 3:35, okay? This is the order when we return. House Bill 1120, Delegate Bogle. House Bill 1301, Delegate Rosenberg. House Bill 1143, Delegate Bagnall. House Bill 333, Delegate Kerr. House Bill 1315, Delegate Gazzoni. House Bill 1199, Delegate Hill. House Bill 1298, Delegate Martinez. House Bill 1481, Delegate Hill. House Bill 1208, Delegate Alston, and House Bill 1449. That is the order for now, okay? So again, 3:35, we start on time. If we're not here, some of us, the hearings will start with someone that is already designated to take over, okay? And those of you that are watching, take a break, get a snack, or stretch. And thank you for your patience. We appreciate you. All right, take us down.
We will resume bill hearings. As you can see, I'm not Jocelyn Pena-Melnick, but I do play her on TV. We will resume bill hearings with Bill 1120. That's Delegate Vogel. I think Mateo is, oh, hi.
Good afternoon, Chair Kerr.
Good afternoon.
Thank you, and esteemed members of the Health and Government Operations Committee. For the record, my name is Lilia Rose, and I'm the Legislative Assistant to Delegate Vogel. I will be presenting on House Bill 1120, the Maryland Business Express Act. According to the Maryland Chamber of Commerce, Maryland RAC's 40th percentage change in new business applications from December 2022 to December 2023. Inefficiencies in business licensing and permitting negatively impacts Maryland's business climate. House Bill 1120 will create a centralized portal where a new business can go to find all of the licenses, forms, certificates, permits, applications, and registrations needed to start and assist their business in Maryland. Under House Bill 1120, the website businessexpress.maryland.gov would include not only state requirements, but also county and municipal requirements for starting a business. A study conducted by the National Bureau of Economic Research found that reducing bureaucratic delays by even 1 month leads to an 8% increase in new business registrations. There is a sponsor amendment written alongside the Maryland Department of Information Technology, and this will lower the fiscal note significantly by clarifying the focus of the bill and changing the frequency of updates from 2 months to 12 months. I urge the committee to give a favorable report to House Bill 1120, and thank you.
And thank you. Do we have questions for the bill sponsor? Can you tell me again what the action you took to address the fiscal note was?
Of course. So we worked alongside the Maryland Department of Information Technology. It lowers the fiscal note by clarifying the focus of the bill to the Maryland Business Express Act website and changing the frequency of updates from 2 months to 12 months. And we'd also be happy to reach out with more information on that to clarify further.
Yeah, the fiscal note, as I'm sure you're aware, says likely by hundreds of millions of dollars over multiple years.
Yes.
So do you think the action you took made a big dent in that?
Hopefully so, Chairman.
Okay.
Yes.
All right. I didn't see it.
No, ask them.
Can you talk with the Department of Information Technology and see what their analysis is of your amendment and if they think it will move the needle on the...
Of course, we'd be happy to do that and get the information to you.
Okay, thank you.
Thank you so much.
And also submit have we received your amendment?
I believe so, but if not, we'd be super happy to
Okay.
send it to you.
Yeah, thank you. We'll
Okay.
need that as well.
Sure thing. Thank you.
Thank you. We have a favorable with amendment witness, Fatima Wahid. Welcome, Dr. Wahid.
Thank you.
You have
My name
2
is-
minutes. Please give us your testimony.
Yes, Hussein Wahid, and I'm with the Advanced Technology Acceleration Initiative, University of Maryland. Small businesses provide largest economic efficiency with respect to advanced technologies as well. And we have known this for a long time, and that is the reason the risk factors to small businesses take precedence in the design of the implementation specifications and standards. It has proven results, and it involves small businesses. And as I had mentioned earlier, over the next 5 years, the total economic efficiency as projected at the lowest level of assumption for economic advantage is close to $500 million from just one initiative that lasted 2 to 3 months. And It involved no expenditures, no cost. It was done entirely on a voluntary basis and can be repeated, reproduced, and is transparent. And these methodologies are consistent with the ones that have been applied by distinguished Professor Dr. Ashwani Gupta, and also the methodologies utilized and developed and in continuous review process by the Center for Advanced Life Cycle Engineering, University of Maryland, College Park. They are in place of what was supposed to have been done under the bill HB 999 from last year. Recently, we confirmed through survey of around 100,000 operations that, in fact, the validity and the value continues to grow. They are useful for human learning, machine learning, artificial intelligence, cybersecurity, and deliver transformative economic efficiency.
Thank you. Questions for this witness? Seeing no questions, Dr. Waheed, thank you for your testimony.
Thank you.
And we have an unfavorable witness, Iris Agbebulam. Welcome.
Hello. Good afternoon, members of the committee. My name is Iris Ibebulam, and I'm a Senior Associate of Advocacy and Public Affairs at the Maryland Municipal League. The League was very much opposed to this bill when it was first introduced, but we're hoping that our concerns will be addressed through sponsor amendments, which we appreciate. I do want to say the Maryland Municipal League consists of 161 diverse and hardworking communities, municipalities, towns, cities, and villages. The initial bill was not only costly regarding municipal finances, but it also would have cost a lot of valuable time and limited resources of these municipalities. I also want to highlight that based on an internal poll, about a third of our member municipalities in the state have less than 5 paid full-time employees, and the bill initially required uploads and updates of documents into a portal every 2 months, which would have been very time and resource heavy. The updated bill language does a great job in spacing out the documents uploads from every 2 months to every year, which is very helpful. I will say that the initial fiscal note highlighted local government expenditures increasing significantly because of a compatibility issue between the local gov systems and One Stop. And we were just wondering if the Business Express website reduces those costs. We also know that the Department of Information Technology mentioned charging municipal governments to include their documents on the One Stop portal, and we wanted to know if those charges will continue on the Business Express portal. We're extremely happy to continue conversations with the bill sponsor, and we appreciate the collaboration regarding this bill. Thank you.
Do we have questions for this witness? Seeing none, thank you for your testimony. There are no more witnesses on this bill, so this concludes the bill hearing for House Bill 1120. Delegate Rosenberg, House Bill 1301.
And I think my witnesses can come up with me.
Michael Huber, Scott Klein, Mary Miller, Bernadette Johnson, Julie Quinn.
Right here. Fine. Right up front. Thank you.
And Kristen Bryce.
The content of this bill will be familiar to the committee because it is the second year that I have introduced legislation to address the issue of prior authorizations for children admitted to the Mount Washington Pediatric Hospital. But I say that the next sentence is not because nothing has been accomplished since last year. Significant progress has been made, but somewhat more needs to be made to solve the problem, and that is what House Bill 1301 seeks to do. and I will defer to the experts from the hospital to speak to the problem and how this legislation, why this legislation is necessary.
Okay. Mr. Chair, members of the committee, I'm Scott Klein, CEO of Mount Washington Pediatric Hospital. Mount Washington is a unique hospital, a specialty children's hospital. We transition children from the ICU to home through intensive rehabilitation and parent training in a lower cost environment. The patients we serve have medical and social complexity. 75% are on Medicaid and impacted by social determinants of health. We admit patients needing complex discharge planning, better to tackle complex discharges in a lower cost environment than in the ICU. We are co-owned by the University of Maryland Medical System and Johns Hopkins Medicine. We partner with pediatric providers throughout Maryland to ensure children receive the right care in the right place at the right time. A properly functioning system of care ensures that we provide valuable health care in the most cost-effective way. Maryland's system of care encourages movement of patients from high-cost to lower-cost environments, and delays add waste. Prior authorization to transfer patients to Mount Washington is an example where waste is added to the system. Our experience has shown that waiving prior authorization allows for rapid movement of patients to the right environment with no downside. The patient does not benefit from prior authorization, nor does the provider. Since we've had no retroactive denials from waived prior authorizations, it appears the prior authorization process does not benefit the payers either. What the prior authorization process does do is delay transfer. Arranging a bed, coordinating ambulance transportation, and ensuring parents take off work requires knowing when authorization will be in place. This means scheduling days ahead in hopes authorization will go through. For the payers where prior authorization is not required, the teams can arrange transfer once the patient is ready. Any days lost are wasted for the patient and the system. For 450 plus admissions, that is a lot of waste. Given the difficulty with hospital throughput and emergency room delays, this is an important opportunity to ensure an acute pediatric bed is available for those who desperately need one. As a pediatrician who's worked with medically fragile children my entire career, I know the value of our patients reaching us quickly to take the next steps in their journey home. For these reasons, I respectfully request a favorable committee report. Two of our clinical staff are here to tell you more about what we do and why it matters.
Mr. Chair, members of the committee, my name is Mary Miller, and I serve as Chief Financial Officer at Mount Washington Pediatric Hospital. I'm also here requesting a favorable report on House Bill 1301. We appreciate the work done by the committee and the state last year to address issues we face, mostly in moving patients out of the hospital towards a safe discharge. Despite progress, there are still problems to resolve. But today, we come to you about the barriers to getting children into our hospital and about how reducing these barriers can be a part of the state's efforts to address pediatric overstays. This bill picks up one element of last year's bill. It prohibits the use, the requirement of prior authorization for transfers into Mount Washington. These delays happen because we are waiting for insurance companies to issue a prior authorization. Without this authorization, we risk receiving no payment, zero payment for the entire inpatient stay. We have met with the MCO and commercial payers to ask them to voluntarily end this requirement. 5 of the state's 9 MCOs have done so, none of the commercial payers have. During COVID, all MCO prior authorization requirements were waived. Every single one of the admissions that were accomplished without prior auth were later confirmed to be appropriate. Not a single one was later denied. This system can work. We know that the acute care hospitals struggle with pediatric overstays. Some unnecessary overstays can be reduced if patients move from acute care to our pediatric specialty care without delays caused by unneeded insurance company paperwork. Thank you for your attention to this matter and for your support of this vulnerable population of Maryland's children.
And thank you for your testimony.
Madam Chair and members of the committee, my name is Dr. Bernadette Crowder, and I'm a neonatologist at Mount Washington Pediatric Hospital, requesting a favorable report on HB 1301. Speaking from the perspective of the baby, imagine the busy ICU, monitors beeping, alarms sounding, people racing to the patient in distress, new babies arriving unexpectedly. Stat procedures, all hands on deck. In the beginning, I was that patient. I was born at 24 weeks and weighed 500 grams, the size of a Coke bottle. I needed help breathing. My heartbeat was irregular. My temperature was unstable. My skin could not protect me. I lived in a plastic box. But now I'm better. I'm working on feeding and growing. These things take time, but now I'm mostly alone. People come when they are obligated, so I lay in my room and wait for a visitor, wait for a therapist, but I'm ready to do more. I'm ready to prepare for life outside of this place. In the ICU, the squeaky wheel gets the oil, but at Mount Washington Pediatric Hospital, all of the kids get the attention they need. It's the bridge to home. There, I am a priority. Nurses take care of me, and specialists come to make sure that I practice eating by mouth. I have appropriate developmental stimulation. They read to me. We practice tummy time. My parents learn how to care for me. When I'm old enough, they'll take me to the playroom where I have additional stimulations. Lights, sounds, textures. I can hold a rattle and maybe shake it. I can lay on the facility dog. I'm treated like a baby. And if I'm sick, they can take care of me. From my perspective as a doctor, Mount Washington Pediatric Hospital is the ideal facility for children to transition from ICU care to home. We provide medical support, education to families, and we empower parents who are bringing home children who may have had significant illness or injury. Wasted days in the ICU are no longer needed, and they delay and impede efficient transition to home. The same is true for the child whose life was interrupted by a car crash, the house fire, the near drowning, the gunshot, the sudden cardiac collapse while playing varsity sports. They are now on the mend and ready for re-entry into the world.
Thank you, Dr. Johnson.
Mr. Chair, members of the committee, my name is Julie Quinn. I'm the Director of Rehabilitation at Mount Washington Pediatric Hospital, requesting a favorable report on House Bill 1301. This bill would remove barriers to transferring children to Mount Washington Pediatric Hospital where they can receive the care they need. The emphasis of medical care in an acute care hospital such as Johns Hopkins Hospital or the University of Maryland Medical Center is to save the child's life. When a child of any age comes to Mount Washington Pediatric Hospital, our job is to teach children how to live their life to its fullest after an illness or accident. When very young infants come to Mount Washington, we provide developmentally appropriate supports for feeding, moving, socializing, and playing. We work with older children on accessing their home, school, community, and recreation. At Mount Washington, we incorporate our patients, their siblings, and family members into normalized experiences. We take children to playrooms, take them outside and into the community to simulate real-life experiences. For a teenager who sustained a spinal cord injury from a gunshot wound, life looks and will feel very different when they leave the hospital. Prior to injury, this teen was playing basketball for his high school, preparing for prom and for college. Our team worked with the patient on increasing independence, cooking activities, and involvement in peer support groups. This patient is now living at home and states, at Mount Washington, I figured out new ways of doing things. I feel empowered to show the world that people with disabilities can live and thrive. The longer a child is hospitalized without access to opportunities for play and self-expression, the more likely they are to have later medical, social, and developmental problems. If we give children healthy experiences and give parents tools to help children cope, it equates to children who are well-adjusted, have fewer rehospitalizations, and less need for medical intervention as they age.
And thank you. Delegate Rosenberg, are Michael Huber and Kristen Bryce part of your sponsor panel, or would you rather take questions and then have them be a second panel?
Michael wants to come on up, so fine. I should also add that there is an amendment that Mr. Johansson has proposed, which is acceptable to us.
Do you know if we have that yet?
I doubt that you do, my fault. I will take care of that.
You know where it goes.
Yes, sir. Yes, ma'am.
Mr. Chair, members of the committee, my name is Michael Huber, Director of Maryland Government Affairs at Johns Hopkins University of Medicine. Here today really to bring to your attention written testimony submitted by David Stockwell, Chief Medical Officer at Johns Hopkins Children's Center. Dr. Stockwell was here on the chair's priority bill, HB 962, which relates to pediatric overstays. And you heard him talk about a few of the challenges that the Children's Center faces. So we wanted to be sure to connect the dots to this issue as well, to the extent that we have children who are awaiting a more appropriate and more supportive level of care, and we have a proposal for how to smooth the path to allow those children to receive that care. These issues are very much connected in that sense. So again, would draw that written testimony to your attention. Thank you for your time, and let you know that I'm here to answer any questions that you might have.
Thank you. And last witness, Kristen Bryce.
Mr. Chair, if you have my written testimony in light of the committee's agenda, I'll defer to my colleagues.
Okay, thank you for that. Opening up for questions for the sponsor panel. Delegate Woods, then Delegate Kipke.
Thank you, Mr. Chair. Thank you, Delegate Rosenberg, for this extremely important legislation. As you know, I'm extremely interested in how we resolve pediatric overstays. With that, I have two questions. One being, is it just the prior authorizations that are the challenge, or are there always the necessary beds available for the children? So I support completely getting rid of the prior authorizations, but I just wanted to get some clarity as to whether there is any concern with being able to meet the requirements for the children who are ready to be discharged from ICU.
So I could answer that. Yes, post-COVID, certainly there was concerns about having enough staff to be able to take care of the patients effectively, but Mount Washington has been able to address that situation, and bed availability is rarely the problem. Okay. The prior authorization process is one where we could have a bed 2 days earlier often, but then we're waiting on the prior authorization and the bed is staying open.
Okay, thank you. Mr. Chair.
Did you have a follow-up?
Yes, sir. My second question, I'm not sure who can answer this, but are there any particular time frames laid out for this transition once the child leaves the ICU and comes to Mount Washington?
Could you clarify what you mean by time? Like how long is it
correct.
Normal?
Do you have an idea of how long you expect, I guess, for lack of better words, the average child to stay in your program?
So our average length of stay at Mount Washington is about 30 days. Okay. That's all comers. Yes. So some patients may be there for a week, some patients may be there for a month or longer. And that's why it's really important to get started as quickly as possible.
Right. But the goal is like 30 days.
Yes.
At this point.
Yes.
Thank you so much. Thank you, Mr. Chair.
Welcome, Delegate. Delegate Kipke.
Thank you, Mr. Chairman. I want to thank you all for the good work that you're doing to look out for these young people. And it's critically important that we improve our wait times through our emergency rooms, and certainly this is a critical component of it. I want to give you the opportunity to expand upon one aspect of the problem. We have a letter in the committee file dated January 7th, 2025, and I want to read just 2 lines from it, then ask for whoever's the right person to answer to help educate the committee on this problem. On the summary section on page 2, it reads, the appeal and administrative day rules as currently applied leave MWPH at significant risk for non-payment for care for medically fragile and socially complicated children with no other place to go. The binary choice puts the hospital in a position of rolling the dice when it decides whether it fights on behalf of these children for medically appropriate care or being paid for potentially weeks or months of continuing care until a safe discharge can be arranged. To whoever is best suited to help us understand the problem here. Thank you.
Sure, thank you. As you may recall, last year's bill addressed 3 issues. It was payment for administrative days when there was no medical necessity, the right to appeal when our providers didn't agree with the state that there was no medical necessity, and then there was this prior authorization issue. So if you may, I jotted down some notes and I'll read this to answer your question. So there was progress on both issues. We appreciate the work of the committee and the state, but these significant problems remain. The state increased our daily payment rate for administrative days, and that works when we all agree that there's no medical necessity but nowhere else for the child to go yet. But sometimes our doctors disagree. And they believe and want to present evidence to the state that the child still needs our care. But if we do that, if we even request a peer-to-peer conversation with the state doctors, we lose our right to be paid for these administrative days. So if we do that appeal and we lose, we are paid nothing for what could be months of care until there's a safe discharge. So similarly, the state now says we have the right to appeal for payment on behalf of the hospital, but if we exercise this right, we won't be paid for the administrative days if we lose. So the risk makes the right a questionable and risky one. And we're now facing an additional problem since we started using these administrative day rules, where we're paid nothing for taking a child back after they've been with us but had a serious enough illness that they needed to go back to acute care for more than 3 days. Just a brief example, we have a toddler who spent the first 2 years of his life in the NICU. Then he transferred to Mount Washington with approval for medical necessity. But now the state says he no longer needs our care, but they have nowhere else for him to be. He recently became sick enough that he needed to go back to Hopkins for longer than 3 days, and Hopkins wanted us to take him back. They needed the bed, and we all agreed that we're the best place for him medically and developmentally. But in taking him back, we will get zero payment because we can't even get the administrative day rates if the child returns to us without that medical necessity on the date of readmission. And just on a personal note, I'm not a clinical person, but I happened to be on the patient unit last week when the nurses were talking about this child's return and how they were excited to see him and happy to get him back in their care. And that's what Mount Washington is like. These children should come back to us, but without any payment at all, it becomes very hard to meet these obligations.
Seeing no more questions, thank you, Delegate Rosenberg, and thank you to your panel for being with us today. That will conclude the hearing on House Bill 1301.
Thank you. Sure.
You did so well. Thank you. Thank you. And this is how today is going to be, I believe, the rest of the week. So you may all have terms. Let's see. Okay. So which one are we on to next? 1143. So House Bill 1143, I believe that's Delegate Bagnall, which is dental services, dental hygienists in schools and school-based health centers in the Maryland Collaborative to improve children's oral health through school-based programs. House Bill 1143. Will you be so kind and bring your panel, Delegate Bagnall? I believe you have Irene Hansen, Lise Elliott, Robin Elliott, right? Are they with you? And anyone else? They can bring a chair and you can get started. Thank you.
Thank you. Thank you.
You're welcome.
Good afternoon, Madam Chair, Madam Vice Chair virtually, and members of the Health and Government Operations Committee. For the record, I'm Delegate Heather Bagnall, District 33C, Anne Arundel County, here on behalf of House Bill 1143, dental hygienists in school and school-based health centers and the Maryland Collaborative to improve children's oral health through school-based programs. You have my written testimony, much of which is in that extraordinarily long title, so I will summarize. I don't have to convince this committee of the importance of oral health care and early intervention, or the critical need we continue to experience in our provider network. A 2023 survey of student oral health conducted by the Maryland Department of Health revealed that 43% of students were experiencing dental decay, 51% needed sealant, and nearly 30% required early or urgent dental intervention. At the same time, dental care has become increasingly inaccessible, and the pandemic just exacerbated the problem, with the rate at which children on Medicare access preventative dental health care falling from 63.8% before the pandemic to 56.5% after. With so many competing demands on working parents, is it any wonder that pediatric dental care may fall down the list of priorities? Our school-based health center program is already a tremendous success story. We have now 96 school-based health centers across 17 jurisdictions. School-based health centers are the result of 40 years of research and are associated with improved GPAs, school attendance, grade promotion, college preparation, and reduced rates of suspension. House Bill 1143 follows the logic, meet people where they are. Although school-based health centers are already authorized to provide preventive services such as oral health care, we still need to understand how best to fully integrate these services. To explore the efficacy of school settings to improve oral health care, House Bill 1143 establishes a collaborative to study and make recommendations on connecting families and children to permanent dental facilities through schools and community partnerships, increasing the number of school-based dental hygienists through clarified scope of practice laws, grant support for uninsured children and Medicaid reimbursements, allowing school nurses to apply fluoride varnishes and other appropriate dental services with reimbursement from Maryland Medical Assistance, integrating dental hygiene services within school-based health centers, and exploring innovative models to improve dental service delivery in schools. House Bill 1143 directs the Department of Health to establish the collaborative with a wide range of legislators, educators, health officials, dental associates, advocates, and other stakeholders. Because there were still continuing questions as to how best to integrate dental hygienists in the school-based health settings, you will see 2 amendments in your floor system that provide for the collaborative to establish the guidance. The collaborative will prepare and submit an interim report by December 1st of this year and a final report by October 1st, 2026 to the Governor and the Maryland General Assembly. And the collaborative sunsets on June 30th. The fiscal impact is minimal and well under the threshold. House Bill 1143 is a small investment to yield a massive return. For all these reasons, I ask for a favorable report on House Bill 1143, and I turn it over to my esteemed panel.
Who's going to be next?
Good afternoon. Thanks everyone for hanging in there. Robin Elliott, I'm wearing the hat of the Maryland Dental Action Coalition, the school health nurses, school-based health centers, and Maryland Community Health System. I just have to thank Delegate Bagnall, Delegate Cullison, and Delegate Kipke for sponsoring this bill. I have to confess I have a very soft spot for this bill. When we were preparing on what to do to improve oral health access for children, we were looking at the latest numbers from the Department of Health, and we were very concerned. These numbers are in your packet. Delegate Bagnall referenced them, but the key indicator are the percentage of children in Medicaid who are receiving at least a preventative service. After Diamante Driver's death, that number was about 50%. We got it up to about 66% in 2015, 2016. It took a plunge during COVID, not surprisingly, but we have yet to rebound. And in 2023, we are only back up to 57%. We know we don't have money, but we have a lot of conviction. And so what this bill does is pull together the people working in school-based dental areas and just putting our best brain power together to figure out how we can do more with what we have already. And so with that, I would ask for a favorable report. Thank you.
Who will go next, please?
Good afternoon. Good afternoon, Madam Chair, Vice Chair, and members of the committee. My name is Sana Kataria, and I'm a dentist trained in India and a Master's of Public Health student at Johns Hopkins. I worked as a dental assistant and treatment coordinator in California, providing care to underserved state-insured patients. I also serve as the president of Johns Hopkins Oral Health Society, where I lead efforts to advance oral health advocacy, education, and interdisciplinary collaboration. Additionally, I also serve on the board of a federally qualified health center in California in efforts to improve healthcare access. I am here today in strong support of House Bill 1143. Over 10,000 Medicaid-enrolled children visited the ER for dental pain last year, many multiple times, totaling the visit to 16,000 visits. Emergency room provides pain relief, but they do not treat the disease, forcing the children into a cycle of suffering. Maryland has only 203 pediatric dentists for over 600,000 Medicaid-enrolled children. And in some counties, there's only one provider for every 2,000 enrollees. Maryland's children are suffering for something that's an entirely preventable dental pain. This bill will allow dental hygienists to provide preventive care in school, eliminating the biggest barrier of transportation. It creates the Maryland Collaborative to expand school-based dental care. Hygienists can apply fluoride varnish and dental sealants, which prevents up to 80% of cavities before they even start. Every $1 spent on sealants saves $6 in future dental costs. We have made progress since the tragic loss of Diamante Driver, but barriers still exist. We have two choices: continue sending kids to ER in pain, or invest in prevention where they need it the most. I urge for a favorable report for House Bill 1143. Thank you.
Thank you. Next, please.
Good afternoon, distinguished members of the committee. Thank you for the opportunity to present testimony today in strong support of House Bill 1143. My name is Erin Allam Hansen, and I'm the Director of Programs at Maryland Dental Action Coalition, a statewide network of individuals and organizations working collectively to improve oral health for all Marylanders. I'm also a mom of a 3.5-year-old who will be attending the Frederick County Public Schools in the near future. MDAC was formed as a response to the death of Diamante Driver, and our commitment to ensuring that Maryland's children have access to oral health services remains at the center of our mission. Now, almost 20 years after Diamante Driver's death, we're starting to see a concerning downward trend in the condition of children's oral health, reversing years of significant progress in the state. One indicator contributing to this concern and the need to act are the results of the 2022-2023 Oral Health Survey of Maryland school children that Delegate Babineau mentioned. This survey is conducted approximately every 5 years by the Maryland Department of Health and is used to assess the oral health status of children in kindergarten and third grade. The latest survey results showed a sharp rise in students with untreated dental decay, specifically 21% of students experiencing untreated dental decay versus just 14% in the previous survey. And in addition, 30% of the students needed early follow-up or urgent care due to pain or infection at the time of assessment. That's compared to just 13% in the previous time point. The interprofessional collaborative that the bill would establish would help launch a renewed public health approach to closing the oral health gaps for children by focusing where children are, which is at school. As a mom and an oral health advocate, I ask for a favorable report from the committee. Thank you.
Thank you, and thank you for being with us today. Who would like to go next?
Thank you, esteemed Madam Chair and members of this committee. My name is Deborah Carty. I'm a registered dental hygienist and a member of the Maryland State Board of Dental Examiners, and I'm representing the board. The board has always been supportive of programs that seek to improve the oral health of children, especially those that are most vulnerable. Early detection and maintaining good oral health is critical. But clearly, we still need to do more, and dental hygienists in schools can help. Cavities, unfortunately, are still the most common chronic disease among children. The board supports House Bill 1143 with three friendly amendments. These amendments are expressly written in our position paper and has been submitted to the delegation. The first amendment is at the bottom of page 2, striking section 1 in its entirety. The second amendment is an insertion on page 4 to include the chair of the State Board of Dental Examiners or the chair's designee as a collaborative member. And then the third amendment is another insertion on page 5, a study recommendation to include clarity of existing laws in the collaborative study. And we believe the board member can help with that. The goal here is improving the oral health of children. The board supports the Maryland Collaborative to utilize dental hygienists in schools to improve children's oral health. For these reasons, the board requests that House Bill 1143, as amended, receive a favorable report, and I thank you again for the opportunity to testify.
Thank you for being here. There is one person, Liz Elliott, and is she on your panel?
Ms. Elliott, not me, was not able to make it. She's a school nurse and was stuck at school.
Okay, well, she's doing the real work. Okay, is Christina Bartz on your panel?
Also, she had to leave.
Well, it says here virtual. Is she there? No?
Yeah.
All right, so
Okay.
this is it for this bill. Let me open it up for questions. Any questions on this bill? Seeing none, thank you so much. I appreciate you. This concludes the bill hearing on House Bill 1143. For planning purposes, this is how it's going to go. We have House Bill 333 next, followed by 1199. Okay? The lawyer on that bill is Lindsay. Then we're going to go on to Lisa, who's the lawyer there. That will be House Bill 1315 and House Bill 1298. And then we're going to end with Aaron, who's the lawyer for 1481, 1208, and 1449. That's going to be the order. So let's go with 333, please. Oh, 1 second, Delegate Bagno, I didn't ask you, but you saw the amendments and you're okay with them, correct? All right. Thank you. Delegate Kerr, do you have a panel?
I do.
Okay.
Small panel.
It's, you know what? It's the quality that matters.
It's a quality panel.
It's a lot of pressure.
That's right. It's a lot of pressure on you. Go
All
ahead.
right. Well, good afternoon, Madam Chair and fellow members of Health and Government Operations. I am Delegate Ken Kerr. I'm here today with House Bill 333 that has the kind of a cool name of Cybersecurity Healthcare Ecosystem. So this is an important piece of legislation addressing the increasing threat to Maryland healthcare system from cyber attacks. The FBI and Department of Justice have labeled these types of attacks as a threat to life crime. And the National Security Council has identified healthcare as one of the top 3 sectors vulnerable to cybercrime. Hospitals are particularly attractive to cyber criminals, often sponsored by hostile governments, because of the disruption that is caused by the denial of access to vital records, data, and sometimes medical equipment, resulting in public fear and overloading unaffected healthcare facilities. In the past 5 years, hospital cyber crimes have increased by over 250%. In 2023, the FBI identified healthcare as the most targeted sector for ransomware because of the need to regain access to records and data make it more likely that somebody's going to pay up. Hospitals experiencing successful attacks lose up to $1 million a day and struggle to regain access to their systems. Other hospitals suffer because of the inability well, they have to take the overflow of patients, and then they can't access records. As originally drafted, HB 333 would have required MDEM and Maryland Insurance Association, MHCC, to enforce increased cybersecurity protections, require biannual third-party audits, the adoption of a zero trust model, and beginning in 2026, the results would be reported to the state CISO and establish a healthcare cybersecurity work group to improve resilience and coordinate incident exposure. Similar legislation was introduced last year but withdrawn to continue to work on this, which we did over the interim with MHA, but not much progress was made. So we continue to work with MHA to find a workable solution to hospital cybersecurity vulnerability. And as a result of the talks with MIA and DO-IT, work has been done in the Senate to amend the cross-file bill, SB 961. So it's been amended to a work group to continue the discussion with the stakeholders and arrive at a cohesive strategy to keep hospital patients and communities they serve safe from cyber and ransomware attacks. So I request the committee give HB 333 a favorable report so this important work can continue.
And before the next testimony, did I miss, did you mention the fiscal note?
The bill has been amended to convene a work group.
So it's going to be just a work group, no fiscal note, they can do it with existing resources?
Revised fiscal note, but that certainly is the intention.
Okay, great, next please.
Thank you, Madam Chair, Vice Chair Cullison, and members of the committee. My name is Ben Yellen. I am the Program Director for Public Policy and External Affairs at the University of Maryland Center for Health and Homeland Security. We worked with the Office of Senator Hester on a report detailing the frequency and impact of cyber attacks on entities making up the healthcare ecosystem. And the data was sobering. Healthcare is an attractive target for cyber criminals for several reasons. First, the system contains valuable data, including patient-protected health information and personal identifying information. This valuable data can be sold on the dark web for amounts far exceeding, for example, stolen credit card information. Second, the disruption to the health system is devastating in its impact to communities. It can cause downstream effects that lead to bad patient outcomes. Cyber criminals are, of course, aware of the potential for these catastrophes, and they have an incentive for these entities to pay significant ransom. What makes attacks in healthcare unique is that an attack on one part of the ecosystem has a cascading impact on the entire ecosystem. When Change Healthcare, a subsidiary of United Health Group, suffered a cyber attack, the impacts were devastating even though the attack had no direct impact on hospitals, providers, or insurers. But because Change Healthcare served as an intermediary to facilitate things like eligibility checks, insurance claims, et cetera, the entire ecosystem suffered. 74% of affected hospitals suffered impacts to patient care, while 94% reported a significant financial impact. So these sobering statistics certainly lend credence to the importance of this bill. I've been happy to work with Senator Hester and Delegate Kerr on the amendments that the delegate discussed. It'll be great to have MHA, MHCC, the Maryland Insurance Administration, and patient advocacy groups at the table to help address this issue. And with that, I request a favorable report with those amendments.
Thank you so much. We're going to actually open it up for questions from the committee. Any questions for the delegate on the bill that is now a task force? All right. Thank you so much. I appreciate it. Next, we're going to go to an unfavorable. Jake Whitaker and Janet, there's a virtual one from Hopkins, Janet Ratha. It is now, can you please testify on the amendments, proposed amendments?
Thank you, Madam Chair, members of the committee. Jake Whitaker on behalf of Maryland's hospitals and health systems, here to testify in respectful opposition to House Bill 333. Thank you, Delegate Kerr, for sending over amendments for a work group. We appreciate your participation in our work group with a robust stakeholder group comprised of members of the state, of the General Assembly, health information exchanges, and health providers. While we do not think further studies required, and we do think that this is better regulated at the federal level, we'd be happy to review any amendments sent over by Delegate Kerr. So once again, I just want to thank Delegate Kerr for his leadership on this issue and support for this important topic. But for the aforementioned reasons, we respectfully oppose the bill as drafted. Thanks.
As drafted and with amendments.
We would love to see the amendments, and I'd be happy to review them with our members. But until I do, I can't give you an answer, Madam Chair, respectfully.
So the committee would like to know what your members think of it now. Once it goes to subcommittee with the proposed amendments, that it will be a work group. What is the position then? Okay?
Absolutely. Thank you, Madam Chair.
Thank you. Any questions? And I appreciate our partnership, okay?
Absolutely.
Thank you. You have a blessed day. Let's go on to Janet Ratha. It's another unfavorable.
Yep, just a microphone check.
Yes, we can hear you.
Great.
Again, if you heard me, the bill as proposed will be a work group. So I'd like you to testify as to the work group because it's going to go to subcommittee. Thank you.
I'm sorry, was that addressed to me?
Yes.
Okay. So
I can see you.
You specifically want me to speak about the work group?
Well, the bill is no longer, the way that the delegate, the sponsor testified, not to the bill as it was written, but he actually testified with the amendments that he proposed, which will make this a work group now.
Okay. And I did not hear the discussion surrounding the work group. So what would be the purpose of the work group?
Okay. So go ahead, give us your testimony. It's the same. Go ahead.
Okay. So testimony as written, I wanted to start with just talking about how the fact that we can agree on one thing, that is, we want to see a reduction, if not elimination, of cyber breaches across the healthcare industry in Maryland. This bill, so as it's written, it could potentially do the opposite. So I'll structure my remarks in 3 buckets, and hopefully it will even answer some of the questions about the work group. So first is the evolving threat landscape. The second is the resource burden that this puts on hospitals. And the third is duplication, potential confusion, in fact, with existing federal requirements. So one thing, being in the industry for 2 decades, I've learned threat actors are incredibly capable. If we just look back at the past couple of years alone, we've seen the US government, private industry to include AT&T, Microsoft, Lumen, Verizon, MGM, rather, to name a few. These are highly secure entities who make significant investments in cybersecurity. If attackers can breach these companies, it shows just how capable they are. So when looking at the healthcare sector specifically, it's clear that our defense strategy must be airtight, focused on the evolving threat landscape and applying our very limited resources to where it matters most. So not following a checklist of requirements that potentially risk becoming outdated. Additionally, the other point that I want to make is that if we look at how threat actors breach systems, there is something that stands out, and that is that a disproportionate number of breaches are due to software vulnerabilities. So meaning vendors at times are shipping us products that are not secure, and in some cases, such as with medical devices, we're reliant on vendors for patches. So they own a piece of this puzzle too, yet the legislation as written places the onus completely on hospitals. Let me pivot to the resource burden very briefly. Hospitals, especially small and rural ones, are operating on the margin. So every dollar spent on compliance and audits is a dollar that is not spent on real security improvements. Further, the bill does create costly mandatory revenue streams for third-party cybersecurity vendors. So this essentially places an additional financial strain on hospitals without addressing the core security risks. It also drains our valuable personnel resources. We definitely need each one of our people, our talented people, focused on active cyber ops, not audits. The last thing I'll briefly mention is
I need you to wrap up, please, because your time expired, and I was generous to give you a little more. You have to wrap it up. We have a lot of more, and the bill is now, as I said, it's being proposed as a work group. So can you give me your last thought, last sentence?
Yep. So even if you add a work group to the mix, we are already subjected to layers of cybersecurity framework standards, guidance, performance goals, and HIPAA regulations. So I don't know that a work group is going to move the needle on security.
Okay, thank you so much. I'm going to open it up for questions now, okay? Are there questions for this witness? Seeing none, thank you so much. And the bill will go to subcommittee where you guys are welcome to come, all right? Thank you so much. I have next 3 more witnesses on this bill. Favorable with amendment, Mr. Wahid, John Fiastro, and Tasha Cornish. Will you please come up? And you each have 2 minutes. And as soon as you sit, please get started. Thank you so much. And those of you that are waiting, thank you for being patient. We appreciate you. It's a long day, so we're grateful to you. Will you get started, please?
Yeah, my name is Hussein Wahid. I'm with the Advanced Technology Acceleration Initiative, University of Maryland, College Park. I would like to point that the best performing system when all operational software failed June 19th, 2023 was an open source system. And that is what we have found in our review, and also that forms the basis of much of the initiative, as well as the basis for advanced technology and engineering research centers at the University of Maryland. They're all based on what the citizens, the common people, experience and what their input is. So entirely survey-based, and it is open, adaptive, and agile system, and it is dynamical as well at the same time. it was not developed as such from the beginning, but it has evolved into this type of system. And that's one of the main reasons it is currently ranked as #1 for life cycle engineering. Also, it has withstood tests in 100,000 survey results that just came out in February, confirming that in the last 5 years, from the start of the pandemic to the epidemic that is continuing now, it still performed better than many of the other systems. And the reason being, it has the transfer from a starting specifications and standards to an implementation that is entirely based on interaction of large number of people who are familiar with it or they are experts. But whatever the reason is, it brings about this zero tolerance to errors as an objective and zero trust that was mentioned in the presentation of the bill.
Thank you. Next, please.
Good afternoon, Madam Chair, Madam Vice Chair and Committee. For the record, my name is Tasha Cornish, and I'm writing on behalf of the Cybersecurity Association, a nonprofit 501c6 organization dedicated to strengthening the cybersecurity industry. Our association represents over 600 businesses, ranging from small enterprises to large corporations employing nearly 100,000 Marylanders. We appreciate the opportunity to offer testimony, and I'll keep it brief as I know that the new direction is to create a work group. With that being said, to echo previous testimonies, we know that there are a lot of laws at the federal level. Just last month, HHS, or 2 months ago now, HHS issued a notice of proposed rulemaking to update the HIPAA security rule to maintain consistency with federal regulations. We recommend an amendment in the work group to require periodic review and updates to Maryland cybersecurity requirements to reflect changes in the federal standards. Additionally, any work group should seriously consider including a safe harbor provision similar to the Oklahoma Hospital Cybersecurity Protection Act of 2023. The Oklahoma law grants affirmative defense and tort actions for healthcare entities that implement and maintain reasonable cybersecurity measures based on recognized industry standards. This approach incentivizes compliance while protecting hospitals and other covered entities from undue liability when they make good faith efforts to secure sensitive information. Thank you to the bill sponsor, Delegate Kerr, and others for your consideration of our amendments, and we urge a favorable outcome. Thank you.
Thank you for being here. Next, please.
Thank you, Madam Chair, members of the committee. My name is John Fiastro here with Tasha Cornish and the Cybersecurity Association. We do want to echo our thanks to Delegate Kerr and Senator Hester for putting forward this package of legislation. But we do want to say, if there will be a work group, the first thing is that the Cybersecurity Association would love to be a participant in the work group. And given that a lot of the legislation before us in the first reading version is very prescriptive, we also think that there should be a carrot, as Ms. Cornish alluded to, of safe harbor. So there should be a contemplation of safe harbor for entities that take on these responsibilities, take on these protocols, these cyber protocols, and there should be some shielding from civil liability if they were to take on these efforts. She mentioned that the state of Oklahoma did this, but there are other states that have taken on safe harbor legislation: Ohio, Utah, Connecticut, and Iowa, but specifically Oklahoma as it relates to their healthcare ecosystem. So we think these are two important contemplations. As we put together a work group, love to work with the sponsor a little bit further to make sure that that's included. Thank you, Madam Chair.
Thank you so much. I'm going to open it up for questions now. Are there any questions for this panel? See none, thank you. And thank you for waiting and being patient, okay? We appreciate it. This actually concludes the bill hearing on House Bill 333. We have one more for Lindsay, because we care about you, Lindsay. House Bill 1199 is Delegate Hill. Delegate Hill, can you come up with your panel, please? Then, for planning purposes, after this bill, we'll have Lisa as the analyst. Is House Bill 1315 and 1298, okay? So you can get ready.
Thank you. Good afternoon, Madam Chair. Good afternoon, committee.
Yes.
Terry Hill, presenting House Bill 1199. So last year, we presented a bill that proposed a way to address or start to address our physician shortage problem by creating an alternative pathway where physicians who trained in other countries and practiced in other countries in good standing could have an accelerated pathway to licensure here in Maryland. The current pathway requires repeating your residency. There is an alternative one for physicians who have contracted with one of the teaching hospitals here. And the chair in her wisdom said, make a work group, come back next year with a plan. So we've come back with a plan. So we met over the interim, and the bill before you is the recommended plan. There are a couple of points to it that I think are important. One is that in order to get information about prior licensure and standing of physicians, we need to have specific countries that we know that information can be obtained from. We also need to know that there are countries where the standards for licensure, the standards for practicing and evaluation are similar to what we have here. The process that you have before you in this bill gives the leeway for that to be determined, so it doesn't require that we would accept this as a pathway for every physician coming from every country. And it also recognizes that right now there is no uniform way to make those determinations, and we don't want to overburden the board with having to make those determinations. So we really have a rollout date of 2027, because the questions that we asked in this bill and tried to address are questions that other states are trying to address as well. And the Federation of State Boards of Physicians is actually looking at the issue, and we believe will come up with a way of at least vetting some of the information that we would need to make the best decisions. So I'm not going to get into the details of the bill. I'll be here for questions, but I really think we're ready to move forward, and that accepting some amendments that are being offered that you have in your packet that we've discussed and we're willing to have more discussions, and some amendments that we are actually asking for the subcommittee to take up. We think we're ready, and we thank the chair for putting us to the task, and we hope that you'll find that we've answered the call.
Thank you for your work. I mean, for taking on the task, which was very difficult to see this picture in front of me. All the people sitting there, I think it's wonderful. I know we have other people testifying, and this is unusual for me to do what I'm about to do, but the fiscal note says it's special funds. We still need approval for that. Do the amendments reduce the fiscal note? Any?
Well, the fiscal note, the special funds come from the fees that the doctors pay.
Right.
Right? And
well, we still need approval.
We still need approval, and in the end, we believe that the support, the fiscal note does not go away because of the amendments.
Okay.
Okay,
right.
that's the answer to the question.
Thank you. But the Board of Physicians did testify with amendments.
Correct.
And they have that special fund. Okay. So who's next? And actually, at the end of the day, we need the doctors. We hear that every day, the shortage that we have in healthcare. Who's next?
I'll be going next. Good afternoon, Madam Chair, committee members. My name is Michael Tran, Health Policy Analyst with the Board of Physicians. The board would like to thank Delegate Hill for sponsoring HB 1199. We would also like to thank all the proponents and stakeholders involved during this process. There's been a lot of work and a lot of collaboration that's been gone into this, and the board is here to support the bill. During the interim, as Delegate Hill mentioned earlier, the board facilitated the work group to study the licensure of foreign trained physicians, or FTPs, and international medical graduates, IMGs, in Maryland. This work group was tasked with looking for barriers faced by FTPs pursuing state licensure, the licensure process for FTPs in other states, as well as other issues regarding FTPs joining our healthcare workforce. You have my written testimony and a copy of the work group's final report, but in short, HB 1199 aligns with the work group's findings and recommendations. The board believes that HB 1199 establishes a strong framework for the integrating currently underutilized FTPs into Maryland's healthcare workforce. We are committed to supporting this effort, and we look forward to collaborating with Delegate Hill and the other stakeholders. Thank you, and we urge a favorable report.
Thank you so much. Who's next?
Good afternoon, Madam Chair, members of the committee. My name is Charlotte Davis. I'm the Executive Director of the Rural Maryland Council. Access to health care is one of the biggest challenges we see in our rural areas, and we see through the Health Resources and Services Administration those shortage designations, and there's at least 6 counties, rural counties, that are shortages, and we see them all across in our rural areas. And the Commission in 2023 to study healthcare workforce crisis did acknowledge that the healthcare workforce is it's particularly acute in the rural areas, not just primary care, but also dental care and mental health care. The U.S. Department of Health and Human Services reported to eliminate those federal designations, the state would require 282 primary care practitioners and 81 mental health practitioners. As this bill would help bring those high-level healthcare workers to practice in Maryland, we ask for your favorable support of House Bill 1199. Thank you.
And thank you so much for working it out. Next, please.
Madam Chair, Steve Wise, members of the committee, Steve Wise on behalf of MedChi. We participated in the work group. At this point, I will just say me too and happy to answer any questions.
All right, thank you. Thank you, Steve, for your partnership. Are there any questions for this? Delegate Woods.
Thank you, Madam Chair. Good afternoon. Thank you so much for this extremely important legislation. I had the distinct privilege of participating in Governor O'Malley's New Americans Council back in 2008, where they looked at doing this very exact same thing to make sure that we could bring people who were trained into our country because of the deficit. First question is, have you had an opportunity to look at that report?
No.
And I forgot now what the second question was. Wow.
Yes.
Okay. Thank you, Madam Chair. I forgot the second question. Madam Chair, if I recall the second question, would I have an opportunity to come back?
Absolutely.
You're so kind. Thank you.
Thank you. Any other questions? Seeing none, Delegate Rosenberg.
Late.
Go ahead.
Going to ask, what impact would serious reductions in Medicaid have upon the provision of rural health care?
I'll have to get more data on that. I don't know specifically, because that's a tough question. A lot of the rural areas do benefit from those Medicaid expansions, particularly in the dental health. You guys expanded that a couple of years ago, so I'll have to go back and double check what that impact would be.
Thank you.
Thank you. I see no other question. Delegate Hill, and forgive me if I missed this. There's a letter from the Maryland Academy of Physician Assistants.
Yes.
And in it, they stated that we wanted to know that the FSMB report does not address the question about collaboration of ITP and physician assistants. We believe this question needs more discussion and involvement of the physician assistant community.
Yes. I think that what will happen is, as the board is tasked with coming up with the regulations around that, one of the issues will be during the 3-year provisional license period, do they have supervisory responsibilities or not? Obviously, once that period is going there fully and they get a full license to practice, they can have the same, it's a full unrestricted license, they supervise physician's assistants and all, so that would be the time to have that conversation.
Okay, thank you so much, Delegate. Thank you. Let's go to an unfavorable. The only unfavorable is virtual. Deborah Brocato, Maryland Right to Life. Will you bring her up, please? Thank you. And then we'll go back to the favorable and favorable with amendment, okay? Trying to be balanced here. Ms. Brocato, good afternoon. Ms. Deborah Brocato, can you give us your testimony?
Hello, can you hear me?
Yes, we can.
Okay.
Trying to be balanced here.
Okay. Good afternoon.
Brocato, good afternoon. Can you
Good
turn
afternoon.
off your
Madam Chair and I'm sorry, can you hear me?
Can you turn off your link,
I'm
whatever you have
here
on?
and I can't see the, let me see. I'm
Whatever
sorry,
you
just a
had
minute.
on the computer, you were watching the hearing. If you could turn it off, please.
I'm sorry, can you hear me? Okay, I'm turning it off. Okay.
Thank you.
All right, sorry about that.
It's okay, it happens. How are you?
Good afternoon, Madam Chair and delegates. Deborah Bricado with Maryland Right to Life. And on behalf of our Board of Directors and followers across the state, we respectfully but strongly object to House Bill 1199. Maryland Right to Life opposes the state interfering with the independent governance of any health occupations board. This bill also is giving authority to an unelected body outside of the United States, namely the World Health Organization, to be involved with healthcare decisions in the United States. Education, training, and licensing vary greatly from country to country. Record keeping varies from one country to another. Some countries have very poor or non-existent record keeping. This lack of uniformity among foreign nations makes it impossible to verify or to quantify the level of professional standard of care for these physicians. The English proficiency requirement is vague, and language barriers pose a real threat to effective quality health care. With that in mind, this bill has no requirements for a written examination that would provide proof of knowledge, nor requirements for a supervisory period during which the individual could be evaluated for a knowledge and skill before giving the physician a United States license. The State Board of Physicians should not assume the licensing qualifications provided are accurate. The lives of the Maryland population are at risk when put into the hands of unqualified health practitioners. Healthcare is not a place to play Russian roulette. Cultural differences in other countries tend to negatively impact women more than men. The cultural norm in some countries is that women are not treated with equal respect and dignity as men. Healthcare delivery provided by those individuals is likely to be harmful to women. This needs to be consideration when choosing countries for physician recruitment. We ask that you protect Maryland lives and demand high standards for those who practice medicine. Please give an unfavorable report on House Bill 1199. Thank you.
Thank you for your testimony. Any questions for this witness? See none, thank you so much for being with us. Will you please bring the other virtual witness? I think it's Pamini Ranasi. Favorable with amendment. Good afternoon. Good afternoon. If you're there, will you please log in, please? Log on. All right, while they are doing that, can I please have Mr. Wadhi and Yang Sao, please? Okay. And is there also a Michael Zimmer? Can you bring them up? Will you please get started with your testimony? You have 2 minutes. Yes. Thank you.
My name is Hussein Wahid. I'm with the Advanced Technology Acceleration Initiative, and in support of the licensing for foreign graduates for physicians. And the main reason is, as I mentioned, the algorithms have been tested for different applications, multiple disciplines, and in each one, the statistical basis has proven to be extremely useful, valuable, and also delivering transformative economic efficiency. That is the reason why the range of application continues to be growing and is broad. And that is one of the main reasons why the Life Cycle Engineering Research Center does so well competitively at present. And actually, any other competitor can use similar algorithms and do better. The only difference is how much of current information that can be included in it. And UNESCO has utilized similar methodologies for physicians and for healthcare providers. And also, they have been able to deliver advanced technology results throughout continents. And this enhances the support to make this happen, the utilization of physicians from other countries be able to apply their skills any part of the world. Because once they go into practice, they start using the data set that is already well established, well proven, And if the practice can match what has been well established in terms of the implementation of specifications and standards, then the risks are minimized to the patient and for the outcome. There is one practice that I want to point out in Howard County that is also advisory, that has been working very well.
Thank you. Next, please.
Thank you. Good afternoon, Honorable Madam Chair and Vice Chair and my members of committee. My name is Dr. Yang Zhao. I am speaking in favor of HB 1199. As a gynecological oncologist with over 15 years of experience, I treated at China's top medical school, Peking University Health Science Center, and completed over a decade of rigorous residency and specialty training. As an attending physician at one of China's leading hospitals, I treated thousands of patients and performed hundreds of complex surgeries every year. When I moved to the United States, I hoped to continue my work, but current licensure system makes it nearly impossible. Despite my years of training and expertise, I would need to pass multiple exams, complete months of U.S. clinical experience, and enter a highly competitive residency process. Even in the best case, I would take over 10 years before I could practice again. All while Maryland faces a severe physician shortage. A structured pathway, such as supervised transitional practice and competency assessment, can ensure that experienced international doctors like me meet U.S. standard while allowing us to serve community in need. Every day, I meet women who wait months of gynecologists. They need care now. HB 1199 would create a path for highly qualified international physicians to step in and help. Thank you. Thank you for your attention.
Thank you for being with us. Are there any questions for these two witnesses? God bless you. Seeing none, thank you so much. Sir, it says Zoom user. What is your name?
Mike Zimmer.
Okay, can you please mute yourself? And I'm going to call on the person that was before you. Ma'am, Mrs. Patmini? Is it Dr. Patmini? Will you be so kind and give us your testimony, doctor?
That's correct. Yeah. So my name is Padmini Ranasingh. Good afternoon, Madam Chair.
Good afternoon, doctor.
And the members of the committee. And I'm the president of Maryland Medical Society, MedChi. And I am here today representing MedChi. I work at Johns Hopkins, but not representing Johns Hopkins. At MedChi, we are in support of Bill 1199 with the amendments offered by the sponsor. As an international medical graduate myself, and also a member of ACCME work group in developing curriculum framework for onboarding and orientation of IMGs, as well as the past chair of International Medical Graduate Section at the American Medical Association. I understand the challenges faced by IMGs. HB 1199 will allow highly skilled, internationally trained physicians to practice in Maryland, addressing the physician shortage and bringing diverse expertise to our community. However, balancing the need for physicians with the need to ensure patient safety and adequate training is a complex issue. It is crucial to implement this legislation thoughtfully with well-structured plan to avoid challenges that the other states face so far, and also to ensure both integration of internationally trained physicians and safety of patients with, we provide higher standard of care. At MedChi, we hope that this bill will improve access to quality health care for all Marylanders. Thank you very much, and happy to answer any questions.
Thank you, doctor, for being with us. We really appreciate it. May I have is there any questions for the doctor? Are there any questions? Seeing no questions, thank you so much for being with us, okay? We appreciate your feedback. May I please have the testimony from Mr. Michael Zimmer? Will you be so kind, unmute yourself and give us your testimony? And then it will be followed by the testimony from Mr. Kairos. Go ahead, sir.
Yeah, thank you, Madam Chair, Vice Chair Callison,
You're
and members
welcome.
of the committee. My name is Mike Zimmer. I am with World Education Services. We appreciate the opportunity to testify today and offer our strong support for House Bill 1199 and our appreciation of the sponsor, Delegate Hill, for her leadership on this. By way of introduction, WES is a nonprofit social enterprise that for over 50 years has been dedicated to helping international students, immigrants, and refugees achieve their career and professional goals. By way of more personal introduction, I'm a self-professed license geek. I used to run licensing for the state of Michigan for more years than I will admit. In recent years, WES has provided technical advice and expertise to a number of states seeking to develop alternative pathways, particularly lately with internationally trained physicians. Just by way of a national landscape, since 2012, 11 states have passed reforms creating pathways for previously licensed international medical graduates. Washington, Colorado, North Dakota, Florida, Iowa, Illinois, Wisconsin, Virginia, Louisiana, Massachusetts, and Tennessee. This year to date, pathway legislation has been introduced in 22 more states all over the country, including Maryland. The list of those states creating or working on pathway legislation crosses regions of the country and certainly crosses political spectrums. The goal of all this legislation, including House Bill 1199, is twofold: to create a meaningful and workable pathway to harness the skills and talents of internationally trained physicians, and to use that pathway to address healthcare workforce shortages. We applaud 1199 and the safeguards it contains within and urge your positive adoption. Thank you.
Being here, we appreciate you. Are there any questions for this witness? See none, thank you so much. And the last witness for this bill is Mr. Kairos. Before he goes, I have to go meet with the speaker at 5. So Delegate Bagnall will continue, and there's only 5 bills left, and she's going to take over, okay? So Mr. Kairos, good afternoon, how are you?
Good afternoon,
Good.
Madam Chair.
Wonderful to see you. Will you be so kind and give us your testimony?
Yeah. First of all, thank you very much for the opportunity to testify. Please pardon me for my attire. It's because I'm at workplace. So my name is Dr. Yazez Kiros. I am here speaking in favor of HB 1199, physician licensing, internationally trained physicians licensing. After I completed my medical training in Ethiopia and Israel, I practiced medicine at University Hospital for about 2 decades, where I treated thousands of patients, taught many medical students, and led residency programs. But unfortunately, because of a war in northern Ethiopia, I was forced to flee to the US. The transition was challenging, but a friend provided me with a place to stay as I worked hard to rebuild my career. Although I'm currently working as EKG monitor technician in Billipon Hospital in Washington, D.C., this position is well below my capacity as a physician. After I came to the US, I passed all the 3 United States medical licensing examinations, and I am ready to go to the profession that I love, bringing my expertise, my many years of expertise to the US healthcare system. I chose medicine to truly make a difference in one's life, even providing a moment of relief of comfort and recapturing my ability to practice medicine in the US means that I continue that mission with dedication. So I kindly request the committee to pass this bill so that experienced physicians like myself would be able to provide care in the US. Thank you very much for the opportunity.
Thank you very much for your testimony. Do we have any questions from the committee for this witness? Seeing none, thank you very much for being here with us today. This does conclude the hearing on House Bill 1199. We're going to turn to House Bill 1315. Delegate Gazzoni, if you want to bring up your panel. Oh, I'm sorry, I missed you. Thank you so much. Thank you for bringing my attention to that.
That's okay. Good afternoon, everyone. Madam Chair, Vice Chair Cullison, and distinguished members of the committee. My name is Dr. Shafat Hassan. I'm a foreign-trained physician with over a decade of experience in general dermatology, skin cancers, and now public health. My qualifications include an MD, a PhD, a fellowship, an MPH, along with several diplomas and specialized training. I strongly support the House Bill 1199, which aims to establish pathways for internationally trained physicians to practice in Maryland without the requirement of completing an additional residency. Maryland faces a growing physician shortage, particularly in underserved communities, and this gap is impacting patient care. During my time observing in the cutaneous medical oncology unit at Johns Hopkins, I saw patients with aggressive skin cancers whose disease had progressed to advanced stages by the time they arrived for treatment. The shortage of specialists and long waiting times left them without timely care, allowing their conditions to worsen. This is not an isolated issue. Many Marylanders face similar challenges in accessing specialized medical care. Meanwhile, highly skilled foreign-trained physicians, many of whom have passed rigorous exams, completed their residencies, and years of clinical training abroad, remain unable to practice due to the regulatory barriers. Last week, a Middle Eastern immigrant doctor, Dr. Ali, who drove me to DC, shared that despite 23 years of his clinical experience as a general practitioner in his home country, he was forced to leave medicine entirely because he could not afford to redo his residency again. Instead, he now works in construction and drives for Uber part-time. He's not alone. There's a huge percentage of ITPs in the US who never return to clinical practice despite holding MDs and extensive experience. A recent study found that among former immigrant physicians not on track for licensure, 77% held MD degrees, yet were working outside of healthcare. To ensure a smooth transition, Maryland could introduce short-term cultural competency trainings, but the notion that foreign-trained physicians need to prove their ability beyond the existing credentialing system is unnecessary. I respectfully urge the committee to support HB 1199. Thank you for your time.
Thank you very much, Dr. Hazan. And I will note that I had you written down as written only, so I apologize for not
It's all right. Thank you so much.
It's all right. We've gone ahead and updated the records. Do we have any questions for this witness? Seeing none, thank you very much for your testimony.
Thank you.
And this truly concludes the hearing on House Bill 1199. And we are now going to turn to House Bill 1315. Delegate Gazzone, if you want to go ahead and bring your panel up. Whenever you're ready, you can go ahead and get started.
Thank you, Madam Chair. Good afternoon, Madam Chair, Madam Vice Chair, if you're watching, and members of the Health and Government Operations Committee. For the record, I'm Delegate Pam Gazzone, and I represent Howard County's District 13. Today, I'm here in support of House Bill 1315 regarding childhood immunization. As with several other bills this committee has heard this year, this bill is designed to ensure that Maryland has, in law, the ability to continue to provide, as part of its minimum package of child wellness services, the childhood immunizations, which to date have been recommended by the Advisory Committee on Immunization Practices of the Centers for Disease Control and Prevention. With the number of changes that we have already seen at the federal level and the challenges to the CDC that have been in the media over the last several years, identifying an alternative standard on which to base Maryland's covered immunizations is warranted. This bill establishes an alternative standard and specifically designates the American Academy of Pediatricians, AAP's, schedule of immunization by age. This maintains the CDC's recommended immunizations as they currently stand as of 12/31/2024, just adds AAPs to the code. Given the uncertainty and with the active outbreak of measles currently taking place in the country, it seems prudent that this second standard be added to ensure that we can maintain high levels of childhood evidence-based immunizations in the state. I respectfully request a favorable report on HB 1315, and just want to also share that I have an amendment that's already in, and there were a couple requests for amendments that came through as part of submitted testimony. I don't see any of them. We haven't gotten to resolution on those yet, but I believe that we will have the ability to work them out with the advocates. And I've already started doing that earlier today. Thank you, Madam Chair.
Go ahead, you can start your testimony.
Hi, good afternoon. Thank you, Madam Chair, members of the committee, and I want to thank again Delegate Gazzoni for inviting me here today. My name is Dr. Monique Swallow-Burke. I am a general pediatrician in private practice in Howard County. I'm also a national officer for the American Academy of Pediatrics, and I'm the chair of the statewide advisory commission on immunizations. And I'm here today to speak in favor of House Bill 1315. I think as a pediatrician, we realize how important immunizations are. We as pediatricians across the country have had concerns with some things that have happened recently in our federal government. The recent February ACIP meeting was actually canceled. The 19 members of the ACIP are appointed by the Secretary of Health and Human Services. And while in the past they have been respected members of the medical committee, and we will hope that it will stay that way, we do have some concerns that we are able to keep up our very high immunization rates that we have here in the state of Maryland. We are lucky to say that we are one of the most immunized states in the United States and have been very privileged to maintain that status for a while. The American Academy of Pediatrics has a very important committee on infectious disease. They are in charge of making recommendations for immunizations. They also edit what we call the Red Book, which is really the standard of care and handbook that is used for pediatric infectious disease and infectious disease around the country and frequently around the world. We're also lucky that one of those commissioners is a professor at the University of Maryland, so has a very big hand in what the Red Book says and what recommendations are made. So we really just want to continue to support that, and we want the encourage us to pass this bill so that we can continue to offer standard of care and support and provide the best care we can for our children in Maryland. Thank you.
Thank you very much for your testimony.
And Madam Chair, if I could just drop in something that I neglected to say. Currently, the CDC's list of childhood immunizations and AAP's list of childhood immunizations are the same.
Thank you. You've answered all the questions I had. So let me open it up to questions from the committee. Seeing none, it looks like you've answered all of our questions. So thank you very much for your testimony. We have a couple of favorable with amendments. I have Aaliyah Horton and Robin Elliott.
Sorry.
Thank you very much. You can get started whenever you're ready.
Good afternoon. My name is Aaliyah Horton. I represent the Maryland Pharmacists Association. It's a professional society for pharmacists, pharmacy technicians, and student pharmacists in the state. We are supportive of this bill for all the reasons that were stated in the previous testimony. The amendment that we have is an opportunity to ensure that we maintain access to pharmacist-administered vaccinations. If the committee recalls, as a part of pharmacist scope of practice, there are guidelines that pharmacists have to follow for administering vaccinations. In particular, for this bill, in reference to this bill, it's related to pediatric vaccinations, and it's based on the ACIP recommendations. And our concern is that if the recommendations go away, if the committee is gone, then we don't have a basis for pharmacists to administer those vaccinations. There's continued concern for adults, but I don't know if I guess there's a question about the germaneness of addressing adult vaccinations as well. So we do have that concern. So this is not anything to change scope. It doesn't change anything. It just ensures that pharmacists can continue to do what they have been doing. And there's also in the requirements for pharmacist education, it's also based on these same recommendations. And so we want to make sure that we're in alignment and can continue to do the work that we do. Thank you.
Good afternoon, Robin Elliott. I'm representing the Maryland Community Health System, which is a group of FQHCs, the school-based health centers, and the school health nurses, very much in strong support of this bill, and thank the sponsor for bringing it. We do have a suggested amendment, and that is if it's possible to extend this framework into Medicaid so that there is a uniform coverage requirement. We would greatly appreciate it. We have flagged that for the Department of Health, have done some very initial research, but also, of course, the department is the expert on Medicaid requirements. And with that, we'd ask for a favorable report.
Thank you very much, both of you. Do I have questions from the committee? Seeing none, I just had one question. Ms. Horton, you had mentioned that your concern about making sure that we're coupling the correct guidance.
Yes, I realized I didn't actually say what the amendment was, so my apologies. So in it's section 508, where it says that pharmacists are able to administer, it lists ACIP, it's based on ACIP recommendations for their schedule of immunizations, as well as any FDA approved or authorized. And we are requesting that the AAP recommendations be added there as well for that guidance.
Thank you very much. And if you could work with the bill sponsor, obviously we are in a time-sensitive moment. So.
Yes, she's indicated that the amendment has been accepted. Yeah.
Perfect. Thank you so much. That I don't think I have anyone else. So this actually concludes the hearing on House Bill 1315. Thank you very much for being here. We are now going to turn, to House Bill 1481. As the chair said, sometimes we have to be a little flexible. Our bill sponsor is not here on the next bill, so we are going to turn to House Bill 1481, which is Delegate Hill. Delegate Hill, if you want to come on up and bring your panel.
Good afternoon. Good afternoon,
As our
Madam
chair says, you are enough.
In committee. Wow. Yes, so good afternoon, committee. Terry Hill presenting House Bill 1481, Disability Services Adaptive Vehicle Access Pilot Program. Back in 2017, I presented a bill that led to a work group of a number of different stakeholders, including the Maryland Department of Disabilities, the Motor Vehicle Administration, physical therapists, disability community members, car dealerships, and went on a site visit to a RF Conversions up in Westminster, because it seemed to me that when we talk about workforce and we talk about how do we help all Marylanders achieve their greatest potential, that one area that we hadn't addressed is we tend to think of mobility for people who are ambulatory disabled as meaning you've got a wheelchair, you've got a scooter. And actually, for many people, having access to a converted vehicle that they can drive on their own to take themselves to run errands, to visit people, to work, is a real type of mobility issue. So the work group came up with some ideas and some plans. We ran into some issues, and it sat there. And then I brought it back to the Department of Disabilities this year. The secretary, who had been part of the work group, said, yes, I think we should move forward. And the MDOD has worked with me to come up with this pilot program plan, which would allow for 2 jurisdictions, preferably, or decidedly jurisdictions where there's limited public transportation to serve as a pilot where we would provide converted vans to adults with ambulatory disabilities so that they could drive themselves and look to see if that did indeed improve their ability to work, their access to community things, decrease their reliance on other support systems, and overall increase their independence. That's the bill. There are some amendments that have been offered by the Maryland Department of Disabilities and coming in under my name that I'm fully supporting. I think the fiscal note is within resources, and I really ask for a favorable report.
Thank you very much, Delegate Hill. Do I have any questions from the committee? Seeing none, see you were enough.
All right, and I think there might be some testimony from the Department of Disability.
I have a favorable with amendment panel. So I have Lori Burong and Fatima Wahid. Is Lori Barong here as well? Oh, okay. You can go ahead and start with your testimony.
My name is Hussein Wahid. I'm with the Advanced Technology Acceleration Program Initiative with the University of Maryland. And like I pointed out, the basic contribution of this initiative is the interactive implementation specifications and standards that provide transformative economic efficiency in multiple fields. It includes adaptability to drive vehicles as well, both the hardware modifications and the software modifications that go with it. But the methodology has proven itself in multiple disciplines, and that is why opportunities that exist where it can be further enhanced or verified present a definite advantage for these programs. So what I wanted to point out was there is an initiative called Equally Able that operates totally independently, self-supporting, and they managed to send devices, equipment all over the world. And so I asked them, how do they manage it? They said just by reaching out, communicating, the advantages of the technology solutions that exist and nothing beyond that. So I think this has great potential, and, we should utilize all existing resources, meaning the voluntary solutions that have been developed, the open solutions framework that exists and does not cost much, but if you work together, quickly there'll be a realization that the economic efficiency is much higher than what was projected before, and you can move these initiatives much faster when you work collaboratively on advanced technology acceleration with open standards. Thank you.
Thank you very much, Mr. Wahid, for your testimony. Do I have any questions from the committee? Seeing none, thank you very much. I'm going to call one more time Lori Barong from the Maryland Department of Disabilities. I do not see her here. If we could just, make sure that we record that we did call for her. And I will also mention that the written testimony from the Department of Disabilities supports the sponsor amendments. Thank you very much. This concludes the hearing on House Bill 1481. We are now going to turn to House Bill 1208. Delegate Alston, if you want to go ahead and come up and bring your panel.
All right. Good afternoon, colleagues. I am Tiffany Alston, delegate representing District 24. I'm here today to present House Bill 1208, public health prohibited food ingredients. You all will remember this bill from last year. It is the red dye ban bill. What's most interesting about the testimony that I've reviewed in opposition is that the same organization has said we should wait for the FDA and they would be happy to follow what the FDA is going to do, has now opposed this bill. That being said, the FDA has taken action and banned these ingredients, and what this bill will do is put Maryland in line with that so that it cannot go back at some later time if the FDA changes its mind. Red dye and other ingredients listed in this bill are harmful and dangerous. They've been linked to cancer, or have been linked to carcinogenics, and people are getting sick from it, including children. And we need to make sure that we are doing everything that we can to keep our state and our children healthy, which is why I'm proposing this bill. California passed this same legislation about 2 years ago. I'm happy to say that this bill has had bipartisan support. And since we had a robust hearing on it last year, I'm not going to belabor the point because the day is late, but I'm happy to entertain any questions that you all may have. I believe there was also opposition about the food labeling portion. I believe that we should, once we ban it, start labeling food while we give the retailers time to get, the manufacturers time to get their ingredients reformulated. So what the label will say is that in some instances, these foods have been linked to cancer-causing agents, so that people and parents can know before they give this stuff to their kids what the possible risks are. And that's all the label portion does. And it gives us time, gives the manufacturers time to reformulate. It gives parents notice about what's going on. And I think it's fair to all the parties. It does not cost much to rejigger your graphic design to put a label on it. And we put labels on lots of things to make sure people are aware of what they're getting into. So it's a consumer protection bill, and it's a bill to make us healthy. I think some people like to say, make us healthy again. So nice bipartisan bill that I hope you all will issue a favorable report for.
Thank you very much, Delegate. Are there questions from the committee? So I have one question you may not be able to answer, but we have some testimony from Jenna Butler that was favorable with amendment, but I don't see what the amendment is.
Yes.
If you could enlighten us.
Actually, like her amendment. Her amendment is pretty smart. What she said was, if we're not able to do a statewide ban, we should ban our school systems from purchasing, which I agree with. I would consider that a friendly amendment to ban the school system from being able to purchase. I think she had another one. Let me find her testimony. And she wanted to expand the ban.
Might have been I was looking at the wrong page. All right, we do have it in our records. I was looking at two of the three, so thank you.
Yeah, so I would say the crux of it is making sure that our school systems can't purchase this stuff, especially since they're using our tax dollars. And then the other was an expansion of what was going to be banned. The part about the school system, I'm totally in agreement with. I would need to look more into the expansion.
Thank you very much, Delegate Alston. We do have an unfavorable panel. We will start with, was there a question? Oh, I didn't even see it. All right, Delegate Shalala.
It was answered.
Oh, it was answered. Okay.
Thanks.
Let me look around again so I don't miss anybody. All right.
Thank you.
Thank you very much, Delegate Alston. We do have an unfavorable panel. We're going to start with Kaylee Locklear, who is in person. Do we have Kaylee Locklear here? All right. Jennifer Gardner is virtual. Do we have Jennifer? Okay. Can we go ahead and bring her up? And then I'll do another call for Kaylee. So welcome, Ms. Gardner. You can go ahead and start your testimony. Oh, I think she's still connecting. Ms. Gardner, can you hear us?
Yes, I can. Thank you.
Okay, you can go ahead and start your testimony.
So sorry. Madam Chair and committee members, good evening. Jennifer Gardner on behalf of the National Confectioners Association and its Maryland-based members. Well, our association supports a rigorous post-market assessment of food and color additives. House Bill 1208 sets a concerning precedent for state food ingredient restrictions through its proposed warning labeling requirement and food ingredient prohibitions, and we respectfully oppose House Bill 1208. As heavily regulated food manufacturers with national distribution networks, our members must follow one unified federal standard operated by FDA. Different laws in all 50 states would severely disrupt the economy. States like Maryland have played a very valuable role in spurring supplemental federal engagement on food additive and color safety. On January 15th, FDA revoked the authorization for the use of red dye 3. Notably, FDA stipulated in its announcement that there is no scientific evidence to support claims that consuming red dye 3 puts people at risk. As available scientific information does not support risk claims, Maryland's proposed warning labeling requirement is unfounded and would generate unwarranted consumer concern for products already being phased out. Temporary warning labeling requirements would inflate product costs, create challenges for multi-state distributors and retailers, and generate consumer confusion over product safety. In addition to FDA's revocation of red dye 3, since Maryland considered similar legislation last session, FDA has now revoked the authorization for the use of bromated vegetable oil, and both potassium bromate and propylparaben are currently under the agency's review. The agency also undertook substantive reorganization late last year to create a new unified human foods program, enhancing the agency's focus on the post-market review of food additives and colors. Supporters of state food and color additive prohibitions have alleged that FDA is not capable of keeping the nation's food supply safe, so states must act. However, recent agency actions refute this narrative, and we respectfully request an unfavorable report on House Bill 1208.
Thank you very much, Ms. Gardner. Are there questions for this witness? Delegate Shalega.
Thank you, Madam Chair. I understand that the FDA has banned red dye 3. What can you tell us about that?
That's exactly correct. So on January 15th, the agency did ban red dye 3, and it is set to be phased out by January 15th, 2027.
So why would you oppose this bill if you're already not going to be permitted to use it?
So the rationale for opposition is really that it's unnecessary in light of the FDA's action, and this bill proposes to put supplemental labeling on packages when the red dye 3 is already being phased out. So it would create a specific label just for Maryland products.
Thank you.
Any other questions for this witness? Seeing none, thank you very much.
Thank you. Sorry. Thank you, Madam Chair. So I assume that the labeling was an interim step that would go into effect before the FDA's regulation kicks in. Is your understanding different? And if that is your understanding, does that not make this more relevant for us to do now?
So it's a very good point. Yes, the label would go into effect before the products are phased out, but it would be in place for a very limited time. And so there would be a requirement for relabeling to occur within a very short time period, putting additional pressure on manufacturers that are already changing their products and reformulating them to address the federal requirement.
Thank you. Thank you, Madam Chair.
Thank you. Delegate Hill.
Thank you. I understand your issue you're raising about labeling individual packages. It would raise other issues, but what if there were just at retailers, there were a sign that said, you know, be aware, red dye number 3, that some products here contain red dye number 3, which the FDA has been deemed to be a potential toxin or carcinogen, so that it wouldn't be on the individual label. There would be a sign at the retailer.
I certainly can't speak on behalf of retail for what their preference would be there, but I think in terms of clarity, that particular evaluation that was done by the FDA did say that the way that the cancer was occurring in male rats was not something that would then be present in humans. So they're not finding a risk assessment for humans. They're just saying as a result of the Delaney clause under the Food, Drug, and Cosmetic Act, they were required to revoke it because anytime there's a cancer risk for humans or animals, that is required to be removed from consumption.
Okay, so that was an explanation of their finding, but you don't have an explanation of whether, from your standpoint, talking about the burden on individual products to carry a label just for Maryland, whether you would object, again, you can't speak for the retailers, to there being a sign, retailers may object to that, that says the same thing, so it wouldn't be on the individual manufacturer or distributor to put it on their product. That's really the question.
I understand the question. I think it's just misleading to consumers to share a warning about a product that the FDA has not necessarily said is safe.
You'd still object. Okay, thank you.
Thank you. Thank you, Delegate Hill. I'm going to take another minute. Oh, there we go. Delegate Martinez.
Thank you, Madam Chair. I have a really simple question. California is already going to be doing some of the labeling, right? Correct? You guys are already going to be required there. If not, I see you're shaking your head no. Could you explain what you guys are doing there since they passed something similar?
So you're correct. California did pass the California Food Safety Act, and it removed certain food additives and colors as a result of that, and that would also take effect in 2027. They then took supplemental action just to focus on colors in school, but I'm not aware of any labeling requirements.
All right, I see no more questions, so thank you very much for your testimony. I'm going to call Kaylee Locklear one more time.
She has food poisoning.
Oh, no. Oh, that is very unfortunate. So with that, we're going to conclude the hearing on House Bill 1208. And if we could just set the record that we did call. And thank you very much for your testimony today. This concludes the hearing on House Bill 1208. We are now going to turn to House Bill 1298. Delegate Martinez, if you want to go ahead and head up and bring your panel.
I'll sit here and you guys can talk on that. All righty. Well, good evening, Madam Chair and members of the committee. For the record, I'm Delegate Ashanti Martinez, here to present House Bill 1298, Health Occupations Practice of Audiology Definitions. This important piece of legislation ensures the audiologists in Maryland can fully utilize their expertise to evaluate, diagnose, and manage auditory and vestibular conditions in the human ear without unnecessary limitations to their practice. You might remember last year we had a very spiritful debate around expansion of scope. We as a policy body decided to do that, and last year was the only bill that the governor had go into law without a signature, and one of the things that they wrote was that they wanted us to come back to the table, figure out some of the kinks, and figure out a better compromise bill. We think we have that with the work product before you. At its core, this bill addresses a critical issue of access to care and professional scope by explicitly including the ordering and performing of in-office non-radiographic scanning or imaging as it relates to auditory or vestibular conditions. House Bill 1298 ensures that audiologists can provide comprehensive, evidence-based care without unnecessary administrative or regulatory barriers. These procedures are essential for accurate diagnosis and effective treatment, and they fall well within the recognized scope of audiology practice. More importantly, these clarifications promote patient-centered care by allowing audiologists to conduct the necessary diagnostic procedures without delay or additional referrals that could hinder timely interventions. Patients experiencing hearing loss, dizziness, or balance disorders deserve streamlined access to the best practices possible. And this bill ensures that Marylanders can receive necessary evaluations and treatments. This legislation has garnered strong support from key stakeholders, including the Maryland Academy of Audiology, the Board of Audiology, and healthcare professionals who are here with me today that are dedicated to expanding access and quality hearing and access to quality hearing and balanced care throughout the state of Maryland. Their advocacy highlights the necessariness of modernizing the legal definition of audiology practice to reflect current clinical standards and best practices. For these reasons, I respectfully urge the committee to issue a favorable report on House Bill 1298. I will add before the committee, my panel continues, that there will be amendments to the cross-file of this bill before the Senate on Wednesday. I am not in support of those amendments, and so I hope that we can work through a real compromise that includes everyone at the table. And so with that, I give it over to my panel.
Thank you, Delegate Martinez and the HGO Committee for your landmark legislation that you passed unanimously last year. Gil Jen on behalf of the audiologist. I believe the only real substantive issue before this committee is the question whether the phrase third-party payers is essential in the bill, and it absolutely is. And here's why. Medicare is federal. Medicaid is state. But Medicare Advantage plans that have health screening requirements are private programs administered by third-party payers, not solely federal or state agencies. And appended to my testimony are about 50 references to the phrase third-party payers in the Health Doc, General, and Insurance articles. One of the statutes says under insurance, it says a healthcare practitioner means a person that is licensed under the health occupations article and reimbursed by a third-party payer. In the dental scope section 4103, an individual licensed by the board to practice dentistry interacts with patients and third-party payers. And in the physician statute 14404, titled Denials, Reprimands, Probations, and Suspensions and Revocations, the physician can be punished if they fail to disclose to the patient or third-party payors lab tests or payments to the lab. So if physicians can lose their license for failing to disclose payments to a third-party payer, that's all part of their scope of practice. So it's totally illogical that the ENTs would have us lose our reimbursements if we fail to perform health screenings mandated by the third-party payer. The Hippocratic Oath says do no harm. If you eliminate third-party payer language, that's exactly what it will do. We ask for a favorable report unamended. Thank you.
My name is Dr. Alicia Spohr, Madam Chair in HGO Committees. I'm here with strong support for House Bill 1298, particularly the inclusion of third-party payers in conducting health screenings, which is still being debated. Audiologists are mandatory providers of Medicare Advantage plans administered by third-party payers, including Blue Cross, United Healthcare, Aetna, and Cigna. Medicare has threatened for years to include mandatory health screenings in Advantage plans, and United Healthcare already references that all plans have preventative screenings. The screenings required by federal and state and third-party payers are often identical, which may include stroke screening, urinary tract infection screening, blood pressure health screenings prior to any hearing or balance testing being conducted. The third-party payers will often adapt the same requirements as the Medicare regulations. The opposition seems to be okay with the audiologists completing health screenings if they're required by federal and state payers, but not when required by third-party payers, even though they're almost always exactly the same health screenings. That seems a little bit irrational and unreasonable. If audiologists are not explicitly permitted to perform health screenings required by third-party payers by statute, they risk financial penalties on all claims in a calendar year, not just those who did not receive a health screening. The clause third-party payers is crucial in this piece of legislation for that very reason. We have an opportunity to build on the 2024 progress with House Bill 1298 to ensure patient access and affordability and prevent penalties to audiologists, and to continue to set an example for the multiple other states who are modernizing their practice of audiology statute, including Arkansas, who just passed the original 2024 language submitted by Delegate Martinez without amendments last week. Thank you, Delegate, for your commitment, and I request a favorable report on this piece of legislation.
Madam Chair and committee members, my name is Dr. Melissa Segev, and I am in full support of HB 1298, which should continue to permit audiologists to order blood work and cultures as it pertains to the auditory and vestibular condition. Audiologists are not interpreting blood work or cultures, rather we're ordering when needed for better patient care. Blood work can aid in screening for systemic diseases that can manifest in the ear, either with hearing loss or dizziness. Balance disorders may be caused from metabolic or hormonal disorders. Medications can cause hearing loss, tinnitus, and dizziness. Continuing to order appropriate labs without having to refer the patient elsewhere results in better patient care and lower healthcare costs. Performing cultures is rare and not something routinely performed for ear-related pathologies. This also applies to medical physicians. If a patient is not healing from standard medical treatment, cultures are an important part of differential diagnosis. For those patients, having test results ordered in conjunction with an appropriate referral can save the patient time and provide more exact medical treatment for the managing physician we refer to, not to mention what type of provider we refer the patient to. As clearly stated in legislation from 2024, audiologists do not perform surgery, utilize a scalpel or needles. Unless someone is not healing from an infection, rarely are middle ear cultures even performed. The middle ear is not accessible unless you use instruments which are excluded from the audiologist's use under the current bill, and they would not be performed by audiologists as this is not in our scope, nor is it permitted under current law. HB 1298 specifically lists what audiologists cannot do, surgery. The area audiologists would culture, if necessary, is accessible from the tympanic membrane, which is the eardrum, to the outer portion of the ear. I brought a little diagram if you wanted to see. This is the eardrum and this is the outer ear that patients access using a Q-tip and sometimes even push it in too far. This is non-invasive and does not cause harm. Thank you, Delegate Martinez, for the ongoing support of audiologists and the patients we serve. I ask for a favorable report on HB 1298. Thank you.
Thank you very much for your testimony. I'm going to open it up to questions. Delegate Hill.
Thank you. And thank you, Delegate Martinez, for doing the work. I appreciate you. Mr. Gill, you've got I'm reading this. It says the conducting of health screenings required by federal, state, or third-party payers. Federal and state payers, as I understand it, they may make requirements. Third-party payers cover it or reimburse it. And I think the issue isn't the inclusion of third-party payers, it's that it says as required by third-party payers. Am I missing something? Why can't it be required by federal, state, or covered by third-party payers? Why is it required by? They don't make diagnosis.
Respond to that.
Yeah.
Thank you, Delegate. First of all, I don't know about you as a physician. As audiologists, we're not receiving any type of coverage reimbursement for any of the screenings we're completing. What is happening is that Medicare, Medicaid, Medicare Advantage is requiring us to do a screening before we do hearing, vestibular, tinnitus, eval, in order for us to get paid for that hearing test, tinnitus, or vestibular eval. So for example, we have to do a depression screening before we can do a tinnitus evaluation in order to get paid for that tinnitus evaluation. So our issue is not around the federal or state, it's actually around the third-party payer because, as you well know, United Healthcare is administering the Medicare Advantage plan. Aetna is administering the Medicare. So we need that third-party payer included.
Right.
Maybe I misunderstood the question.
I think we can include it. I think the problem is the use of the word ahead of third-party. They're the ones who are covering it. But when they require, third parties don't require testing.
Third-party, just
or screening. They're following the federal. It's the federal government that's requiring it. We want them to reimburse you for it.
We're not asking for reimbursement. We're asking for, let me back up again.
Okay.
We're not asking for reimbursement of the actual screening test. What we're asking for is reimbursement of the auditory and vestibular tests that we would bill, like a hearing test, a balance test, positional testing. But especially in the United Healthcare Medicare Advantage plan, there are certain screenings, preventative screenings that we have to do.
I see what you're saying.
Okay, so I'm not quite sure you understand what I'm saying now. So in order to to be paid for the tinnitus evaluation, I have to do a depression screening.
Right.
I'm not asking to be paid for a depression screening, but because United Healthcare says I have to do a depression screening, if I don't do that, then I get penalized in my payment for that tinnitus evaluation
So it
because I
might
didn't
be,
do it.
and maybe we can talk about it, it might be that it's as required by third-party payers in compliance with federal regulations. Because I think the concern was that we don't want third-party payers to be dictating healthcare. And the way it's written, it looks like we're opening a door for third-party payers to be dictating.
Do you mind if I have Mr. Jen make a comment on that around some of the amendments that we had talked about with MedCai about rather than
Well,
putting...
they'll be up.
Okay, okay. Because I do know at least in his written testimony.
I don't think
there
it's
was
an
some-
issue of the goal, I think it's an issue of the language.
And maybe there's a better way of drafting it. I just want to make sure that we're not stuck on the federal because the Medicare Advantage is administered by third-party payers, and so they're putting in our contract some of those requirements. And we want to make sure that if United Healthcare says we have to do X to see a patient, but Medicare doesn't say you have to do X, but United Healthcare does under Medicare Advantage, then we want to make sure that we as audiologists are in compliance and can do what Medicare Advantage says.
Gotcha.
Does that
Thank
make
you.
sense?
Yep.
Thank you for that clarification, and thank you for understanding what I'm trying to convey. I appreciate that.
Thank you very much. Questions from the committee. I have a follow-on question, actually, to further clarify, because I'm looking at the language of the bill, and I think the confusion is, the reference is required by federal, state, or third-party payers. I believe that that would mean required by federal payers, state payers, or third-party payers. So the federal and state references are not to the guidance, they actually are to the payers. Is that correct?
I think the answer is yes, and interrupt me if I'm wrong, because the federal payer, sorry, Delegate. Oh, that's okay. The federal payer is Medicare, the state payer is Medicaid, and then the third-party payers are all of the individual contracts that we have with Blue Cross Blue Shield, Aetna, Cigna, United Healthcare. So for example, one of the contracts, which is not mine because I don't participate, this is United Healthcare Medicare Advantage, and it's, again, this is included in our written testimony, but it says all United Healthcare Medicare Advantage plans, right, cover the following Medicare covered preventive services. And then it lists these services, and some of them apply to when you have to do them for audiology testing.
Thank you. That does help bring some clarity. And Delegate Martinez, you had mentioned, am I correct, that this was the consensus bill as far as you understood?
So it's a start, right? We've had conversations from the start of session, trying to bring everyone together. We knew coming up with the hearing we weren't going to be quite where we needed to be, and there were still some finalized conversations that need to happen. Then we found out today that there was going to be some amendments to the Senate on the cross file. I hadn't been asked or contacted around that. And so from my understanding, we are still very much in conversation. I take my guys from these people over here, and they weren't very happy. And so until we're all happy, I'm not happy. So
Thank you. Thank you, Delegate Martinez. Any, Delegate Taveras.
Thank you, Madam Chair. I'm not sure if this was already addressed, and I apologize if I'm re-asking the question, but it was my understanding that the removal of third party would have cleaned up the language. So people are not satisfied with that on this particular panel?
I think the issue revolves around how audiologists are classified within the Medicare system. Because we're classified as diagnostic suppliers within Medicare, dated back to the 1960s, and I promise I'm answering your question without a history lesson, we cannot opt out of Medicare. So we are mandatory Medicare providers. Because we cannot opt out of Medicare, we also cannot opt out of Medicare Advantage, which is a program administered by a third-party payer. That's not technically a federal payer. They they are administering services on behalf of Medicare, but once the patient opts for that Medicare Advantage plan, they forfeit their federal Medicare payment in lieu of that privatized insurance, who may offer them more services, more benefits, discount plans, et cetera. So because audiologists are required to participate in that Medicare Advantage plan, and those plans are administered by third-party payers, that's why we're so concerned with having third-party payers there, because we don't want our reimbursement to be affected just because we can't do a pass-fail health screening if it's required under their system. Did that answer your question, Delegate?
So, no, I think that what's needed then is to have everybody at the table and have a conversation of how you can resolve this issue, which is where you had mentioned prior. Thank you.
Thank you, Delegate Taveras. I'm looking for any other lights because I keep going too fast. All right, seeing none, thank you very much for your testimony. We do have one favorable with amendment panel, and that's Ashley Bagwell. Go ahead and get started whenever you're ready.
Good afternoon, Madam Chair and members of the committee. I'm Ashley Bagwell here this afternoon on behalf of MedChi in support of House Bill 1298 with amendments. I'd like to thank Delegate Martinez for introducing this bill and the committee for allowing us to revisit this issue one more time. We had a number of issues with the bill that passed last year, which is perhaps not a surprise to anyone. I did also want to reference the letter that the governor wrote in the spring of last year, highlighting some of the broad provisions in the bill. I think that the changes that we are seeking address some of the governor's concerns and attempt to address some of the most important concerns that we had. Very quickly, on page 2 of the bill, lines 1 through 2, this language was in the bill as introduced last year and struck, so it did not appear in the bill as it passed, and so we would simply ask that that language be struck again. You've already heard a lot of back and forth on the inclusion of the third-party payer language, and Delegate Hill, I think, your questions hit to what our issue is here. We do not have any issue with language that allows audiologists to be reimbursed through the MIPS program as they described. I think the way that this language is in the bill allows third-party payers unusual authority over a scope of practice. I know that Mr. Jen referenced several parts of the health occupations article where third-party payers appear, but it does not appear in a scope of practice in this way. Lastly, lines 24 through 25 of the bill, we do still have concerns about inclusion of language that allows for collecting or ordering of blood work and cultures. Just very quickly, I think that Madam Chair, if I can just finish my sentence, that if something is serious enough to require culturing, then that partnership or relationship with the physician will be necessary anyway, and so we would request that y'all would give that language a little more thought as well. Thank you, Madam Chair, and with that, I'm happy to answer any questions.
Thank you very much for your testimony. All right, I'm looking for questions from the committee. Seeing none, I have a question. Are these the amendments that were referenced in the Senate testimony, or are these amendments that you have presented to the bill sponsor in the various stakeholder meetings?
I know that there are Senate amendments. I've not had a chance to look at them yet, so I don't know if they match up with these. I'm happy to report back once I have a chance to look at those.
Okay, thank you. If you could report back to the sponsor of the bill.
Yep, of course.
Committee. Any further questions? Seeing none, thank you very much. Oh, Delegate Hill.
Same question.
Too fast.
You said that is the issue. Do you have a suggestion about how to address their issue? As I understood it, that third parties are requiring that they do this test. It's not a reimbursement thing, but they're requiring it be done. Is the problem that it's in the practice of audiology section and there needs to be a separate section, or what is the alternative that you're suggesting and that you and Mr. Jen are going to talk about?
I'll have to think some more on that. I think the way that this reads allows third-party payers to dictate to providers what health screenings to do. And so that's our issue, that remains broad, and
their testimony
they could require any health screenings.
Their testimony is that's what they're doing, that they are dictating that before you do the thing we'll pay for, you have to do a screening.
I understand that that's what they're doing. I think our concern here is that in the scope of a provider, it is saying that third-party payers can require health screenings.
So that the issue might then be that we need to, if that's what they're doing, we have to tell them they can't do that.
Understanding that I'll say this. We understand what their concern is. I think we want to be able to address their concern without including something in the scope of practice that sets a precedent that allows third-party payers to have say-so over what a provider's scope of practice is, because that is unusual and isn't done anywhere else.
Thank you.
Thank you, Delegate Hill. I'm just looking again. So I am going to ask that you think about this quickly, because we are very time sensitive, as everyone is aware. And we currently have two bills that are moving through the chambers not aligned. So it is very important.
Understood.
Giljen is right there in the audience. I'm sure that, that you, if you could exchange calendars, like at the end of this hearing, and make sure that we're having those conversations and get back to the bill sponsor in this committee.
Absolutely.
As swiftly as possible. Thank you very much.
Thank you.
And with that, this does conclude the hearing on House Bill 1298. We are now going to turn to the last bill of the day, last but not least, and this is House Bill 1449. Delegate Szeliga, if you want to go ahead and bring up your panel. And I also want to take this opportunity to thank Matt and the Priegel family farm for the amazing charcuterie platters that you offered to this committee. They were very much appreciated, and they've kept us all upright through this very long day. Delegate Szeliga, I have on your panel Liz Rietzig, Matt Priegel, and Steve Belkoff, and then we've got another group after that.
Yes, we're here, present, and accounted for.
All right, perfect. Go ahead and get started whenever you're ready.
Thank you, Madam Chair. For the record, Delegate Kathy Szeliga here today with House Bill 1449, Public Health Milk Products Direct-to-Consumer Sale of Raw Milk for Human Consumption. This is a pretty simple bill. It allows for safe and limited sale and consumption of raw milk to consumers by farmers at farms. It's very intentional. So we're not talking about walking into the Giant or the Safeway and accidentally buying a gallon of raw milk. You will have to intentionally, as a consumer, seek this out. And the bill, I think, is 16 pages long. It has quite a bit of safety measures in the bill. And other states are doing it. We are not creating the wheel here. And we're actually allowing legally today for the sale of raw milk for pets. So that is going on. And, we haven't had any problems to date on that. So with that, I'd really like to turn it over to my panel, who are the experts on this issue. So with that, I'll turn it over to Liz.
Well, thank you. Good evening, Madam Chair and members of the committee. My name is Liz Reitzig, and I am here in support of HB 1449. I believe I speak for all of us when I say we want a safe and secure food system for all Marylanders. You're about to hear concerns over bird flu and foodborne illness in raw milk. While we must be careful to take real risk seriously, we must be equally mindful not to allow exaggerations, hype, and corporate greed to sow fear and division at our tables. In a conversation with the Health Department just last Friday, They shared that so far, and with extensive testing in place, there are no positive bird flu cases in Maryland's dairy or milk, or dairy herds or milk. And yet the divisive fear runs deep. It reminds me of the story of Crossroads America. The May 1945 edition of the Coronet magazine, a popular women's magazine, features a cover article that raw milk can kill you, complete with an illustration of skull and crossbones. And it was about the town of Crossroads, America, where there was a deadly outbreak of undulant fever. The author targets women, warning mothers how dangerous it is and how terrifying it was. 1 out of every 4 patients died, and it was more poisonous than the toxin strychnine. How frightening. If I were a mother in 1945, I would be terrified too. But there was one big problem. It was completely fabricated, a diabolical lie made up to change women's buying behaviors and artificially inflate corporate profit for the dairy farmers while the small farmers struggled. But the fear hit its mark, and women began to reject a major staple food: clean, safe, raw milk. We can do better than basing 2025 laws on 1945 lies and the generational fear propagated by those lies. Raw milk is an age-old, multicultural food, and access to safe raw milk from Maryland's small farms supports Maryland's food security, which we all want.
Good evening. My name is Matt Priggle. I'm a 5th-generation dairy farmer. Farms in Maryland of all sizes, practices, and trades are up against the wall. Right now, farms are facing increased regulations, an energy company attempting to seize active farmland, loss of market autonomy, and much more. According to the Maryland Dairy Industry Oversight and Advisory Council, last published report in 2022, they highlight the rapid decrease in the Maryland dairy farms. According to the report, in 2021, the Maryland Department of Health regulated 322 dairy farms. By 2022, 10 farms went out of business, leaving only 312. To make things worse, from 2012 to 2022, Maryland lost 193 dairy farms, averaging about 19 a year. The Maryland dairy industry is in a serious crisis. With the support of HB 1449, it can give farmers the opportunity and potential and alternative to co-ops and major dairy processors by allowing them the option to set their own prices and sell direct to consumer without the extreme financial burden and risk of building their own processing plant. It can also greatly lower the financial output to simply start a farm, a new farm. With the barrier of entry being lowered, hopefully more people will pursue the opportunity to start a farm. Many farms other than dairy are pursuing value-added products to help sustain their farms. Raw milk would be another product they could add, helping dairy farms while also helping meat and produce farms that have farm markets and stands. Raw milk is simply a tool, a metaphorical tide to raise all of Maryland's agricultural industries.
Thank you. My name is Stephen Belkoff. I'm a professor at Johns Hopkins. While my work at Hopkins informs my testimony today, I want to make it clear that I'm here on my own behalf. I'm perplexed at the attention raw milk gets from our regulatory agencies. Several years ago, a colleague and I discovered that when certain immune cells, PDCs, were exposed to raw milk, they produce surprising amounts of anti-inflammatory cytokines or cell messengers. Why is that important? Because many of the diseases in our society are associated with chronic inflammation: asthma, allergies, osteoporosis, cardiovascular disease, and others. Finding a potential way to stimulate the natural production of anti-inflammatories, we thought, could have a profound positive effect on public health. We proposed a clinical trial to investigate if what we saw in the laboratory carried over to the clinic. As part of the clinical trial approval process, the Hopkins legal team had to get input from the Department of Health and Mental Hygiene. We were shut down. I was told that I could get a humanitarian exemption to conduct a clinical trial using crack cocaine, but if I used raw milk, the state of Maryland reserved the right to pursue Hopkins legally. Seriously, raw milk is more dangerous than crack cocaine. There's no doubt that raw milk poses some risk, but so do many other things. If you look at the Foodborne Illness Outbreak Advisory from the FDA, there's a host of foods that are considered risky. Last year alone, 2024, the list starts out with cucumbers, carrots, onions, eggs, chocolate bars, cucumbers again, organic walnuts, and on it goes. We don't ban the sale of fresh cucumbers or carrots or require that they be cooked before being sold to the public, so why should it be any different for raw milk? I only ask the committee to ignore the fear-mongering and respectfully consider the real risks and benefits of raw milk.
Thank you very much. I'm going to open up to the committee. I'm going to start with Delegate Woods.
Thank you, Madam Chair. My question is for Liz. I actually have two questions, Madam Chair. Thank you. My first question is, can you tell us why milk was ever pasteurized in the first place? And my second question is, why does milk have to be refrigerated?
Okay. Well, we started pasteurization, actually, it came from a policy in America in the late 1800s where the whiskey makers were using the waste from the distilling process to force feed cows that were kept in confinement in the cities near the distilleries. And this is the abbreviated version. So these cows were kept in horrible conditions. There was very poor sanitation in those cities at the times. We're talking specifically Chicago and New York. And the transportation, there was not refrigerated transportation, no closed milking. The cows were unhealthy, and it was really terrible, terrible quality milk. We have a term for this. It was the swill dairies or the distillery dairies. And there were two campaigns. One was a campaign from the co-owner of Macy's department store, and he advocated for mandatory pasteurization of that milk. Whereas another commission of doctors called the Medical Milk Commission, they advocated for actually feeding our children clean milk and getting it from the surrounding farms like Priggle's Family Creamery. And the pasteurized milk, it was subsidized by this very wealthy businessman, and that eventually won out. The mandatory pasteurization laws began in Chicago in 1908, and then they've just trickled down. And then with the publication of this story in 1945, this was another domino that just broke and made the mandatory pasteurization the thing, with fraudulent stories just like this that got picked up by other women's magazines, by Reader's Digest. That precipitated the mandatory pasteurization laws.
The second question was, why does milk have to be refrigerated, or does milk have to be refrigerated?
Well, listen, I'm a huge proponent of raw milk. I've been drinking it for over 20 years now, daily. I raised my 5 children on raw milk, never an illness. And I don't always refrigerate it, because what you get from raw milk, the natural fermentation process, is that it turns into a product similar to yogurt. And then if you don't refrigerate it for longer, you get something very similar to natural ricotta or cottage cheese. However, a lot of people, including me, I love to drink it fresh and tasting like milk. And so if you keep it really cold, if the milk is clean to begin with, it will last a good 2 to 4 weeks, kept at 34 to 36 degrees.
Thank you so much. Thank you, Madam Chair.
Delegate Kipke.
Thank you, Madam Chairman. I forgot your name. I apologize to the gentleman all the way to the right.
Oh, Steve Belkoff.
Thank you, Steve. Could you remind us who you are, and then answer this question? How do the risks of drinking raw milk compare to other things?
It depends on what papers. My name is Steve Belkoff, and I represent myself, but I am faculty at Hopkins. How does it compare? Well, it depends on what you read. There is one study here, for example, there's a higher risk, a notable risk, higher risk of consuming raw dairy. But that typically results in some gastrointestinal systems, perhaps hospitalization. In that same study, however, if you look at the raw milk, if you look at the comparison group, the pasteurized group, right, pasteurized cheese, there were 16 deaths in this cohort, 15 of which came from the pasteurized cheese group, not from the raw milk group. So you have to dig deep into the data, and unfortunately, I don't have a a clear answer for your question, a succinct answer. I'm not sure one exists because everybody comes to the table with their own agenda.
Well, could you share with us some examples of things that are legal? You just mentioned pasteurized cheese, but some things that are legal to consume. Things that come to mind for me are raw oysters.
There's a whole list. I can give you a quick rundown here from the FDA. Just give me a second. So you have, as I mentioned, cucumbers. So there's cucumbers, carrots, onions, eggs, chocolate bars, organic walnuts. There was basil. There is a report of an outbreak with raw cheddar cheese, but actually if you dig into it and read the FDA's website, there was no E. coli found in that cheese that they claim was the cause of the outbreak. So there's a bit of a skewed report. Queso fresco, which is also a cheese, peaches, plums, nectarines, cantaloupes, applesauce, onions, ice cream, raw cookie dough, morel mushrooms,
So not
flour.
to interrupt you, but would you say that raw milk poses a greater threat to public health than any of those things?
I don't think so.
Thank you.
Delegate Hill.
Thank you. It's good seeing you all again. And I guess I want to make sure, Ms. Smith, that you weren't suggesting that because there's no bird flu now, we shouldn't be worrying about it and that we wait until things break out, right? That
To
wasn't
me?
yeah, you had suggested in your testimony that there are no, in other words, that to be afraid of bird flu is not a reason to want to have, whether it's a ban or a prohibition or safety standards. That's not what you were trying to say, right?
I think I understand your question, and I think that right now with the concerns that we have over bird flu, our health department and our Department of Agriculture are managing it. They seem to be doing a fantastic job because we have 0 cases of it in our dairy herds and tested milk, and they are testing. So I think that it's something that we have to be aware of and be mindful about, but not exaggerate the risk of just to shut down something that people clearly want and are clearly getting from maybe less desirable sources.
All right. May I ask a question of the sponsor? Delegate Shalega, thank you for the bill. Did you read the Maryland Veterinary Medical Association's testimony?
I have not read that yet.
All right. So if I may, they basically are offering some fairly significant, I think, amendments to the bill, and they're pointing out that herds are not static, and that even though I think the bill has a testing prior to a permit being issued and then at least once a year, they're suggesting much more rigorous testing when a cow gets added to the herd, testing for brucellosis and tuberculosis and other kinds of things, which sound to me pretty prudent. So I just would be interested when you get a chance if you could read that, because you're good today, therefore you're good for another year, doesn't quite seem to make a lot of sense either.
Yeah, but the bill does have, and I think the reason they didn't oppose the bill, didn't they just come in as information?
Yeah, but it's a lot of suggestions about how to do a better job.
Make it safer. But and of course, you know, the Priegel Farm, other farmers, they want to make it safe, and it's going to be very limited, the number of farms that are going to want to engage in this program, because if you read the bill, it has a lot of testing and regulation and permitting, but certainly I appreciate that. Delegate Hill will take a look at that and see, you know, what we could entertain with those amendments and potentially make the health department happy. I'm not sure we'll ever make the health department happy, but
well, their job is to be safe, not happy. Right?
Yeah, so. Yeah. But the flip side of that coin is we have people today selling raw milk on a black market, which when I first heard that, I'm like, what? Is there like a milk mafia out there? And yes, there are people that are buying raw milk from
other states, Pennsylvania,
and
right?
other people, and it is not regulated. So, you know, folks who want to purchase this, again, my body, my choice, you know, nobody's making you. It will be more expensive, harder to access. You know, why not give them a product that we feel is safe? And, you know, you all know farmers. There's nobody that cares about their animals more than the farmer. So, you know, we don't have, yeah, there's always some bad actors, but they're not going to get involved in this practice, I don't think, because the amount of testing and checks is much more rigorous.
And if I may ask a final question? Thank you, Madam Chair. The bill also excludes certain size farms, and this does not apply to farms with fewer than a certain number of cows. What is that about? Let's see, it does not apply to.
Go ahead, yeah, Liz can answer that.
Yeah.
Yeah, that's basically just an exemption for personal use and people who would be interacting directly with neighbors or a communal type of situation where they're not going to register anyway, and it just makes sense for there to be an exemption for really hyper-local micro dairies.
All right, thank you. Thank you, Madam Chair.
Delegate Alston.
Thank you, Madam Chair. I was just wondering, do you know approximately how much raw milk is being currently sold?
How much are you selling per year? You're selling it for?
Are you asking on the black market or legally in the state?
Well, I would say how much raw milk is being sold with the pet warning that this is pet food?
Yeah, I'm aware of 4 farms in the state right now that are selling it.
4? I didn't hear you.
4 farms.
4 farms?
Yeah.
Okay. All right, thank you. So is it like a lot or a little, like, I'm just trying to.
I couldn't say for them. I can only speak for myself.
Okay.
Right now, our raw milk for cats and dogs is about on par for the sales in comparison to our whole milk.
Okay, great. Thank you.
Yes, ma'am.
Other questions from the committee? I have a question. I think this is for Ms. Rietzig, just because you had mentioned that, you know, the Department of Health, the Department of Agriculture are managing the H5N1 outbreak, but both the Department of Health came in unfavorable. The Department of Agriculture came in with a letter of concern. Given that the 2 regulatory entities seem concerned about this, how do you respond to that? I want to give you that opportunity because obviously you're not going to be able to respond to their testimony.
Thank you, thank you. This bill has come up in various forms in years past, and the health department has always opposed it. And there was no bird flu 10 years ago that was a concern, I should say. And in conversations with them, they have expressed that there are no change of circumstances, including if bird flu is not an issue in a year, in 2 years, if it's not a serious issue, there are no changes in circumstances in which they would not oppose this. So, yeah, there's that concern is being brought up because it's here this year, but it's also not the thing that's their deciding factor.
And the Department of Agriculture?
I would say that this committee can be in touch with them with any questions they have about their letter of concern or their specific policy on this.
Thank you. Thank you very much. I'm just looking to see if there's anyone. All right, I don't see anyone else, so thank you very much for your testimony. We have two more folks from the favorable panel. I have Tyler Huff and Mary Bowen.
Madam Chair, members of the committee, for the record, Tyler Huff, Maryland Farm Bureau, and here today in support of HB 1449. As you heard the stats from Mr. Pregel earlier, the dairy industry in Maryland is struggling and we're losing farms every day. A big reason to that is the fact that farmers in general are price takers. We're not price makers. This is a rare opportunity where there's a little more of an opportunity to be a price maker with the allowance of raw milk with direct sales to consumers, especially when we're talking talking about supporting our small local farms, our small local value added, and the emergence of value added. As we continue to see struggles throughout all of agriculture, and ag looks for a way to diversify and find new opportunities to keep these farms as farms, to keep their families in agriculture, to keep their operations up and running. To give some price background here, according to the last census and University of Maryland Extension stats, for somebody under a milk contract with a co-op that sells their milk directly to those co-ops, they're looking at roughly $25 a hundredweight. Milk is sold in hundredweight, not gallons. To compare that on the raw milk side, if you're looking at raw milk nationally, roughly sells for $6 a gallon, which if you're going to compare that to hundredweight comes up to roughly $73 a hundredweight. So there is a considerable opportunity from a financial standpoint here for those that are going to sell raw milk. I know it's not going to be a lot. It's going to be regulated. It's going to be very small and very specific, but there is a financial opportunity here for the farmers, for the dairy farmers in the state to continue to diversify their operations, to look for a new value-added opportunity, and potentially keep those farms in the family and in agriculture for the state. We request a favorable report and happy to answer any questions. Thank you.
Good afternoon, Madam Chair and members of the committee. Good afternoon, Madam Chair and members of the committee. My name is Mary Bowen, and I am the farmer behind Prosperity Acres in Calvert County, a multi-generational farm dedicated to ethical, sustainable food production. I stand before you today in strong support of House Bill 1449. We already have the ability to sell raw milk as pet milk in the state of Maryland, but let's be honest, I know there's customers that are buying it to drink for themselves. I cannot talk to them. It is a real, legal, and safe choice to buy it as pet food. But when you're buying it as pet food, I can't answer any of your questions that you have about the safety of the milk and how it's taken care of I have it as cow milk. I don't sell, I sell it as goat milk. I don't have cows. And when it leaves the cow, I can't tell the customers what's happened to it because I'm selling it as pet food. I am not allowed to talk about any of the process. So it leaves the customer wondering, why can't she talk to me about it? They're asking me questions and I can't answer them. All I'm allowed to tell them is, I drink it myself, my family drinks it. To me, that feels very sketchy. I want to be able to tell someone why it's clean, healthy milk, but I can't. I stand there before the moms and I can't answer them. The families that come to me that I know that are buying it for their dogs, I can tell them all they want to know. That's pretty sad. Meanwhile, the illegal raw milk trade that's pouring into our state, that milk, we don't know whether it's tested or not. That's illegal. That's a public health risk that concerns me as a farmer. Legalizing and regulating raw milk for human consumption protects consumers, supports local agriculture, and keeps dollars here in Maryland rather than pushing it underground and across state lines. Thank you, Madam Chair and the committee.
Thank you very much for your testimony. I'm looking for questions from the committee. Delegate Alston.
Yeah, from the Farm Bureau, right? So if this were to be legalized, would we tax it like we do everything else?
I would have to get back to you on a 100% sure answer on that. I don't want to misspeak, but I would venture to say it's being sold. I don't believe that those that are selling value added have that tax exemption. Ms. Owen might be able to answer that better than I can, but I would assume there would be some sort of tax that is put on the milk.
Okay, currently the pet milk that you sell, is there a tax requirement for that?
No.
No, okay, thank you.
No, it's sold as pet food, so there's no tax on it.
Okay, thank you.
Thank you. Delegate Shalega.
Thank you. Yes, Delegate Alston, we don't tax food, so Don't give anybody any ideas. For the Farm Bureau. So if this bill were to become law, tell us about other value-added things farmers could do with that milk.
Absolutely. So our value-added industry is large. We can incorporate things such as beer, wine, making grapes into jelly, and tomatoes, and the whole 9 yards that can be manufactured from that standpoint. So when you talk about value added, it's taking the product and making it into something else before you sell it. So we can look from the standpoint of adding cheese, yogurt, ice cream with that raw milk side on it rather than having to go through the pasteurization steps. So it would be a value added product in itself, but still opt for other opportunities within that scope within the dairy products realm as well.
So soft cheeses, I understand that, are ready before 30 days could be.
Yes.
Like this charcuterie board. Thank you.
I do have a question, but I also wanted to clarify the record that we will hear from the Department of Agriculture later, but they are signed up for information, though the letter says letter of concern, but I just want to make sure that the record is clear. Apologies, let me get, Ms. Bowen, you had said that you can't talk about what the process is with your clients, even if they're asking about how they're getting the milk delivered, like what that process looks like. You're not allowed to discuss that, even if they're buying it as pet food?
Correct. We're not supposed to be talking with them about any of it. It's very strange to me. The only thing that the Maryland Department of Agriculture tells us that we're allowed to talk about is that we consume it. So I take a risk every time I talk to someone and I tell them what my cleaning process is, what the care of my goats are, and if someone turns me in, then I take that chance of having my permit pulled from me. But I don't want to be seen as a sketchy farmer, so I do it anyway. I tell them how our milk machines are cleaned, whether we give vaccinations or not to our goats, the testing that they get done yearly, meaning although Maryland is a brucellosis-free state and tuberculosis-free state for our animals, we still do that testing so that, again, I tell people this is what I do, even though I'm not supposed to. We're just supposed to not talk about it because it's labeled as pet food, and that's it. It's a very sad situation. I think that we should be allowed to have open conversations about it, because if someone's going to feed it to their family, they should be able to ask any question that they want direct to the farmer. I love being able to sell direct from my farm. And for a while there, as Tyler just talked about with the value-added products, I was selling pet food cheese because that is a snack for a dog. And I was selling ice cream. And unfortunately, again, I wasn't able to talk about any of it.
Just to clarify, so you can't talk about any of the processes on your farm?
Oh, I can talk about all the other processes. They don't want you to talk about anything that could lead someone to think that it's okay to purchase it for human consumption.
Okay, thank you for the clarification.
You're welcome.
Delegate Hill.
Yeah, I want to, and I'll ask the department also, are you saying that if I'm not interested in using it for myself, I really have no right to ask you for my dog what your processes are? I mean, you're saying that even if it's for my dog, you can't answer a question?
I didn't say that it's not your right to answer that question.
That you can't answer it?
I cannot. I'm not allowed to give you any sort of response that could lead you to think that you could consume it. So that's why the only thing they want us to refer to is that we consume it ourselves daily.
All right, thank you.
You're welcome.
All right, seeing no other questions, thank you very much to this panel for your testimony. To be balanced, We're going to go to an unfavorable panel, then we'll go back to favorable, because we've got a favorable with amendment. So if I can bring up Clifford Mitchell, Zach Myers, Nilesh Kalyanaraman, and that's virtual. And then also on this panel is Megan Davis, but she's virtual. And when you're ready, you can go ahead and begin your testimony.
All right. Good evening. Chair Bagnall, members of the committee. For the record, I'm Dr. Nilesh Kalyanaraman, the Deputy Secretary for Public Health at the Maryland Department of Health, here to testify in opposition to House Bill 1449. Raw milk. We're here to talk about something that we have a safe product for, which is pasteurized milk. We've had that for decades and decades. And our real interest in being here is to maintain the safety of our food supply and make sure that people are as free from disease while they're consuming these products, right? Raw milk may contain harmful organisms. That is why pasteurization was implemented in this. The right comparison between raw milk is not with cucumbers or carrots or any other product. It's with pasteurized milk. And we know from decades of experience, from studies, that frankly, pasteurized milk is much safer for consumption and has the same health benefits. This is why food safety regulations exist, not just for milk, of course, but for a wide variety of food products. We see that there continue to be outbreaks, particularly in states where raw milk is legal for sale. In fact, just in the past year, we've had inquiries about raw milk sales, either sales or consumption in Maryland, that sickened some people in West Virginia, right? We have a safe product. We want to keep people safe. That is the reason we are here in opposition to this. You know, somebody had mentioned that, you know, we've done raw milk testing for bird flu for the HPAI. Yes, we're doing that. But frankly, that is just an added concern that we have at this time, but it is not the sole basis for our concern, right? We have to do ongoing testing and monitoring, and particularly concerning with bird flu is that the virus is transmitted precisely through milk products. And so for that reason, I'll stop here. I'm going to turn it over to my colleague, Dr. Clifford Mitchell, to talk a little bit more about some of the data and some of the specific details around raw milk and pasteurized milk.
Good evening, Chair Bagnall, members of the committee. Dr. Clifford Mitchell, the Environmental Health Bureau Director at the Maryland Department of Health. So I want to answer some questions that people have been asking about this and talk a little bit about our Office of Food Protection, which strongly supports the dairy industry and strongly supports a strong and vibrant dairy industry here in the state. In 1892, when Nathan Strauss first introduced pasteurization in New York, the death rate for children dropped by 87.4% from 125 per thousand to 15.8 per thousand. That was the basis on which we decided that pasteurization was the reason to and the justification for keeping milk as a safe product. The bill, which talks about a lot of mechanisms to monitor the safety of milk, ultimately cannot guarantee that raw milk is safe. And I just want to assure you, even if you test well water and monitor the safety of the herd, you cannot be absolutely sure that the bacteria, which often come at the end of the process from gut bacteria, from handling of the product at the end as the herd is being milked, you cannot be sure that that is a safe product. The only way to be sure that it is a safe product is by pasteurization, hence the reason that we produce milk here in Maryland in order to keep our dairy products and our dairy industry safe and vibrant. The other thing I would say is that you may hear that states where there is a black market. I am sure there is a black market. I will say that the data show that outbreaks are almost universally occurred and significantly more occur in states that have legalized the sale of raw milk than in states that have not. So the data suggest that the sale of raw milk will in fact lead to an upsurge in outbreaks.
Thank you. My name is Zach Myers. I am the Director of Member Services for Mayola Local Dairies. Those of you more familiar with the dairy industry might recognize that, but that is part that owned by Mayola is owned by Maryland and Virginia Milk Producers Cooperative Association. So I work for Maryland, Virginia. Maryland, Virginia has been in Maryland and Virginia and surrounding states now for over 100 years. I'm also just recently appointed to the governor's Dairy Industry and Oversight and Advisory Council, which is made up of dairy farmers and industry folks with an interest in Maryland. Full disclosure, I'm not a Maryland resident, even though I don't sound like it. I'm in Pennsylvania. So I'm here today representing not only Mayola, our brand, but also the governor's Dairy Industry and Oversight and Advisory Council. For my testimony, this sort of sums up. This was presented by the advisory council to the governor last year in 2024. Unfortunately, I don't have the exact date to refer it to, but I would like to read it as part of my testimony. And quote, the governor and the General Assembly should continue to prohibit the sale of raw milk directly to Maryland consumers for human consumption. The council is certain that the health risks associated with raw milk consumption are based on well-documented sound science and repeats its recommendation against allowing the sale of raw milk directly to consumers for public consumption. Pathogens in milk can cause very serious, sometimes life-altering conditions and sometimes even death. The only method proven to be reliable in reducing the level of pathogens in milk and milk products is proper pasteurization. Should raw milk be allowed for sale directly to the consumer, MDH anticipates an increase in the number of milk-related outbreaks and will likely incur more cost and require additional suffering for the staffing for the routine regulation of raw milk, as well as the investigation and control of these outbreaks, end quote. And just as just one more thought, just from a co-op perspective, Maryland, Virginia actually requires its members to sign an affidavit saying that they will not sell raw milk. Again, that's to protect the brand. And one thing I didn't say in my introduction is of the roughly 300 dairy farms in Maryland, 83 of those are Maryland, Virginia, Mayola members. So even if this was to pass, that would disallow a portion of the Maryland dairy industry from participating. So, and I know that Maryland, Virginia, Mayola is not the only cooperative that is present in Maryland, and I know from other members on the council that we're not the only cooperative where that doesn't allow the sale of raw milk from its members. Thank you.
I'm going to start with Delegate Woods.
Thank you, Madam Chair. And I apologize, I forgot your name on the end.
Dr. Mitchell or Clifford Mitchell?
Dr. Mitchell, thank you so much. I have two questions for you. First one, do you dispute that the entire reason that milk was pasteurized in the first place was because of the cow's access to the alcohol and unsafe conditions?
I would say that I'm not disputing that some cows in that time were certainly drinking, but I do want to say
they were going to the bar. You mean?
Wherever they happen to be. I would recommend to you actually a lovely story. This is the biography and story of pasteurization of Nathan Strauss, who introduced it in the United States. The overwhelming evidence is that pasteurization worked because it reduced and eliminated bacteria and viruses in milk.
I understood that, but my question was, do you dispute that it was because of the cow's access to alcohol and unsafe conditions?
The conditions may have been true at that time. It doesn't change the fact that the same bacteria that were there then are there now, even without the alcohol.
Okay, and then the second question was, you made mention that there are more conditions where there are problems as a result of the raw milk than not. Could you provide us with copies of that information and what states are affected?
Yes, the CDC has done outbreak investigations that looked at where they were identified and where they originated, and we can provide that to the committee.
Thank you, Madam Chair.
All right, I saw Delegate Hill, followed by Alston, followed by Shalega.
So many questions and so little time. I'm gonna talk to Mr. Myers.
Sure.
You said you want to protect the brand. I want to be clear, when you say protect the brand, are you saying that outbreaks will lead people to think that even pasteurized milk is unsafe, or are you saying that we don't want competition? What do you mean by protect the brand?
It's not about the competition. It's from a brand standpoint, and when you're managing brands, if we would allow a member to sell raw milk and then there was an outbreak resulting from that, and it got out that they were Mayola producers, then it would negatively impact the brand, and they wouldn't go to the Giant store and buy Mayola milk. So that's when I say protecting the brand, that's what I mean. And as a co-op, if we don't sell milk, then we can't return profits back to our members. So if we have something that negatively impacts our brand and our ability to do business, then that's going to affect our ability to pay our members and keep them in business as well.
Okay, thank you. May I have one? Thank you. Dr. Mitchell, if the legislature were to ask the Department of Health to work with the Department of Agriculture and the dairy industry and come up with regulations and processes by which we could regulate raw milk for human consumption, recognizing that it may not be as safe as pasteurized, but asking you to come up with a method by which it could be as safe as possible, what would your response be?
Delegate Hill, here's my concern, and this goes to some of the earlier testimony today. Milk is sort of a special commodity in some ways, and the reason is, and we've heard this from the earlier panel, whether you're talking about oysters or cucumbers or other things, milk sort of occupies a special place in the way families manage it and who it gets fed to. Very few children or infants are fed raw oysters. But milk is something that many people, unfortunately, have fed raw milk to children and infants, and that's been where we've had problems. So one of my concerns is, even if, let's take the hypothetical case where, and I do think this is hypothetical, you tested every single lot of raw milk. It would be prohibitively expensive, but you would still miss a possible contamination somewhere along the way. And because this product is more likely to be given to children than almost any other product, I still have a lot of concern about where it ends up. So if the legislature says to us, we will always obviously do what we can, develop regulations, but in order to do that with the greatest degree of confidence, I'm concerned that you would end up with a regulatory framework that was frankly unworkable.
Okay, and if I can have a final, thank you. So Pennsylvania does this, and we're told that people are going to Pennsylvania, getting their raw milk, coming back, drinking as adults and giving it to their kids. So, are they having high rates of outbreaks and illness, and what's right and what's wrong with their system?
So one of the stories in the CDC story was actually about Pennsylvania. Pennsylvania has been the source of several multi-state outbreaks. Actually, they have exported their outbreaks to New York. We've had problems with Pennsylvania products, both with milk and with raw cheese. And so I am concerned that, I can't control what Pennsylvania does. But I will say it is the source of a continuing degree of challenge for my office and the department that we continue to see this movement across the border. But yes, in fact, Pennsylvania has been the source of a number of outbreaks.
All right, thank you. Thank you, Madam Chair, for your indulgence.
Delegate Hill. Delegate Alston.
Thank you, Madam Chair. So here's my concern. People are doing this anyway, and we know that they're doing it. You've heard testimony about a black market. You've just told us about people going to Pennsylvania to get it and bringing it here. Why can't we come up with a framework that makes it as safe as possible for Marylanders and put a warning on it? I mean, we eat raw fish, and that has all kinds of possible pathogens and bacteria in it that cannot be killed no matter what we do to it. And we warn people that this is what will happen. People eat raw eggs, and we put, I don't even know if the warnings are on the eggs anymore. I haven't looked, but people eat them knowing that it's not safe. So why can't we warn people about the safety, make it as safe as possible, and then give people the choice since they're doing it anyway?
So I think the issue is the caveat emptor is not how we do food safety, right? We don't say, here's your risk. We try to minimize that. And I think our challenge is, as Dr. Mitchell noted, is that we have a safe way to handle milk. It's pasteurization. So what's being asked is, can you devise a system that is just as safe but bypasses pasteurization? That's really hard. We can try to get as close, but we're trying to recreate a thing that we already have.
I think you're missing the point of my question. I understand what you're saying about pasteurization, but people feel strongly that they don't want pasteurized milk. Just like I didn't want to give cow's milk at all to my child. I thought my milk was better. So that's what I gave her. And so people are going to make conscious choices about what they feed themselves and their families. So it's not pasteurization versus raw milk. It's how do we keep them both safe for people who are going to drink one or the other. It's not it can be both and.
I understand that. I think that our position is that we don't think that the both and framing is the correct framing. That said, right, we could obviously, listen, if we're going to have to come up with regulations, we would have to come up with regulations. But I would simply note that we're trying in that framework, to Dr. Mitchell's point, it's going to require a lot more testing than is laid out here, right? And at some point, the sizes of the dairies that we're talking about and the sales that we're talking about, in order to get it to be safe, is not regulatorily feasible. And so you're de facto allowing a much higher level of risk to make a regulatory framework that's workable.
Thank you, Madam Chair.
Chalega.
Thank you, Madam Chair. I would say other states are doing this, so it is possible and it's being done. Dr. Mitchell, you talked about the Pennsylvania outbreaks. Were they from farms that were registered?
I believe they were. There's at least one farm which has refused to be registered, but there are others which had been registered.
I believe what you're talking about did not come from a registered farm. And, it is, I live in Baltimore County. I know people that go to Pennsylvania and buy raw milk. It lasts a long time, especially if you keep it refrigerated. So, you couldn't see a way, even though we know lettuce, cucumbers, cantaloupes, all of them are not safe, right? I mean, aren't there outbreaks of E. coli on all of those?
Delegate, that's correct. There are.
So
but you can't really, sorry, go ahead.
We let people eat them, so if other states are doing it, and we know our folks are going to other states to buy it, you can't find a way in the framework to make it a consumer choice. Again, nobody's going to be fooled. Oh, I went in the grocery store and accidentally bought a gallon of raw milk. That is not what we're talking about. And I think that's what you're hearing from our committee members. Other states are doing it. You don't think Maryland can find a way to make this happen for people that want to do it?
So, Delegate, I guess what I'm saying is that I understand that other states are doing it. Those other states are having more outbreaks than we do, first. Second, again, if the legislature decides that we're going to do this, we will come up with a framework, but the framework that's in the bill does not guarantee that the product will be safe. And if you want a guarantee that the product is going to be safe, this would be a very much more complex framework. I also think that, to your point, again, I would go back to we have seen children die as a result of this. And so I understand that caveat emptor might apply in the case of an adult, but there's a group of people here for whom they are not making a choice, which is children. And for them, it seems to me we have a higher standard or a higher burden to assure their safety. And then that goes to Deputy Secretary Kalyana Raman's point. We know how to make this a safe product, which is pasteurization.
Yes, again, I think we hear each other. And finally, I would just say, your initial talk about pasteurization and how kids were sick was 1892. I mean, that's 133 years ago. I had to use my calculator, sorry. And the world is transformed. People have landed on the moon. And, it's not a fair comparison. I get what you were saying. We didn't have refrigeration. It almost sounds like, if we go back to letting people drink raw milk, we'll have what we had then. And we have testing measures. We have, measures for sanitation. We have so much in place 133 years later.
Delegate, I couldn't agree with you more. I wasn't there at the time, despite appearances. However, what I would say is that the bacteria haven't changed that much, and their ability to survive in raw milk has not changed.
But our ability to check for it has.
So we would be somewhat better off, but I think we would still not be where we are with pasteurization.
Yeah, thank you. I think we have an impasse here.
Kipke.
I'm not going to ask any more questions, but at this hour, why not? So, Dr. Kaye, you keep saying that there's a safe alternative. So why would we want to open up something that's less safe? And I'll tell you, I've been to bull and oyster roasts, and kids eat raw oysters. My daughter, who was 5, who's healthy, I wouldn't have let her if she wasn't healthy, by the way. But she took a fork and knife and eat it piece by piece, which I can't even imagine. I'd have to swallow it and look the other way. But there are pasteurized oysters in grocery stores, and there are raw oysters in grocery stores. So, and as far as I can tell, the risks of a raw oyster with Vibrio bacteria, for example, it poses a much greater threat to one's health than diarrhea from raw milk. So how would you respond to that?
Well, I think, Delegate Kipke, that to Dr. Mitchell's point, right, milk is a far more prevalent food item. It's far more prevalent in children, right? It's a part of our culture. And so I think it does have a different place in how we treat it and how we actually, look at safety and look at how it's being consumed. So I hear you about the oysters, right? We talked about sushi and this, right? But there are certain food items that are consumed differently, and I think we need to look at those differently.
So just a quick follow-up to that. In states who have some regulatory scheme for raw milk, or states who have just allowed raw milk to continue, the states who have allowed it in recent years, has there been a significant statistical increase of consumption or a significant statistical increase of illness?
So I'm going to defer to Dr. Mitchell on this one.
Delegate, if you're talking about states that have recently done it, we don't have those statistics yet. It takes a while for them to percolate through. The studies that I mentioned are older, but still look at a comparison between states that at that time had allowed legal sales versus those that did not. And they did show an increase.
An increase, but is it statistically significant?
Yes, it was.
Okay.
And again, we will supply that to the committee as requested.
Thank you.
Mm-hmm.
Delegate Rosenberg, followed by Delegate Woods.
Cliff, since I know you and you're a resident, or were a resident of the district, what product that's out there or what a product says something that's, what vegetable or anything that is out there is a comparable risk in your professional view to raw milk that is not now legal?
Delegate Rosenberg, first of all, thank you. I'm delighted to see that your leadership continues here in the House.
Thank you. Go ahead.
That said, I'm not going to answer your question because I'm sorry, I couldn't resist. It's late. Please forgive me. No, I think that it takes a little bit of math to figure that out. The number of cases of outbreaks, it would actually take some work to figure out exactly what that is, because the way the FDA and we tend to look at that is by quantity of thing consumed. And so I guess the simplest answer to say is, if you look at raw vegetables probably have a comparable risk not to raw milk, because all of those products are basically grown under what are called good manufacturing practices. The Department of Agriculture works for them, and they work under both good agricultural and good manufacturing and good agricultural practices, I should say. And they do a superb job of actually minimizing that risk. So the only way that you get a comparable risk with vegetables or fruits is if they're mishandled. That is to say, if they're not grown with good agricultural practices, if there's a risk of contamination, fruits and vegetables, cantaloupes, et cetera, actually have a much lower risk than raw milk because of the way they are handled in the farm.
Even when mishandled?
Even when mishandled. I mean, the cases where we've had, for example, ciders that have caused E. coli outbreaks is because the apples were actually collected and were dropped apples. That is, they say they were on the ground and put into the cider. So in that sense, they could have come into contact with feces or other material. But the problem with raw milk is, by its nature, it is coming from the gut of an animal, and so it is closely in contact with skin. So the risk of contamination is far, far greater than for fruits and vegetables.
Thank you.
Thank you. And I'm going to take a point of personal privilege and follow on to that, because I think we're getting caught up on this fruits and vegetables comparisons. Am I correct that we still make recommendations to wash your fruits and vegetables, that we still have standards, that we still have testing, and we do still have outbreaks?
That is correct, Madam Chair. And I would note, the reason we do that is because if you cook a cucumber, it's really pretty inedible, even if you heat it up. But the good news about pasteurization is we can heat the milk and it still retains all of its nutritional value and content.
Thank you very much. All right. With that, Delegate Woods.
All right, Madam Chair, thank you for this opportunity. I don't do this often. I believe this is my first time. So, Dr. Mitchell, if you would... Yes, Dr. Mitchell, if you would kindly help me so that I am not deceived by Dr. Google. I am reading from Dr. Google that the percentage difference between children who die from raw milk is not at all significant from the percentage of children who die from pasteurized milk. When you provide that report, can you please do the comparison?
Delegate, I'd be happy to, and it would help me if I knew what the source was that said that.
Okay, I'm happy. Can we meet after? Because I actually went to several sites.
Yep, thank you
so much. Thank you, Madam Chair.
You're welcome. Looking for any other lights? All right, I do have a question. I'm actually going to ask the same questions that Delegate Woods asked of the sponsor panel, which is, why do we pasteurize? Why do we refrigerate? And also, what is the timing of farm to refrigerator? Because I think, to the sponsor's point, this is pasteurization has a long history, but also the way that we consumed our food was quite different too. The supply chain was quite different. So if you could answer those questions for me, why do we pasteurize? Why do we refrigerate? And what is that timing look like now versus when we first recommended pasteurization?
I think the answer to the pasteurization question is because there's unequivocal scientific evidence that it reduces and eliminates the risk of bacterial contamination and viral contamination in milk from organisms including Brucella, tuberculosis, bacteria, and viruses. The question of the timing, I'm going to defer to my co-op neighbor, but I think we generally allow residents in held tanks, I believe, of only 3 days. Is that correct?
That's correct.
Yeah, and once you basically milk the cow, it has to be at your co-op.
It can be 72 hours at the farm, and then it can be held 72 hours before it has to be processed, but generally it doesn't. Once it gets to processing, it doesn't last 72 hours, as long as there's not some kind of snowstorm or something like that that prevents it from being processed. So that's the time. And as far as I know, one of the ladies that testified for it said that raw milk lasts anywhere from 2 to 4 weeks, or up to 4 weeks, maybe. I don't remember exact wording, but we know from the processing side that in order to be able to put a date code on the milk, that there's quality control measures and tests that have to be taken. So depending on how it's pasteurized, like for HTST or high temperature short time pasteurized milk, it's 18 to 21 days. It's going to, as long as once it's packaged and is handled correctly, once it leaves the packaging line, goes to the grocery store, and the consumer buys it and keeps it in the refrigerator, it's going to last 21 days unopened. And if it's extended shelf life, it's going to last 70 to 90 days unopened. We know this because we have to test it. And then aseptic milk can last up to a year unopened, and it does not have to be refrigerated either. So we know this from the standardizations from the pasteurized milk ordinance that the FDA has oversight of. That is basically how processors and dairy farmers have to operate to be able to produce quality milk. It's all in the PMO, and so because of the testing that goes through, we know what those time periods are for that based on how it's processed, how long it's going to last, as long as it's properly taken care of at the right temperature and doesn't warm up.
Thank you very much for that answer. Delegate Hill, another bite at the orchard apple?
Second bite of the day.
Yeah.
Thank you. Dr. Mitchell, we should clarify. We heard testimony that if I'm purchasing raw milk for my pet, I can ask, but the seller producer can't answer any questions about how it's processed and how I know that it's clean. Is that true? And if so, what would be the rationale behind not allowing people to talk about how my pet's milk was processed?
Delegate, there are about, I believe, 30 or so farms that sell raw milk pet food licensed by the Department of Agriculture. I would prefer not to speak on behalf of the Department of Agriculture regarding their rules. I think that's probably better a question to ask them.
Thank you.
And we'll have that opportunity.
Thank you.
They're on another panel. Thank you, Delegate Hill. One last question, because again, it was raised in the original panel, so I just want you to have an opportunity to answer. And that, there was a talk about what is lost with pasteurization. So what is lost by pasteurization and what is gained?
So from all the data that I'm familiar with, there is essentially no difference between pasteurized milk with respect to nutritional value or value as a food item. And so from my point of view, what is lost is an opportunity for bacterial growth, which thus renders it a safe product.
Thank you very much. Looking for any more lights? Delegate Kipke, you're not hidden behind your computer, right? Okay. Okay, thank you very much. Thank you to this panel. We have one more favorable with amendment and then an information panel virtually. So I have Asia Rodriguez and Anna Kate Cagle.
Asia's not here.
Asia's not here, okay. So Anna Kate Cagle. You can begin whenever you're ready.
Good evening, Madam Chair and members of the committee. My name is Anna Kate Cagle. I'm a student attorney with the University of Maryland with the University of Maryland Public Health Law Clinic, and I am testifying in support of House Bill 1449 with amendments. Although Maryland currently prohibits the sale of raw milk for human consumption, demand for this product continues to grow. To meet this growing demand, we are seeing more and more consumers turn to unregulated sources to purchase raw milk, such as traveling to a nearby state with more lenient laws, purchasing it online, or from a local farm selling it as pet milk. This is problematic because consuming black market raw milk further increases the already high risk of foodborne illness associated with consuming unpasteurized dairy. House Bill 1449 takes a harm reduction approach to this issue by legalizing raw milk, which is a product that people are already consuming, and making it safer by implementing restrictions that have been proven to decrease the risk of foodborne illness. While this bill is an important step in improving consumer safety, we urge two key amendments to further reduce these risks. First, we recommend clarifying that the sale of raw milk is prohibited in retail stores. States that allow retail sale of raw milk experience 3.6 times more foodborne illness outbreaks than states that limit sales to farm only. Keeping raw milk out of retail stores will help mitigate these risks while also limiting the public's exposure to these products and also supporting Maryland's small and mid-sized dairy farmers. Second, we recommend delaying the bill's effective date by 1 year until October 1st, 2026, due to the ongoing avian flu outbreak in dairy cattle. Because avian flu can be transmitted through raw milk, consuming these products poses a heightened threat at this time. So delaying implementation will allow public health officials to monitor and contain this outbreak before raw milk is more widely available across the state. With these changes, the bill will better protect Maryland consumers while also supporting local farmers. We request a favorable with amendments report on House Bill 1449. Thank you.
Great timing. All right, I'm just looking for any questions from our committee. Seeing none, thank you very much for your testimony. We have one more witness on this bill. We have Rachel Jones from the Maryland Department of Agriculture. She is virtual, and it is an information testimony. What's that? Oh, you sure do. So let's go to, you know what, she's unfavorable, so let's go to information, and then we'll go to the unfavorable. Thank you for keeping me honest. Ms. Jones, welcome. If you can go ahead and start with your testimony.
Sure. Good evening, Madam Chair, members of the committee. So Rachel Jones, Maryland Department of Agriculture. Our testimony is primarily informational. As you know, we briefed this committee as well as the House Environment and Transportation Committee a couple of weeks ago on HPAI, also known as H5N1 or avian influenza. And so our testimony for today is primarily centered around the fact that given the fact that it's MDA's primary role right now to contain HPAI, we're following guidance as we shared in those briefings with both committees about questions that were asked about the safety of chicken and eggs and milk. And at the time we shared, and so we're just being consistent with that position, which is that we adhere to USDA and FDA regulations on the federal government side, which basically have specified that there's no concern about the safety of commercial milk products that have been pasteurized for human consumption. However, there is a concern, as MDH has already noted, that HPAI could be spread more prevalently in raw milk. And so MDA is being consistent with what we shared in our previous briefing with you all, which is just that with HPAI cases, thankfully, since we've testified before you all, there's only been one additional outbreak in the state of Maryland, but to date we've had 5 on the Eastern Shore and 1 in Montgomery County. And our goal is, as the migratory season for wild birds begins to come to an end, our goal is to keep that contained. And so our testimony today is simply to remind the committee of what we've shared and that our goal at MDA is to currently contain the spread of HPAI. And I understand there's some questions that I'll happily take.
I'm going to start with Delegate Hill.
Thank you. It's good to see you again. You were listening to some, if not all of the hearing. There was testimony about people being prohibited to answer questions about the line of production of raw milk when it's, they can't sell it to humans, but they're not allowed to even discuss the process if it's being sold or purported to being sold and bought by someone for pet use. Can you address why that might be, or if that's true, or if that's a misinterpretation?
Sure. I believe I understand why it happens. I know that in our regulations that MDA has surrounding pet food, and which obviously would pertain to raw milk, there are specifications in there about what has to be in the label. And particularly as it pertains to raw milk, there's a requirement in our regulations that raw milk distributed for pet food or specialty pet food has to have a label on it that says, warning, not for human consumption. This product has not been pasteurized, may contain harmful bacteria, and may cause foodborne illness. And so I can understand those who do currently sell milk, sell raw milk, probably thinking that in order to adhere to the law, they mustn't mention that, it's processed in such a manner that makes it safe for them and their family to drink if they are saying they consume it on a daily basis. I think it's probably extra caution. I would assume it's extra caution on behalf of the sellers to not want it to be perceived that they are promoting or saying that this is safe for human consumption, because they know by Maryland law it's not legal, and so they probably don't want to be perceived as saying that. But there's nothing in our regulations that bars farmers who sell raw milk from speaking about it, but I can understand why there might be a hesitancy to do so in an effort to ensure they're complying with the law. That's all I can think of.
Okay, so to clarify, nothing that says you can't tell me how often your machines are cleaned, you can't tell me how often the vats that they're held in, there's nothing that says you can't talk about the way you process the raw milk?
Not in Department of Agriculture regulations, no.
Thank you. Thank you. Thank you, Madam Chair.
Thank you. Do I have any other questions for this witness? Seeing none, thank you very much for being here. Thank you for your testimony and for being here to answer questions. We do have one more witness, one more virtual witness. Megan Davis is unfavorable. Ms. Davis, you can go ahead and get started whenever you're ready. Ms. Davis, can you hear us?
Yes, hi, can you hear me?
Yes, you can go ahead and get started.
Great, thank you. I'm Dr. Megan Davis. I'm an associate professor at Johns Hopkins Bloomberg School of Public Health. I'm here on my own behalf and not that of my institution. I'm a food safety and infectious disease expert, and most importantly, I'm a veterinarian. And I started my career in dairy practice. I value dairy farmers a great deal and their service. I drink local milk, but I drink it pasteurized. And that's because pasteurization makes food safer for all the reasons that we have discussed. So I oppose HB 1449, in part on the well-established risks that raw milk can pose for consumers. What wasn't mentioned was that this can also add to costs for the state in terms of outbreak response, and also cost to consumers, not just for the burden of disease, but also for healthcare services. But there are additional public health and health security reasons to reconsider this bill at this particular time related to avian influenza. H5N1 was introduced into dairy cows as a big surprise last year. We are still learning about this virus. It has been very, very promiscuous. It's gotten into a lot of different kinds of animals. It has affected over 100 cats in the United States. So I do also oppose raw milk sales, although I recognize they are legal in the state of Maryland. It has sickened 41 dairy workers. And what's most concerning, which is brand new, something we just recognized through some of the same national milk testing strategies that we are using in the state of Maryland, is that there has been an additional variant that has gotten into dairy cows, the D11. This is the variant that killed the person in Louisiana and hospitalized a poultry worker. So the disease in humans associated with this particular variant could be more severe, and we don't yet know enough about it. The other concern is that a lot of our strategies that we've put in place since last spring really have focused on the original B313 that we think was spread through cow-to-cow transmission and cow movement. We know less about this particular one, and it could come in unexpected times and ways. Thank you very much for your consideration. I'm happy to take questions.
Thank you very much for your testimony. I see Delegate Hill.
Thank you, Doctor. Could you just finish drawing the line? We've been told that that the H1N1 is not an issue in Maryland related to raw milk. We don't sell raw milk except to pets. You're suggesting that this is still a concern. Why would, if we change this and started allowing the sale of raw milk outside of the black market, why do you think that would increase risk?
The risk, there are two different risks here. The first risk is that it could be introduced to a Maryland farm. What we recognize from the most recent cases in Nevada and Arizona is that we identified it in the milk ahead of the appearance of disease, and that's appearance of disease in the cows and appearance of disease in the workers. And genetic testing suggests that it was circulating for weeks ahead of that. These are all opportunities for it to get into consumers, and raw milk is the way it could get into consumers, because what we're testing with the National Milk Testing Strategy of the USDA and the state partners who help to implement it is the bulk milk at dairy processing plants going into a pasteurized food chain. So these farms would not be included in that surveillance program. And we currently do not have any point of use tests for farmers to conduct in order to test for H5. And there's no mention in this bill of testing for viruses, including H5N1. So we could be flying blind and not know that it gets into a consumer chain through the raw milk direct to consumer sales.
All right, thank you. Thank you, Madam Chair.
All right, I don't see any more questions. Thank you very much for your testimony.
Thank you.
This concludes the bill hearing on, I just put it to the side. This concludes the bill hearing on House Bill 1449 and actually concludes our hearings for today. Yes, yes. Thank you very much. If we can go ahead and go down.